Good morning, everyone. I would like to call to order this public hearing of the Committee on the Judiciary and Public Safety. It is now 10:08 a.m. on January 24th, 2023, and we are conducting this hearing in person and streaming on the DC Council's website at YouTube at CM Brooke Pinto. I'm Councilmember Brooke Pinto, representing Ward 2 and the chairwoman of this committee. The Committee on the Judiciary and Public Safety has oversight responsibility for matters affecting the district courts, criminal law, procedure and justice, public safety, including policing, violence prevention and intervention, and civilian police oversight, access to justice, including victim services and justice grants, fire and emergency medical services, and the district's 911 and 311 services, forensic science, fatality review, and medical examinations, Homeland Security and Emergency Response, Adult and Youth Corrections, Family Law, Probate and Estates, Child Support, and Women's and Gender Policy. Today, the committee is meeting to conduct a performance oversight hearing for the following agencies. First, the DC Sentencing Commission, and second, the Office of Victim Services and Justice Grants. We'll start today with the DC Sentencing Commission. The commission was created in 2006 for the purpose of producing voluntary sentencing guidelines for judges in the district in order to ensure greater consistency and fairness in sentencing. While voluntary, judges follow the sentencing guidelines 98% of the time. The Sentencing Commission is also broadly responsible for analyzing sentencing data, policies, and practices, both in the district and across jurisdictions. This includes tracking case-by-case sentencing and compliance with the sentencing guidelines. Finally, the Commission produces recommendations to the courts, the council, and executive agencies on enhancing the fairness and effectiveness of criminal sentencing in the district. The Commission is currently composed of 12 voting members and 5 non-voting members. Although my Secure DC Omnibus Bill, Bill 25-345, currently under consideration by the Council, would slightly increase district representation on the Commission by adding 3 voting members, 1 additional representative from the mayor, 1 additional representative from the Council, and the Chief of Police. We are joined today by no Council colleagues I can see yet. We have no public witnesses signed up today to testify regarding the Sentencing Commission. And so I will call our government witnesses, the Honorable Milton Lee, Chairman of the DC Sentencing Commission, and Lyndon Fry, the Director of the DC Sentencing Commission. Hello, sir, would you state your name for the record? Okay, great. And we have Judge Lee joining us online. So it is the tradition of this committee to swear in all government witnesses who appear before it. So Judge Lee, if I can ask you take your camera off and turn yourself off mute. Go ahead. Okay, got it. We will swear him in when he joins then. So if I can ask you both to raise your right hand. Do you swear or affirm under penalty of law that the testimony you are about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth? Thank you both. Let me take a seat. I will now invite Director Fry to make any opening statement that you may have. And it's my understanding that you'll be the only one making an opening statement from the government witnesses. Okay, great. Please go ahead.
There we go. This is my first time testifying in person. So, all right. So, excuse me. Thank you, Chairwoman Pinto. I appreciate the opportunity to testify before you and the committee today. I'm also, as I said, accompanied by the Commission's esteemed chairman, Judge Milton Lee, who is an associate judge of the DC Superior Court. Today, I'd like to speak with you about some of the 2023 sentencing trends that the Commission has observed, some of the agency's recent accomplishments, and a challenge that's currently facing the agency. As you mentioned in your introduction, the Commission is currently made up of 17 members, 12 voting members, and 5 non-voting members. There is legislation proposed that would increase the membership of the Sentencing Commission, and the Commission itself is not taking a position on that legislation. However, the Commission's goal is that it remain an apolitical, data-driven body, and that the members bring diverse views to the Commission and its deliberations. The Commission's longstanding policy, which has continued under Judge Lee's leadership, is to ensure that every member of the Commission, both voting and non-voting, has an opportunity to participate in drafting of guidelines and policy changes, and is given the full ability to express their views on any issue that comes before the Commission prior to the Commission taking any vote. And additionally, whenever possible, the Commission tries to act with a full consensus of its membership, and that's something that we actually have been able to accomplish a lot. Almost every substantive decision made by the Commission does come through with unanimous support of our members, and that's because we do an excellent job sitting down, listening to the concerns of our membership, and really trying to craft policy that everyone is comfortable with. Obviously, that does not happen all the time. There are differences of opinions, but whenever possible, that's the approach that we take. Recently, there's been a lot of discussion about short split sentences. We met yesterday. We talked about that a little bit. A short split sentence is a compliant short split sentence is a sentence where the court imposes a total sentence within a defendant's recommended sentencing guideline range and then suspends all but 6 months or less of that sentence. On the guidelines master grid, short split sentences are only available in 10 of the grid boxes. So that's 22% of the boxes on the master grid, which, as you know, serves as the backbone of how the sentencing guidelines work. However, just because a short split or probation sentence may be available in that box does not mean a judge has to impose that type of sentence. A prison sentence is available in every single box. So for every single felony sentence in the District of Columbia, a judge can impose a straight prison sentence. In fact, last year, even in boxes where probation or short split eligible sentences were available, a majority of the defendants, 54%, were actually sentenced to prison or long split sentences. So the amount of time they initially served was at least the minimum of the guidelines in the box sentencing range. Talking a little bit more about data from 2023, we've seen the court begin to return to normal operations after the COVID emergency. The trends in both the number of cases, counts, and defendants sentenced is picking up where it resumed prior to COVID, which we are seeing a gradual reduction in the number of sentences, and going back there, the number of cases going through Superior Court. Another statistic that really shows the court returning to normal operations is the amount of sentences that result following a plea versus a trial. During COVID, when it was virtually impossible for the court to conduct jury trials, as high as 98.8% of all cases were resolved through a plea agreement. Last year, at the case level, that was down to 92%, which is exactly in the range where we've seen it historically as far as plea versus trials. And that is almost solely accountable just for the court being able to resume its operation and actually bring in jurors and conduct jury trials at the same level that they had before. Looking at all sentence counts last year, 68.5% of all felony sentences resulted in a prison sentence. Only 16.2% resulted in a short split sentence, and 15.3% resulted in a probation sentence. So the majority of sentences were for prison sentences, and that includes long split sentences as well. We briefly touched upon this yesterday when we met as well, but we continue to see a decline in the number of drug cases being sentenced. Last year, only 4.7% of felony sentences were in drug cases. That's the lowest rate we've ever observed. It was around 7% in 2022. If I was here before you last year, I would have said the same thing. Last year, that was the lowest rate we observed, and it went even lower than that. Homicide sentencings are right where they would have been before the pandemic as well. In 2019, there were 84 homicide counts sentenced. Last year, there were also 84 homicide counts sentenced. And so I know that the homicide rates and arrest rates have picked up in DC, but it also is important to remember that homicides, above all other cases, take the longest time to transition through the court system. And so those numbers add up slowly. So even though the court has returned to normal, we're not going to see the results of additional trials for several years, because it's not uncommon to have a 2 or more plus year delay in the time it takes from a homicide case that comes in, if there's ultimately a conviction for that defendant to be sentenced on that offense. Also, as you mentioned, we continue to see exceptional compliance with the DC sentencing guidelines in Superior Court. 98.6% of all felony sentences last year complied with the sentencing guidelines. Perhaps even more importantly, 94.3% of all felony sentences fell within the in-the-box recommended sentencing range and options. So what that means is there are certain category of cases where the judges can still follow the guidelines, but impose an outside the box sentence. But even a vast majority of those were not just following the guidelines, but actually fell within that recommended in the box sentencing range and sentencing options. The biggest reason for non-compliant sentences or sentences that comply with the guidelines but fell outside of the guideline range were Rule 11C1C pleas, where the government and the defense enter into an agreement for a specific sentence or a limited sentencing range. And if the court accepts that sentence, they're then bound to it. By rule, the guidelines consider all those 11C1C plea sentences as compliant for 2 reasons. One, they're often entered into before the defendant's criminal history score is known. So they can't be judged beforehand whether or not it's going to fall inside or outside of the box. And 2, the judge is not the one imposing the sentence. They're obligated to follow that plea, unless it's a range, in which case the judge can choose where in that range the sentence falls. Of the very limited number of sentences that were not compliant with the guidelines, which was only 1.4% of counts sentenced, which is a very low number. 17 of those were below the guidelines. So the judge didn't follow and went below, and only 4 went above. However, the sentences that went above the guidelines deviated much more from the in the box guideline range than the sentence below. The sentence that went below, for a majority of them, only went just a little bit below the sentencing guidelines. For the few sentences that went above, they went above by a substantially larger number. I think 2 other important things to note, and this is a credit to our partner. Last year, we received every single criminal history score from CSOSA that they did a guidelines calculation for. In years past, it's really been a back and forth between DC and CSOSA to make sure, or between the Sentencing Commission and CSOSA to make sure that we had all of those numbers. And so through working with them and keeping up both more training and communication, we've gotten it so every single defendant who got a score, that score ended up being reported to the commission. Another statistic that shows our great partnership with Superior Court judges is anytime the commission believes a sentence does not comply with the guidelines, we reach out to the judge and ask them, can you verify that the data we have is correct? Because oftentimes the judge did impose a compliant sentence. It's just for some reason the reported data didn't reflect that. So we give them a chance to correct that. If the data is correct, we then ask, why did you not follow the guidelines? Because that gives us great feedback on if the guidelines are missing anything, if there's anything else we consider. For the first time ever last year, we received 100% feedback rate on letters sent to the judiciary. And so we're very pleased with that. And again, that's a credit both to our judges and the work that commission staff has done setting up a process to make sure we're getting that information in a timely manner. In 2022, The commission answered 11 data requests. In 2023, that number stayed the same at 11. However, those requests got much more complex and detailed. So it took 370 hours to answer data requests in 2022. It took almost 800 hours to answer those requests in 2023. And even through the first quarter and a little bit as of today in fiscal year 2024, we've already received and responded to 10 data requests and spent more time working on those requests than we did in all of fiscal year 2022. So I think it's great that we're getting it out there, that we are this resource. We can provide data to the council, to the mayor's office, to our partners, to researchers, and even to individuals who might be interested in it. But it comes at a cost to the commission, as it takes a lot of time and resources to put that data together. But we are very happy with what we produce. Going along with that, one of our accomplishments over the past year has been, it used to be when we got a data request, we responded to the party making the request. Now, if we think that data request is relevant and might be interested to members of the public, we actually publish those data requests on our website, and we've gotten great feedback from that. We've also started using MPD data. Several years ago, we went forth on a project that expanded our data system to be able to bring in MPD arrest data. And for the first time ever, we've started doing geographic analysis based on that MPD arrest data. We produced a paper that looked at case papering rates by ward and found that for the most part, case papering rates are consistent from ward to ward. Between 49 and 64% of felony arrests in each ward were sent to the court for prosecution, with the exception of Ward 6, which had a slightly greater papering rate of 67%. Ward 8 had the lowest papering rate of 59%. And moving forward, the commission plans to do more geographic analysis because I think it can reveal very interesting statistical trends. We've also been monitoring and working with the new legislation being worked on by the council. As you are intimately aware, the council has put out a lot of new proposed criminal justice legislation. We break those down to analyze if any new legislation either changes or modified offenses, or does anything else that would require the sentencing guidelines to be modified. And so this commission's continuing to work on that. We've even started working on proposed legislation just so we can decrease the amount of time it takes. So commission staff looks at proposed legislation. Once the legislation is finalized, we then bring that to the commission to propose any changes before the commission votes on it. We continue to expand the commission's outreach and training activities as well. For our core partners, those who use the guidelines on a daily basis, we actually have individual quarterly trainings or training materials that we send out to them. That again has helped us keep up communication with our partners, and I think is the reason some of our interagency relations have gotten better over time. And then we are out in the community as well, both educating individuals on what the sentencing guidelines do, how the commission works, and just sentencing general in DC, but also to hear from community members about how they think the criminal justice system, specifically regarding sentencing, is working. If they think sentences are too lenient, if they think sentences are too harsh, it's all anecdotal information, but you can learn a lot by talking to people who are actually dealing with those situations as part of their lives. It could be victims, families of victims, defendants, families of defendants, just talking about what you see. And the results aren't always what you would expect. But that's really helped the commission as we start looking at evaluating what priorities we should start addressing on the commission. So the last thing in my opening remarks I want to touch on is just a challenge facing the commission, and you've actually heard me talk about this before. The court is in the process of transitioning to a new case management system. This is a major lift for the court, and I commend them. It's any system like this, as I'm sure you know, it's very hard to launch a new system, especially when there can be no overlap, because data has to come from one place. At some point, they're just going to have to flip a switch from the new system to the old system. There are lots of challenges involved with this. Because of that, that implementation has been delayed several times. We still don't know when it's going to go live. Also, the requirements of that system have been continually updated as the court keeps trying to get it to work. The court's been a very good partner working with CJCC and other criminal justice agencies to make sure their systems can continue to work after it goes live. But this presents challenges for the Sentencing Commission because we're a little unique in this area. First, because we look at historic data. So we need to be able, when the new court system goes live, to analyze both data from the old system together with data from the new system, which is highly problematic and just difficult to overcome. The other is we don't just focus on one area of criminal justice data coming from the court. We look at a holistic, from arrest to case papering all the way through case resolution and sentencing. So we're consuming data from all points in that criminal justice process. Because of this, our system is going to have to be adapted more than most other partner systems. And until we complete testing and know exactly what that entails, we don't know how many changes there will be. So while I think we've done a good job and the council has been very kind in helping us do this, is staying on top of this and doing everything we can to make sure our data system's ready. There are still a lot of variables out there, and I think it will be challenged. And it's highly likely that we come back to the council and say what we have in place right now just isn't enough. But again, I have to commend the court and CJCC for working with us to do everything possible to minimize the amount of changes that we have. So once again, I appreciate the opportunity to be here today and the time you've given to speak with and learn more about the sentencing guidelines. And I'm happy to answer any questions you may have. And I apologize. I don't think we have Judge Lee yet.
Okay, well, thank you so much, Director, for that testimony and for all of the work that you and your entire team does throughout the year. It is extremely important work. And as you highlighted, the amount of hours intensity of responding to data requests, I think is also an indication of the level of interest in your work that people have and getting into the nitty gritty. So thank you for all of that effort. I wanted to ask you kind of to start very specifically on something that you mentioned about a lag in time with homicides. Mm-hmm. And you said, it's not uncommon for by the time it gets to a homicide case may get to sentencing or trial, maybe 2 years. Can you just elaborate a little bit on what some of those causes for delays are in our homicide cases?
I don't even know if that you would call it a delay. It's just the normal timeline. There's a lot more evidence gathering statutorily. There's less time requirements of when the case can be forward. So most of that, I think, is due to investigation, both by the prosecution and MPD, as well as by defense attorneys. And because these are usually larger, more complex matters, they take time to schedule as well. But the short answer really is that not in every case, but in most of these cases on the criminal side, they're the most complex cases that are occurring in Superior Court. And so both preparing for and actually having the trial just takes more time.
Okay, thank you for that. I think there's a lot of questions from the public sometimes about the process by which these cases go through the system. And is it a fair summation of what you talked about with court operations, that court operations are back to where they were before COVID?
I can't speak to all court operations, but what I can speak to the data that we're seeing as far as the numbers coming through and how things are processing is yes, it looks very similar to the trends that we saw in 2019 and before. So from the sentencing and the results end, yes, it does appear that they are at or almost back to normal.
Okay, great. So I'm interested in this mission that you talked about of community listening, and going into the community and hearing what people think about sentences. Of course, anecdotally, but what are some of the trends that you're hearing from the community in those listening sessions as it relates to the Sentencing Commission's work?
Well, I think there's three parts that we hear. The biggest thing we hear, and it's often posed in the form of a question, is, you know, such and such person was arrested for armed robbery or armed carjacking, but they ended up getting a sentence that was not nearly as severe as what you would expect for that offense. Doesn't that show that there's a problem with the sentencing guidelines? We get that question a great amount. And the answer really is it's part of the process. So what someone is arrested for is not ultimately what they're convicted of. And the sentencing guidelines themselves is conviction driven. So when we are scoring and providing the in the box range, that's based on what offense that defendant was convicted of. When we're calculating a defendant's prior criminal history score, which can also increase their recommended sentencing, that's based on prior convictions. That doesn't mean judges can't consider other behavior. We have fairly wide sentencing ranges in DC, and they absolutely can factor that in. But as far as the guidelines themselves, it's based on conviction. So if, for example, someone is arrested for armed robbery, but prosecutors only bring a robbery charge and that person ends up pleading to attempted robbery, the guideline range recommended for that defendant is going to be on what they're convicted of or what they went to trial and were found guilty of beyond a reasonable doubt. And so that often results in this perception that some of these sentences are too low, but it's not actually because of the offense they're being sentenced on. It's because there's a difference between what they were arrested for and what they're ultimately sentenced of. So we hear that. We also hear that we wish there were more rehabilitation programs in DC, that people who are released on probation or released from prison were given more support and opportunities. And on the flip side, we hear people who are saying, no, it's too late. There are too many people who are arrested who don't receive severe enough punishments. And it's interesting that on both sides of those, for both the, we need more support for community supervision and things like that, that comes from both victims and prior defendants as well. And for the same reason, people who are saying it should be more harsh and there aren't enough penalties, we also hear that from victims and their families, but we hear that from the defendants and people involved with them at the same time. So it's really, you can't really pigeonhole people on what their opinions are going to be based on their prior experiences. But one of the advantages that we have had since the commission started its outreach activities several years ago is really being able to hear this, because then we can bring in those views and let our commission members know what people are talking about. And usually that's already known. We have a fairly diverse membership as it is. I think if the commission is expanded, that will probably continue as well. But we like to hear all ideas and bring those to the table.
Okay, thank you for that. That's really helpful. So let's talk about some of the specific guidelines themselves. So in 2018, the commission reduced unlawful possession of a firearm with a prior felony conviction from Master Group 7, which is 12 to 36 month range, to Master Group 8, which is a 6 to 24 month range. And in 2019, the commission reduced unlawful possession of a firearm with a prior crime of violence from Master Group 6 to Master Group 7. So both of those moves have a lower sentencing range. I'd like to talk a little bit about the Sentencing Commission's rationale for those moves and what type of considerations are made when making those kind of shifts. And can you, as you're thinking about that or speaking about that, can you talk about what some of the implications are for the re-rankings?
Yes. And so if you don't mind, and I appreciate our attorney advisor, Ms. Buckley's holding our grid up here just so I can use that as an example.
Sure.
So the reason the discussion started about re-ranking those offenses is that we were routinely seeing that the most common offense that was being sentenced outside the in the box sentencing range was felon in possession convictions. And so that's what put it on the commission's radar to start analyzing this. When we looked in it further, what we found is, unlike just about every other offense on the master grid, individuals who are being sentenced under felon in possession, either as a prior felony or a prior crime of violence, were having their prior conviction double counted against them. So what I mean by that is the sentencing master grid has 9 offense severity groups. The lower the number, the more severe offense. Carrying a pistol without a license is ranked in master group 8. Prior to the change, felon in possession, prior felony was ranked in master group 7. But most of those times, based on the facts of the case, the only difference between those 2 offenses was the fact that the defendant had a prior felony conviction. But what that also meant was, in addition to that prior felony conviction, moving a defendant who would have been in group 8 into group 7, it also moved them to the right on the sentencing guidelines grid. And so that prior conviction was being counted against them twice. So it was moving them up where you get higher sentences, and it was also moving them to the right where you get higher sentences. And that's one of the reasons we were seeing judges not imposing as many in the box sentences for those offenses. And so it was for that reason that the commission re-ranked the offense down into master group 8. Now, the mandatory minimum for those offenses still apply. The mandatory minimums always trump the guidelines. So when applicable, judges still have to impose that. Additionally, the defendants are still receiving more severe sentencing guidelines recommendations on the basis of that prior felony. So they're still having that shift to the right based on their criminal history score because of the prior felony.
Thank you. Thank you for that analysis. And I think it goes to one of the missions of consistency and making sure that the guidelines in each box is consistent. What we're also seeing in community right now is a proliferation of illegal firearms and higher levels of recidivism for people who've previously been charged with gun offenses. And so how does the commission weigh that balance of responding to what we're seeing, especially with repeat offenses as it relates to a gun, and making sure that that is addressed without undermining the ability to take into account if the defendant has a prior felony conviction?
So the first thing we do, and this is the starting point for all offenses, is we look at what the maximum and any mandatory minimum punishment for that offense is. And the reason that we start there is because that's really taken as guidance from the council on how serious they feel that offense is. And so the commission looks at that, but it also, even during these changes and afterwards, is evaluating for each offense whether or not that is effective or not. So we do look at criminal justice trends. I will say, again, my rookie in-person appearance is coming through. We do continually look at that, and it's something I think we will continue to address going forward. But we're looking at gun offenses, and everyone on the commission is uniquely aware of the problems with gun offenses in this city right now. That's not lost on us at all. And also what can be done to respond to that. So I think it may not be as specific an answer as you may want, but it's something that we do consistently review and consider. I'll mention this very briefly. We do have a little bit of a data deficiency when it comes to looking at prior offenses, simply because CSOSA provides us with a defendant's total criminal history score, but we don't have access to the full criminal history score breakdown. So we can't do as much research as to defendants being sentenced for an offense now, what their prior offense was, and what that could lead to in terms of increased sentence length, sentencing options, and whether adjustments can be made. That does not mean the commission is ignoring the issue. It's just stating that there is a data element that if we could do even more with.
Okay, and I want to get back to that with CSOSA and what data we do and do not have access to. But
I believe Judge Lee is now with us.
Oh, great.
I'm so sorry, folks, that I was delayed. And Court, I hope you accept my apologies. Don't let me interrupt.
Not a problem. Actually, Judge Lee, if you are going to be staying with us, I'll go ahead and swear you in. We swear in all government witnesses who appear before the committee. And that way you can join Director Fry in answering questions.
Very well.
Great. All right, you've got your right hand raised already. Do you swear or affirm under penalty of law that the testimony you are about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. So it's actually great timing, Judge Lee, for you to join, because we were talking about the trends in community right now with access to illegal firearms, with repeat offenses, especially for people who have previously been convicted of firearm offenses. And we were discussing the ways in which those realities were considered or contemplated in shifting the box that these cases fall in. But it goes back to a discussion we were having yesterday at the council breakfast. The Sentencing Commission joined us for several hours and answered a lot of questions from colleagues. And one of the things that we talked about was this kind of chicken or the egg theory of, is the commission influencing judges or judges influencing the commission? And so on one hand, 98.6% of cases per your testimony, judges are sentencing people within the guidelines. So that would lend itself to the argument that judges are following the guidelines. But you've also said that the guidelines were promulgated and created based on judicial practice and other data. And so if I'm hearing that the sentencing guidelines are followed, and then in the case that they weren't followed, we're looking to what the judges are doing and then perhaps updating the guidelines, where is the data component of making the determination of what should be in a different range? Or is it really only based on practice? So in theory, at the time the sentencing guidelines were promulgated, if judges were issuing very low sentences or very high sentences, it would seem to follow that the guidelines would mirror some of that.
So a large part of what the initial guideline effort was to try to create some consistency and fairness across all felony sentencing. And so what you initially saw was that they looked at a wide range of felony sentences, and they took the top 25% off the higher end of judges' sentencing pre-guideline. They took the lower 25% off of the range, and they created this 50% middle ground, which the guidelines were initially based on. And that was looking at really a substantial amount of information about sentencing pre-guidelines. So when you ask specifically about the felon in possession, the unlawful possession of a firearm, where an individual is sentenced because of the prior conviction, part of the reason that the adjustment was made to the guideline was because of the actual practice of the parties and judges in sentencing. So if you recall, in that instance where an individual is convicted of that offense, there's a 1-year mandatory minimum. Our original guidelines were actually a little higher than that. And so the modification or the adjustment to the guideline brought in line the practice of the court and the parties for asking for sentences consistent with the mandatory minimum, so that the guidelines reflected that.
Is the goal to have the guidelines be followed 100% of the time?
So I imagine a good number of people probably take that position. And Mr. Fry and I don't know that we've talked about this one, but Council Member Pinto, I don't believe that that is really a goal that is appropriate. And I say it for the following reason. The guidelines are voluntary, and they're designed to give judges discretion within boxes. But there's nothing about the guidelines themselves that say to a judge, this is what you have to do. If a judge, based on hearing from the government, the defense, and all of those other individuals with an interest in the case, determines that the guidelines are just not an appropriate sentence, that judge should have the authority to simply move away from the guideline and impose a sentence that is permitted by statute. And so when you see judges who sentence outside of a box with a non-compliant sentence, there's something about that case that simply says to them, we need to do something other than what is in the box, whether it's below the guideline box or above the guideline box. I actually think there's value in that, because when the judge communicates with us about the reasons for that, that's a data point for us. And if we get enough of those data points, we should be taking a very serious look at what the guidelines are doing about a particular offense, where we simply have the data that suggests that maybe the guidelines aren't the right application to that set of facts.
Thank you. Director Frye, do you have a different take on that?
No, I agree with Judge Lee. Our goal is not to get 100% compliance with the guidelines. There are always going to be outlier cases or outlier situations. I also think it's important to note that just because we see trends happening in Superior Court does not mean we automatically adjust the guidelines to meet those trends. It just means that we analyze them and evaluate them to see what happens and whether there is a situation where we should be making adjustments or not. But it's not like we're trying to modify the guidelines so they accommodate all sentences in Superior Court. That's definitely not the case.
Okay, thank you. So I want to raise another example that came up yesterday morning about strangulation and negligent vehicular homicide. Can you re-articulate what that conversation was and what some of the decisions were about the grid with those two offenses?
Certainly. So, I don't think I need that.
Might be helpful.
Sorry?
So that actually might be helpful.
Oh, okay.
I have one here too, but
Well, we can hold it up so everyone can see it.
right.
Have grid will travel. So strangulation was one of the new offenses passed last summer as part of the Emergency Act. And therefore it came to the commission as a new offense of where we should rank it on the master grid. And so we started, as we do with every offense, and we looked at what's the maximum penalty for the offense, what's the maximum penalty that can be imposed for the offense because of statutorily required backup time. That's not always the maximum penalty. We look at if it's defined as a crime of violence, and then we look at the general harm caused by the offense, and then we compare it to other offenses with similar penalties. So for strangulation, what we did is we saw strangulation was given a 5-year maximum penalty with a 3-year maximum penalty the judge can impose at sentencing. So at sentencing, the most time the judge could give for that offense was 3 years. And then we compared it to all the other 5-year maximum penalty offenses. We found, I believe, actually, I don't have my notes from yesterday in front of me, but I think I can do this by memory. We found there were 54 5-year maximum penalty felony offenses that the commission had previously ranked. Of those, the majority were ranked in Master Group 9. However, it was close. A number were also ranked in Master Group 8. Master Group 8 is where a 5-year offense would fall on the guidelines default grid. So if for some reason there is an offense that the commission hasn't been ranked that is coming up for sentencing, the guidelines have a default grid based purely on the maximum statutory penalty that says if it's, in this case, if it's an offense with a maximum of 5 years or more, but less than 10 years, its default is in Master Group 8. So we looked at that, and then we found, so we had a majority of these 5-year penalties in Master Group 9, slim majority, a number in Master Group 8 and only one offense in Master Group 7 with a 5-year penalty. That one offense was negligent vehicular homicide. And so while the commission talked at length about the harm caused by strangulation, and without a doubt, it was considered a very, very serious offense. That harm was similar to the offenses that were ranked in Master Group 8 than the extreme harm, in fact, an actual homicide for the one offense that was ranked in Master Group 7. And so as a result, the commission ranked the offense in Master Group 8. And so as you'll see on the master grid, it would fall in Master Group 8 with carrying a pistol without a license, unauthorized use of a vehicle, attempted robbery, and offenses of that nature.
Okay, thank you so much for that clarification. That makes a lot of sense as it relates to all of the categories that have a maximum allowable penalty of 5 years. Was intentionality of the offense one of the considerations that you made?
Yes. So it's one that we look at. So intentionality, one of the things we look at for all offenses that are being ranked are what are the elements of the offense and what are the different ways that that offense can actually be committed. And intentionality or intent goes directly into that. It's one of the challenges the Sentencing Commission faces under our current statutory scheme is we have, this is not true for strangulation, but just talking more generally, we have some statutes that are very, very broad. Robbery is a good example of this. Robbery can be committed in a number of ways. So all of them have a significant amount of harm, but some of them, a physical snatching of something off of someone, has a lot more harm than a pickpocketing, which can also be covered under robbery, where the victim may not even know the event occurred until after the fact. So there's a great disparity in what can be done under that offense, which is one of the reasons why we have such large guideline ranges, is we have to cover that range of behavior. Otherwise, it really, it would not be fair to a defendant who committed a pickpocketing to treat them as if they committed a forcible robbery. But the reverse is also true. And so when we're looking at new offenses like strangulation, we look at the intent and the different ways that those can be offenses. The offenses can be committed along with the harm when we're evaluating where to rank them. So it's not just based on the data. It's not just based on where other offenses are placed on the grid. All these things are taken into account together.
Okay, thank you very much for that explanation. One more thing on strangulation that worries me is, given its classification in Group 8, it's my understanding that would make it eligible for probation for the entirety of the sentence because it's falling in the yellow box. Is that right?
For individuals convicted of a Master Group 8 offense with very low criminal history scores, so column A and B, column A is no prior non-lapsed felony, so essentially just misdemeanors or maybe very old felony offenses, and column B, which could be one prior lower felony. Those are probation eligible. Column C is short split eligible. However, defendants with the most severe criminal history scores, even for offenses in Group 8, are in prison only boxes. And again, that's not to say a judge can't impose a prison sentence in any of those boxes. However, you are correct in that group for defendants with lower criminal history scores, they are eligible for either probation or a short split sentence.
Okay. And I think that's something of particular concern with strangulation, similar to what we were talking about earlier today with repeat offenses committed with a firearm and the trends that we're seeing now. Strangulation is extremely predictive of future domestic violence, future homicides. And we see this a lot with intimate partners. And I worry that some of those cases in trying to make strangulation a felony offense was the legislature recognizing this summer that this was a very serious offense and needs to be treated as such. And so that worries me for strangulation victims, that some of those cases could be served entirely on probation.
Well, can I just add a kind of a quick thought here? Because I think one of the other considerations for the commission is when we have new legislation that comes, is the new legislation something that's defined as a crime or violence or not? That is certainly a discussion piece and a factor for us. So when strangulation was enacted, it was not placed in the portion of the DC code that defines a crime of violence. And so the concern that you raise, I think, is a very significant one. But when we see that it's not so classified, that puts us in a little different place for discussions. And Mr. Fry, can you just remind me and correct me if I'm wrong, but I think that the commission vote on the classification for strangulation was a consensus vote. Is that right?
Yes, it was.
Okay. Well, thank you for that additional context. And Judge Lee, luckily, one of the provisions in Secure DC clarifies that strangulation is a crime of violence. And so my hope is that the council votes in 13 days to pass.
If I may
Yeah,
interrupt,
please.
and as that changes, so by adding it a crime of violence, that will cause the Sentencing Commission to reevaluate the ranking of that offense as well. The other thing I want to add is that if there is strangulation that involves the violation of a protective order, that has a statutory enhancement that will also enhance the guidelines range for that offense as well. So the guideline range increases by the top of the guideline range goes up by the exact same percentage as the statutory enhancement.
How has the commission contemplated civil protective orders and violations of them? Has this come up in other contexts in your work in the last year?
Not over the past year, but the violation of protective orders is something that's discussed. And like I said, because that is an enhancement, that the commission has evaluated those and put that enhancement of provision in effect, so that if that's found and the statutory enhancement applies, not just for strangulation, but for any other offense, it will increase the top of the guideline range as well.
So switching gears a little bit, congratulations on the rollout of the Sentencing Guidelines User Support Program. I understand that in fiscal year 2023, the commission offered in-person trainings, pre-taped training videos, virtual trainings, virtual office hours, and an annual report fact sheet. I'm interested to learn more about the upcoming effort by the commission to produce the sentencing guideline decision trees that will walk users through how to determine a defendant's prior criminal history score. So who is the audience for these sheets, and how are you monitoring the efficacy of what's included and how you're distributing them?
That's a great question. So the audience for these sheets is 100% for practitioners. That's not to say we won't use them to help the public better understand how the guidelines work, but we really are trying to make it easier for practitioners to apply the guidelines. Because when we talk to them, we understand that, I think the guidelines are fairly easy to apply, but I work with them on a daily basis. That's not true for all practitioners, judges and attorneys alike. And so we try to make that as easy as possible. And so what the goal of these decision trees is that instead of just having to read the rules and kind of figure out what are the steps in determining, what a possible offense severity group is, or what my client's criminal history score might be, it'll actually walk them through on a step-by-step basis. Look up the offense severity group in the guideline manual, determine if an enhancement applies, see if it's a well-armed or attempted offense that might affect that ranking. And then going to the criminal history score is, how they read through a defendant's criminal history sheet, pulling out, which of these are convictions, which of these are convictions that happened within the last 10 years, which of these are juvenile convictions, how can those juveniles be scored, so that attorneys, rather than having to do it on their own, can essentially follow a step-by-step process in applying the guidelines as they go about determining how to craft or whether to accept pleas, what should be stated to the court, and what the defendant's actual score and recommended sentencing might be. So it's really an effort to make that easier for them.
Okay, thank you. Well, I look forward to seeing that.
I do too. We're very excited about this initiative. I don't know that we'll be able to cover every single circumstance, but we're going to try to cover as many as possible.
Understood. So in your responses, Director, to pre-hearing questions, you mentioned that the agency has concerns about funding for personnel, specifically the need for more data analysts. In addition to staffing challenges for data analysts, are there other experts or professionals that the commission needs and which would facilitate your work?
So we absolutely could use more data analysts. I mean, as you've seen, and as I talked about, the amount of data being requested from us continues to increase each year. More analysts would allow us to respond to more data requests, do more individual detailed analysis, perhaps into areas that we haven't looked at yet. And just make sure that our data system is functioning as it should be, because that builds into this as well. Our data system is over 10 years old now. In addition to meeting the court's upgrades, we also have to maintain it in a similar fashion. So beyond more analysts, I don't think we need any more specialized technical staff. I think the biggest hurdle we have now is we need to readjust the organizational chart of the Sentencing Commission so that we can better and more efficiently handle those needs. We have not had a general counsel for over 2 years, even though we have a qualified individual who could assume that role. We don't have the funds to support that. Additionally, what I would like to do is take our statistician role and move that into more of a management role that could supervise all data projects and also oversee our data system. And so more funding would allow us to do that as well. And I think those would both increase the commission's performance. That's not to say in the future we might not need more expertise, but that would be the most helpful things at this moment.
Got it. Okay, thank you. So let's talk about CSOSA a little bit, because in your pre-hearing responses, you talk about the lack of access to reports on criminal history data. This is also something we talked about yesterday morning. But then in your testimony, you talked about CSOSA being a good partner and sharing information. And so can you explain what the distinction is? What authority does the Sentencing Commission actually have in getting the information you need on criminal histories from CSOSA, and how does that depart from what you're actually receiving from CSOSA?
And that's another very good question. So the short answer is we have no authority to request things from CSOSA. CSOSA is a federal agency. As a local DC agency, we work with them as a partner, but don't have any authority over them. And CSOSA has a representative on the commission. His name is Cedric Hendricks. He's one of their associate directors. He's been a fabulous commission member and really does work to try and get us the resources we need. The problem is CSOSA's interpretation of the Privacy Act is that they are not allowed to share that unique data with us because it has so much personal identifying information. And it makes sense. Someone's criminal history information is some of the most secure information that there is out there, especially when we're dealing with juvenile offenses that show up on people's criminal records. So they interpret that as them not being able to share it with us. So all they give us is the defendant's total criminal history score, rather than a breakdown of offenses that we could really use for research and analysis, both on research on what's currently happening, but also what would the effect be of potential guideline changes that we might make in the future. It's not, they do work with us as a partner. For the past several years, we've been trying to find solutions to this issue. Unfortunately, the solutions that we've come up with under their interpretation of the Privacy Act have just been too labor intensive for us to get that data. We talked about whether or not they could strip away a lot of the identifying information that would allow them to give that to us. Unfortunately, the way their data is preserved, it's not in a really electronic database. It's just in essentially a Word file. So that would take a great deal of manual effort. Also, removing some of that PI, personal identifying information, reduces our ability to kind of link those up with some of our other data that would encompass full analysis. So it's not that CSOSA isn't working with us. It's just that they have a different interpretation of the Privacy Act than we do. And because of that, they don't feel that they're allowed to share that data with us.
And is the Sentencing Commission or anyone at CSOSA, from your knowledge, working on securing changes to the Privacy Act with the federal government to address this issue?
Not specific to this issue, no, I'm not aware of anyone working on that.
Seems like something we should work together on.
I think so.
So in 2022, the commission started following prosecution rates. What kind of trends have you found?
So this was something that we were allowed to do because of our upgrade in accessing MPD data. And so what we found is that prosecution rates, and we only have a very small sample size since we started following this. So I don't want to talk about trends just because we don't have enough data to do that. But what we saw is that prosecution rates have remained consistent in 2023. Just let me flip through my notes to get to. Let me just ask our statistician who knows these numbers much better than I do.
Sure.
Do I have to raise my hand? And say anything?
If you're going to answer questions, you do, but if you need to just
Oh.
share a note with him.
So working.
70% 2018. Thank you. So in 2018, we saw a case papering rate of approximately 72% of felony arrests. In 2022, that number had dropped all the way down to 54% of felony arrests. For 2023, and I have to emphasize that this is preliminary data for case papering rates. We have to do a lot of data cleaning, and we'll put those final numbers out in our annual report that gets published in April. But at least at this point, it appears that the case papering rates for 2023 have actually increased from 54% to 64%, which is a fairly large one-year jump. One thing I have to highlight, and I know I mentioned this yesterday, but every time we talk about it, I think it's very clear, is that our case papering rate does undercount two situations of papered cases. The first is when a case is not brought forward in Superior Court, but moved over to U.S. District Court. So it becomes a felony case. In our data, which only comes from Superior Court, that looks like a not papered case, even though the prosecution was taken up in federal court. That happens in a small percentage of cases, but it does happen there. The other situation is if a case is initially no papered by the prosecution. So they've determined that there's not enough evidence to move it forward at that time, but they gather more evidence later on. A very common example of this is they have some sort of physical item that they think there may be DNA on. And so they get a warrant and they get a buccal swab, so essentially a cheek swab from the defendant to take their DNA and compare it to the DNA on whatever object that could be. Oftentimes we're talking about a firearm. Once those results come back, that may increase their amount of evidence. And so they may repaper that case. Again, that doesn't happen a lot of times, but it certainly does happen in those situations as well. In our data, that comes across as a no papered case because at least initially the government did not bring a prosecution in Superior Court.
Thank you so much for that additional context. I think it's really important, as is the breakdown that we continue to look at of violent crime papering rates. I'm very interested in what you highlighted earlier of the rates dependent on ward.
Yeah.
That's definitely something that we should dive into a little bit more as well. And another thing with DNA testing that Secure DC addresses is to allow for this testing to be done at arrest for felony cases, which we're hoping will allow these cases to move forward. So lastly, I want to ask about the management system. You talked a little bit about the court's major process to switch to the system, but it's my understanding that the Odyssey Enterprise Justice Project to update the commission's current internal data system and integrate the data from the DC Superior Court has been delayed. Can you explain a little bit about the cause for delay, if that's true? And if the cause is on the Superior Court side, then what we think the timeline is?
I can. Well, I can answer part of that question. So the cause of delay is from the Superior Court working through its partners. And again, we meet on a weekly or more basis with Superior Court, with the partners, with CJCC to discuss this process. So it's by no means an intentional delay. It's just a very large, very complex project. The court has rolled out part of their new system on the civil side, and they're working to refine that more as we speak. And because of that, on both the family side and the criminal side, which was put in phase 2, just because of the essentialness of operations in both of those divisions, it hasn't been released yet, and they're not going to release it until they're sure that it's going to work and it's going to work properly. Also, as they work through this, they continue to make changes. That's not to make our or anyone else's life difficult. It's just a matter of what they need to do to integrate those systems. Unfortunately, it is those changes that causes issues for the Sentencing Commission, because we have to react and adapt to those changes to make sure we still get the data. To the second part of your question as to what the estimated timeline is, unfortunately, I can't speculate to that right now. We've had several deadlines and anticipated release dates that were not able to be met. And so I think at this point, and I don't want to speak for the court, especially Judge Lee, I think they're being more conservative and not trying to put out the deadlines that they may or may not be reachable until they're more confident in their ability to do so. But that's just me reading the conversations. That's not my direct firsthand knowledge.
Well, I'll give you the direct answer to the chair. There's not a firm time period that I'm aware of right now for Odyssey to be moved over to what we refer to as phase 2 for family court and the criminal division. Odyssey is up and functional in the civil, probate, and tax divisions. But with a new system that does all that Odyssey does, there's a lot of work we have to do to make sure it fits the demands of the court system. And so if I find out that we have a firm date, we'll certainly provide that to you. We've had to adjust some dates as we just work through onboarding this new system.
Okay. Well, we look forward to staying in touch on that progress. Thank you very much, Judge Lee. I want to give you both, Judge Lee and Director Fry, if you have any closing thoughts you want to add. No pressure to do so, but just in case we didn't get to anything or you wanted to clarify anything before we close out.
Judge Lee?
Mr. Fry, I'm going to defer to you. I will say nothing more than we appreciate the opportunity to come to the hearing today, but also the opportunity at the breakfast yesterday. We thought it was important that we're able to share information, and we want everyone at the council to understand that we continue to be available to share whatever information that you folks think will be helpful in the task that you have. So thank you very much on behalf of the entire commission, each of its members, and the staff.
I also want to reiterate that thanks. I think as you are uniquely aware, these are critical times and situations that we're dealing with. And so the support and attention that's being given to the Sentencing Commission is very much appreciated. Also, I know we've gone over a fair amount both today and at the breakfast yesterday. But if there's any follow-up questions or things you could use more information on, more details about the guidelines or about our data, we're ready to assist you, any members of this committee, the council, or even any members of the public in understanding that better. So we definitely consider ourselves a partner as we go forward trying to find solutions.
Fantastic. Well, thank you so much, Director Fry and your entire staff. And thank you, Judge Lee, as well, for joining us today, all the work that you do throughout the year. Look forward to a continued partnership.
Thank you, Chairman.
All right. We are now moving on to the Office of Victim Services and Justice Grants so that everybody can follow along. If you're waiting to testify virtually, we're going to first hear from our I'm going to speak about the office briefly. Then we're going to hear from our one panel of in-person public witnesses. Then we're going to take a brief 15-minute recess, and then we will come back and hear from the remaining public witnesses and then our government witnesses. Okay. So we are turning to the next agency on our agenda today, the Office of Victim Services and Justice Grants. As we call it, and you'll hear me call it throughout the day, OVSJG. OVSJG's mission is to develop, fund, and coordinate programs that improve public safety, enhance the administration of justice, and create systems of care for crime victims, youth, and their families in the district. In FY 2023, OVSJG distributed 132 awards, amounting to many millions in grants. This includes funding to support district students struggling with attendance, returning citizens, victims of domestic violence and sexual assault, and many other victims of other crimes. OVSJG is the state administering agency responsible for the direction of systemic criminal justice planning, coordination, management, research, training, and technical assistance. OVSJG provides policymaking expertise, advice, and counsel to the executive on the role of victims and offenders in the criminal justice system, and evidence-based practices to respond to, intervene in, and prevent violence. This is done in part through the work of the Juvenile Justice Advisory Group, which includes 5 appointed youth members and the Domestic Violence Fatality Review Board. I look forward to discussing today how OVSJG is working to provide transparency in the grant dispersal process and ensuring that all funds available are awarded to grantees in a timely fashion. This is especially important for our access to justice initiatives and goals in the city as well. I'm interested in gaining clarity and transparency from the agency on several concerning reports the committee has received, such as the agency including a quote, no cause termination clause in its grant contractual language. This would essentially allow the agency to terminate grant awards without any cause at all, and concerns from grantees that the agency is not operating with transparency and consistency with grantees. For grantees who are operating on tight budgets and vulnerable victims, this is of the utmost concern. I'm also interested to hear about how OVSJG is measuring where the greatest demand for service is, where the district should be prioritizing additional resources, and the impact of our existing grant programs. On a related note, I want to learn more about the agency's funding strategies, grant administration practices, and the legal basis or sources of some of its recent policies and those denying mortgage payments. Finally, I'm hoping to discuss various issues and programs such as the private security camera program, the violence prevention response team or VPART coordinator, domestic violence prevention, and youth services. For today's hearing, we'll hear first from our public witnesses here to discuss OVSJG and then from our government witnesses. As usual, public witnesses will have 3 minutes to present their testimony, and those who represent organizations will have 5 minutes. If there are 2 people from the same organization, 1 person will have 5 minutes, and it is up to you who you want that person to be. Now I'd like to invite our first panel of in-person public witnesses. We have 1 panel today, so I'll ask you all to come up. And if you can start sitting in this chair and then move. So Nancy Drain, Executive Director of DC Access to Justice Commission. We're gonna have to pull another chair up. If Akima, you wouldn't mind helping, or Evan, okay. Nancy Drain, Executive Director, DC Access to Justice Commission. Dawn Dalton, Executive Director, DC Coalition Against Domestic Violence. Charles Lowry, President of the District of Columbia Bar. Rachel Feinstein, Director of DC Government and Community Relations, Jewish Community Relations Council of Greater Washington, and Ingrid Swinton, Public Witness. If I can ask everybody scooch over a little bit so we can fit a 5th chair, that would be great. Thank you for accommodation. All right, and we will start with Nancy Drain, Executive Director of the DC Access to Justice Commission.
Good morning. Thank you so much for the opportunity to testify today, Chair Pinto, and welcome to the committee staff. My name is Nancy Drain. I'm the Executive Director of the DC Access to Justice Commission. The commission was created in 2005 to address barriers that district residents experience with the civil justice system, including the scarcity of legal services. I'm glad to be the first today to testify about the impact of the initiative funded through OVSJG and administered by the DC Bar Foundation. This committee has consistently championed this program from its creation in fiscal year 2007, and especially in the last several years. We are especially grateful for the council's support last year when the program was facing significant reductions. Today, you will hear testimony that will demonstrate the wide breadth and deep impact of the initiative. With our time, we would like to provide an overview to complement our detailed written testimony. The initiative has three components. The first, the Access to Justice Grants Program, addresses the demand for civil legal services in the community, promotes language access through an interpreter bank, and supports DCBF's efforts to make legal services more effective, collaborative, and accessible. The second, the Civil Legal Counsel Projects Program, was created to provide targeted support for legal help in eviction-related matters. And then the third, the DC Poverty Lawyers Loan Repayment Program, is an important retention and recruitment tool that keeps high-quality legal services attorneys serving our residents. The initiative is a critical part of the district's comprehensive strategy to address community priorities that the mayor, the council, and we all share: stable housing, public safety, and economic opportunity. Initiative programs help build stronger neighborhoods where district residents can live, thrive, and maintain a good life for themselves and their families. The initiative is critical because, unlike in criminal proceedings, there is no right to a lawyer in civil cases, even when your family, your home, or your safety is at risk. This is a highly effective program with a long track record of success. Today's testimony will show that giving people legal help leads to better individual and community outcomes. The initiative works. What does this mean in practical terms? Every day, initiative-funded staff at over 30 nonprofit organizations are in the community across all 8 wards. They staff legal helplines, legal clinics, and offer community education. They partner with district agencies and community nonprofits, including health systems. They represent tens of thousands of district residents in a wide range of legal issues. They promote policy solutions here at the council and beyond. They facilitate pro bono representation of low-income clients by private lawyers, and they operate courthouse-based programs and promote fairness in our courts. The initiative helps maintain the district's unique character by keeping district residents safely and stably housed in their community. Our testimony details the effectiveness of initiative housing interventions offered to thousands of residents, highlights like 81% of represented tenants remaining housed. The initiative furthers your commitment to a holistic view of public safety by making our community less vulnerable to crisis. Our testimony provides a host of examples of initiative programs that address family instability, support youth, returning citizens, survivors of crime, and address core areas that individuals need to thrive in their community. We also detail the way initiative programs promote economic security and opportunity for district residents, obtaining tangible financial benefits for individuals, but also leading to community savings, especially in the health context. In creating the initiative, the district has ensured that the civil justice work is done strategically and in a coordinated manner and with equity in mind. Together, initiative programs work together to leverage resources and maximize impact through collective action, collective learning, and evaluation. This includes innovations that make our civil justice system more accessible. It would be hard to imagine our civil justice system without the initiative. It would be less effective, less just, and less equipped to address the community issues we face. Thank you so much for the opportunity to testify today.
Thank you, Ms. Train. Don Dalton, Executive Director of DC Coalition Against Domestic Violence.
Good morning, Chairperson Pinto and staff. My name is Dawn Dalton. I am the Executive Director for the DC Coalition Against Domestic Violence, otherwise known as DCCADV. We are the federally recognized statewide coalition of domestic violence service providers in the District of Columbia and include domestic violence specific housing providers, counseling and case management services, legal services, and culturally specific organizations serving African, Latinx, Asian and Pacific Islander, immigrant, teens and youth, and survivors who are deaf and deafblind. Intimate partner violence continues to be a significant safety and public health concern for DC residents of all ages. To that point, we know that 39% of women and 25.5% of men living in DC have experienced sexual violence, physical violence, stalking, or a combination thereof perpetrated by an intimate partner. OVSJG is the primary DC government funding body of domestic violence services in the district. Without a strong, healthy relationship with this office, the clients served by members of DCCADV and many others struggling who have yet to be connected to resources will be pushed further away from the support they need and deserve. During the last year, we have appreciated increased communication and responsiveness working with Director Porter and her team, and we look forward to continuing to work with OVSJG to improve consistency across grant managers and grant awards. However, this being said, the grant cycle has also raised concern within our membership because they can no longer be confident that the OVSJG funded services they provide will be sustainable for their clients to access. As you know, and mentioned in your opening statements, in the FY24 grant agreements, OVSJG added a new clause stating that issued grants can be revoked at any time during the year without cause with 30 days notice. Grantees were required to agree to this provision despite the objections from the field. We join with our fellow OVSJG grantees in expressing the deepest concern over this new no-cause termination provision. Our organization, like most other DCCADV member programs, rely on the funding that we receive from OVSJG to provide critical, life-saving services to survivors of domestic violence. It is not possible to plan annual budgets, hire and retain dedicated staff, and provide uninterrupted services to survivors, knowing that one of your main funders can pull funding mid-year with very little notice. We ask that the council take immediate action to have the clause removed from OVSJG agreements or nullified so that we can focus on continuing to provide uninterrupted services to survivors. Similarly, we would like to add our voice to the issue of transparency that you also noted that have been raised by our membership and the broader victim assistance network of OVSJG grantees. The mayor's budget has not historically included enough information for grantees or the council to identify how OVSJG will allocate its pool of funds to support the myriad of victim service needs, such as the percentage that will fund domestic violence services in the upcoming year, or the percentage that will fund human trafficking, sexual violence services, etc. OVSJG's compliance with all of the provisions of the Transparency Act of 2022 will enable the victim services community to better coordinate efforts and meet the needs of all victims of violence and maintain the highest quality of services for survivors. Each year, DCCADV and our member programs are tasked with meeting the needs of increasing numbers of survivors without sufficient funding. We were pleased in FY24 to see funding increased or kept level for many services on which survivors rely. However, we are concerned year after year as we face cuts to critical services and funding that does not meet the demand. In addition, OVSJG will not fund primary prevention for domestic violence. Partner violence in adolescence can be a precursor or risk factor for partner violence in adulthood. Primary prevention strategies are key to ending partner violence in adolescence and adulthood and protecting people from its effects. A comprehensive approach that simultaneously targets multiple risk and protective factors is critical to having a broad and sustained impact on intimate partner violence and other interconnected forms of violence like bullying, community violence, suicide, and others. It's all connected. As the main DC government funder of domestic violence services, if OVSJG will not fund domestic violence primary prevention efforts, it is unsurprising that other agencies have not stepped in to fill that gap. In the remaining seconds of my time this morning, I would like to say we have a budget platform for FY '25 in the ask of $30 million over FY '24 funding. We also stand in solidarity with the Victim Assistance Network and the Fair Budget Coalition to meet the broad array of service needs within district residents. And I'm always open to answer any questions that you may have. Thank you so much.
Great, thank you, Ms. Dalton. Next, we will hear from Charles Lowry from the DC, excuse me, the District of Columbia Bar President.
Yes. Thank you. Good morning, Chairwoman Pinto and members of the council. Thank you for this opportunity to testify. My name is Charles Lowry, and I am president of the District of Columbia Bar. The DC Bar is the largest unified bar in the country with more than 117,000 members nationwide and 65,000 members in the DC metropolitan area. As DC Bar president, I also chair the board of directors of the DC Bar Pro Bono Center, the largest provider of pro bono legal services in the district. On behalf of the bar and the Pro Bono Center, I would like to express my enthusiastic support for the Access to Justice initiative. The DC Council and you, Chairwoman Pinto, deserve special thanks for your leadership in creating this program, which provides critical legal assistance to low-income district residents. The Access to Justice initiative plays a vital role in promoting the rule of law by reducing barriers that prevent equal access to justice for low-income district residents. When our most vulnerable residents can meaningfully participate in our legal system, the chances for injustice are greatly diminished. The Access to Justice initiative leverages the power of volunteer lawyers. The DC Bar has one of the strongest commitments of pro bono of any bar in the country. However, private law firms and government lawyers depend on DC's network of nonprofit legal services providers for training, mentorship, and support. A well-resourced, well-functioning community of legal services providers is critical to the rule of law and makes it possible for a volunteer attorney to defend a mother and child at risk of eviction, help a young father maintain custody of his children, and assist a disabled neighbor seeking public benefits. Access to Justice initiative funding has been transformative for the DC Bar Pro Bono Center. In 2020, when Mayor Bowser issued the emergency order to stop the spread of the coronavirus, initiative funding empowered the Pro Bono Center to collaborate with 5 other providers to create the Landlord-Tenant Legal Assistance Network. That hotline connects DC residents facing eviction and other housing issues with free legal help. It includes the Pro Bono Center's Landlord-Tenant Resource Center, one of the only free legal resources available to small landlords. That network has served over 10,500 individuals since its inception. Recognizing the Landlord-Tenant Legal Assistance Network is of great value to the community, in 2022, the council passed legislation requiring landlords to include the network's phone number in all notices of past due rent served on tenants. This bold, progressive action by the council ensures that tenants at risk of eviction are notified about free legal services before a case is filed against them. In a recent survey, 75% of tenants reported that availability was the only place they turned to for help. The Access to Justice initiative also supports the Family Law Assistance Network. This is another innovative collaboration launched amid the pandemic. Since March 2020, through a telephone hotline and on-site at Superior Court, the Pro Bono Center and 2 partner providers have helped 3,000 individuals in their divorce, child custody, and child support cases. Initiative funding has enabled the DC Bar Pro Bono Center to do more to help DC residents remain in their homes and keep their families together. We have built a custom call center and intake and referral platform, which has become, again, the #1 source for tenants facing eviction. Pro Bono Center staff can efficiently route calls to our partners, protect confidential information, and email legal information to clients. Partners can monitor each caller's progress, and tenant organizers can complete intakes in the community and submit a tenant's request for help from a smartphone. So we also have a new program to address the significant lack of free estate planning and probate services for district residents. It is critical that we protect our longtime DC residents who are at risk of losing their family homes and generational wealth that contributes to the overall well-being of families and communities in our city. So Access to Justice Initiative funding has been critical to ensuring that our legal system can deliver outcomes that are fair and accessible to all district residents, irrespective of wealth or social status. We'd like to thank the Judiciary Committee for its commitment to helping people experiencing poverty and its recognition of the importance of providing access to justice for residents of the District of Columbia. Thank you for your time, and we are available for questions as well. Thank you so much.
Thank you, Mr. Lowry. Rachel Feinstein, Director of DC Government and Community Relations at the Jewish Community Relations Council of Greater Washington.
Good morning, Chairperson Pinto, staff, and fellow panelists. Thank you for your leadership and work on this issue and for the opportunity to provide comments on the Office of Victim Services and Justice Grants, OVSJG. My name is Rachel Feinstein. I'm a Ward 6 resident and Director of DC Government and Community Relations with the Jewish Community Relations Council of Greater Washington, the JCRC. The JCRC is the public affairs arm of the organized Jewish community, representing over 100 synagogues, community centers, schools, and social service agencies throughout DC, Maryland, and Virginia, including nearly 20 in the district alone. I am here today on behalf of the DC Jewish community and one of our community partner organizations, the Jewish Coalition Against Domestic Abuse, JCADA. JCADA, who is a coalition member of the DC Coalition Against Domestic Violence, is a Jewish victim services agency that works closely with both local domestic violence agencies and the local organized Jewish community. Their resources are dedicated to, one, empowering all survivors of intimate partner violence in the greater Washington area to live safely, two, educating the local Jewish community about intimate partner violence, and three, articulating the unique needs of Jewish survivors to the secular community. JCADA serves the Jewish community and anyone in need, regardless of faith, gender, or other identities, free of charge. In DC, JCADA provides both clinical long-term trauma therapy as well as victim advocacy services. In FY23, they saw 177 clients in DC, 20% of their whole client base, with $127,000 in funding from OVSJG. We in JCADA are particularly concerned, as mentioned earlier, about a new clause added to the FY24 grantees contracts that allows the Office of Victim Services and Justice Grants to revoke grants at any moment with just 30 days notice and without cause. Grantees, including JCADA, were required to agree to this new provision despite community objections in order to receive vital grant funds. When grantees approached the office to discuss the provision, they were denied the opportunity to discuss further. We ask that the council take swift action to remove this clause from grantees' contracts or be nullified so that service providers can focus on supporting victims and not whether they will lose their funding. I'd like to share a couple JCADA client experiences. First, a client's abuser was released from prison and began harassing her digitally and then in person at her home and work. JCADA helped the client find different housing and helped her to enroll in the address confidentiality program, as well as set her up with a new Ring camera. The JCADA advocate also spoke with the client's manager per the client's request to ask that she be transferred to a different work location due to safety concerns. Specific to the Jewish community, anti-Semitic incidents in the United States have been on the rise for several years, and since the horrific attacks in Israel on October 7th, 2023, the atmosphere in the cultural, political, and social service sectors has deteriorated dramatically for the Jewish people. A JCADA advocate related the following story. Sarah, name changed to protect privacy, a client who recently left her abuser and has begun to establish a new life, has a son who currently lives in Israel. Due to enforced isolation from her abuser, she has few personal connections and constantly struggles with loneliness. Her stress has risen with worry for her son since the outbreak of the war. Sarah shared with her victim advocate that she was considering returning to her abuser because he could provide support that she is unable to find elsewhere. Jakeda's victim advocate was able to find safe community-based support for Sarah, empowering her to remain committed to her safety plan and continue to thrive in her new life. This is the kind of work that would be disrupted if the 30-day revocation clause stands. Thank you for the opportunity to provide you with these comments. I'm happy to answer any questions today or following the hearing. The services Jakeda and others provide in DC are vital. In the words of a DC Jakeda client, I am more grateful than you will ever know for the support. You have given me another level of safety and protection. I'll never forget your kindness. Thank you.
Thank you so much. Ms. Feinstein. Ingrid Swinton, public witness.
Good morning, Chairman Pinto and staff. My name is Ingrid Swinton, retired. I'm 64 years old. Even though I'm retired, I work 2 part-time jobs to make ends meet. I was facing an eviction from my resident, and legal counsel for the elderly assigned Attorney Child to help me. I received an eviction notice to go to court. My landlord was looking to evict me from my home. I have lived in my current apartment for 6 years. My floor has many seniors and is quiet, and I love that it is a good family environment. As a grandma, it is important that it is in a good school district. I'm comfortable there, and as an older person, I really want to stay. The issue was that I was not able to pay parking and late fees because of the finances at the time, and management was applying my rent to these other fees. As a result, I was never able to catch up with the balance on the statement, even though I was paying my rent. They appointed me one of the best attorneys on their staff, I believe. I am grateful for the staff appointment to me. Attorney Child spent many hours with me on the phone, email instructions, and in-person visits, clarifying the next steps of this case. She and staff at Legal Counsel for Elderly gave me their attention to this case. Attorney Child explained to me that management was illegal applying my rent to late fees. She challenged this practice in court, but the case was not dismissed. So we went to mediation. At mediation, my attorney took the lead to negotiate on my behalf. Through mediation, I was able to enter into a payment plan that could keep up with and will allow me to stay in my apartment. She made sure I knew what I needed to know to make a choice about the payment plan. Bread for the City provided a check which helped make the payment plan workable to me. After mediation, the settlement agreement was filed with the court, and the court was dismissed, and the case was dismissed with a reasonable payment plan I can do. In addition to representing me in my case, Attorney Child told me about Housing Counseling Service Relief Program. I applied and received additional financial support. I was able to get caught up with my bills, which made it a little easier on me to keep up with my rent and payment plan. After I received 3 checks, I was informed the program ran out of money and had no more to give. Through the help of Legal Counsel for the Elderly, I was able to settle my case and stay in my apartment. People may not know their rights as a tenant. If they knew their rights, they would be able to make better decisions and not be taken advantage of. Having information about my rights was crucial and allow me to stay in my home. I want to thank you for allowing me to testify.
Thank you very much, Ms. Swinton, for sharing your personal story and experience. We really appreciate it. And I'm glad that the payment plan worked out. Thank you all for being here and for the work, the crucial work that you do throughout the year. And as we think about performance oversight for OVSJG, which is what we're here to discuss today, I want to ask those of you who have had specific conversations with OVSJG about the no cause termination clause. And so, Ms. Dalton, I know you talked about that in your testimony. What was that conversation like, if you can share about being made aware of this new methodology and how they informed you of it?
So there were no prior conversations to the grant agreements going out that this new clause was being put into and included into grant agreements. So it took all of the grantees by surprise to see this included there. Subsequent to learning of this, in one of my conversations with OVSJG, what was explained to us was that this is a clause that is in many of the DC government agency grant agreements, and cited a particular regulation that I know is in the pre-hearing questions that OVSJG provided. The piece that continues to be confusing to us is our understanding is that those regulations are connected to contracts and not grant agreements, and that there is a very clear divide around the expectations and what qualifies as a contract versus a grant agreement. So that is an area where we are still looking for some answers.
Thank you for that. Have there been any conversations about how they would enforce the no cause clause if it came to that?
No, other than it is a situation that would be not very likely to occur, that there would need to be a major catastrophe within the DC government, within the city, in order for those dollars to be reallocated to respond to some emergency of some sort, that the Office of Victim Services and Justice Grants didn't see that it would be implemented. That being said, we saw mid-year cuts occur last year to OVSJG grants rather. And whether that was a mistake or we were able to get those funds reinstated, but we have seen a history of mid-year cuts to victim service grants. And so it's cause for concern.
Mm-hmm. Okay. Mr. Drain, I'm not sure if you had something to add to that. Okay. Okay. So Mr. Lowry, I wanted to ask you about the pro bono hotline. The pro bono services that the DC Bar provides are so important to so many district residents. How has that hotline been working? And do you think it's getting enough public publicity? And how could we aid in that effort for people to know about the resource?
Well, thank you for the question. I have some basic information on that, Chairwoman Pinto, and I might have to get back to you with more detail, but I believe that based upon my testimony, the fact that the hotline number is now available, to so many more residents and put into the forms and papers that tenants receive, that's a great addition. But I think we're open to opportunities to spread that word even more. So.
Thank you. And do you feel that you have sufficient staffing to manage the hotline incoming inquiries?
Yes, I do. I think at the DC Bar and the staff of the DC Bar Pro Bono Center, the leadership there is working hard to reinvigorate the staff and to really move the whole pro bono program forward. So.
Great. Thank you.
Thank you.
Ms. Drain, thank you for highlighting the different categories of work that you're involved with. What categories comprise the biggest portion of spending within access to justice? Where's the biggest need?
Sure. So looking at the FY '24 budget, the Access to Justice Grants Program, which supports a wide range of civil legal services, that appropriation was around $20 million. The Civil Legal Counsel Projects Program, that's the eviction related work, that was $11 million. And the loan repayment program was $350,000. And I just want to note that the Access to Justice program does include other housing related work. So I think that the Bar Foundation will testify later, and I'm sure provide you with more detail, but I think all told about 50% of the funds go towards housing related work, but that could be foreclosure or housing discrimination, eviction prevention efforts. So trying to get landlords not to file for eviction, but to help tenants earlier in the process. So that's how the funding is distributed. It has been about in those ratios over time, and certainly would continue in those ratios in the future. We always emphasize that the need presented in the community is always greater than the capacity that we have to serve. We could always use, additional funding to support the need, but are incredibly grateful for the increases that we've received in the past several years.
Thank you very much. And we're about out of time, but I just wanted to ask you, Ms. Swinton, if you knew the check that Bread for the City was able to provide to go towards your payment plan. What was that process like for you to get that money in your pocket?
Oh, it was very easy. Miss Chow, she sent me the instructions on exactly what to do. And so I called them and they told me information that they needed in order to check to see if I was qualified. And once I sent them the information and they went over it and read it, they told me I was qualified, but it was very easy because of Attorney Chow instructions to me.
May I make a quick follow-up point?
Sure, very briefly.
Yes. I just wanted to emphasize that this ability of legal services providers to connect people with other programs is a really key part of the initiative. It's of course the primary service is legal service, but I think what Ms. Wynn described is something that folks do every day to try to identify those other resources that are in the community and make sure that clients have access to them. So I just wanted to highlight that. Thank you.
Thank you all. Okay, well, appreciate you being here. This is sorry, we don't have the time to ask some questions, but this is our only in-person public witness panel for OVSJG today. So we are going to take a brief recess. That it is 11:55 right now. We're going to recess until 12:10 p.m. And we'll pick up with our virtual public witnesses. Thank you all. All right, welcome back, everyone, to the Committee on Judiciary and Public Safety Performance Oversight Hearing, the Sentencing Commission, and the Office of Victim Services and Justice Grants. We spoke with the Sentencing Commission this morning, and our first panel of public witnesses for the Office of Victim Services and Justice Grants. The time is now 12:17 p.m. on Wednesday, January 24th, and we are reconvening. I would like to invite our next panel of virtual witnesses on the Office of Victim Services and Justice Grants: Kira Jarrett, Diana Fitz, Sandy Marifer Hernandez Escobar, Tatiana Santos, Karen Newton Cole, Marilyn Lovo, Caroline Fair, Elena Bowers, Danielle Del Pielago. As a reminder, public witnesses have 3 minutes to present your testimony. Those representing organizations will have 5 minutes to present your testimony. If there are multiple people from the same organization, one of you will have the 5 minutes representing the organization. It's up to you which that is. We have many public witnesses today, so I ask for all of our witnesses' help in monitoring the clock so I don't have to cut you off with time. So thank you all for being here, and we'll get started with Kira Jarrett, the Chief Executive Officer of the DC Bar Foundation.
Good afternoon, and thank you. I want to make sure that you can hear me. Thumbs up, okay. My name is Kira Jarrett, and I'm the Chief Executive Officer of the DC Bar Foundation, the leading funder of civil legal aid in the District of Columbia. I want to thank you for the opportunity to testify today regarding OBSJG funding, which we received through the Access to Justice Initiative. I have 3 brief points in my time, but first I want to start with a thank you, a word of thanks to the council for funding this initiative for 2007. There's no question that your investment has had an impact on thousands of vulnerable DC residents. And second, I want to thank Director Porter and her office for their support as we have managed this program. The first of my 3 points is that I want you to know that the Access to Justice Initiative works, and we have the data to prove it for each revenue stream. The Access to Justice Grants Program, through this, we've been able to respond to increasing client demand. By the time we receive the final reports for FY23 in the next month or so, we expect that we will have surpassed the number of cases closed in FY22, which was nearly 13,000. The second revenue stream, the Civil Legal Counsel Projects Program, which we refer to as CLCPP, we've managed this since 2018 with a $4.5 million investment at that time. And over the past 6 years, because of the incredible success of that program, you have seen fit to more than double that investment with $11 million awarded in FY23. Later this morning, you will hear from Kelly Jarvis of NPC. She is the lead evaluator of this program. But please understand that this program benefits district residents in every single ward in the city, with more than 7,400 residents helped and more than 9,000 cases closed in the nearly 4-year period from August 2019 to June 2023. The third revenue stream is the Loan Repayment Assistance Program, which we've managed since 2007. It's a vital benefit for DC legal aid attorneys with student loan debt. At the end of FY23 in September, we had more than 36 attorneys enrolled in the program. We've since seen that number increase to 49. But in FY23, including one-time funding that we received, we were able to forgive almost $683,000 in debt. The second point I want to make is that the Access to Justice Initiative is making systems change happen. You have provided us with targeted funding to create a more coordinated system of legal aid, intake and referral so district residents won't struggle so much in finding help from more than 50 legal aid organizations. We are creating a model that folks across the country are watching very closely and of which you can be proud. With district funding provided last year, we have continued to develop the system, and we're prepared to launch a pilot in the next couple of months in the area of family law. And through a series of focus groups we hosted throughout FY23, many in partnership with other OBSJG grantees and also other community stakeholders, we know that district residents need this system to work, and that's what we're building. The third point that I wanted to make is that Access to Justice Initiative promotes public safety. investments in civil legal aid, promote public safety, which I know is a top priority for the council. And I just want to share a few brief examples of how that happens. By providing trauma-informed legal and support services for victims of domestic violence, we can reduce future incidents of violence. And when we reduce and prevent the ongoing cycle, it creates a safer and more secure community. Assisting formerly incarcerated persons helps to reduce recidivism. When formerly incarcerated people transition back into the community with support and services such as employment and housing, we reduce the chances of a reoffense. It allows them to make positive and healthy contributions to their community. And a third example, in providing legal services to individuals facing debt-related lawsuits, this helps prevent a financial crisis for the client that can severely impact and limit access to their basic daily needs. Mitigating these debt and financial issues helps the client and contributes to neighborhood stabilization and community well-being. If these issues are not addressed immediately and with the proper resources, we increase our chances of community crisis. Early, successful intervention methods can create more stability and resiliency in our communities. As I wrap up my testimony, I just want to reiterate that the Access to Justice Initiative allows DC residents to get the help that they need in accessing critical services. And every resident deserves a fair, just, and equitable legal experience. And funding through OVSGG makes that possible. I thank you for the opportunity to testify and would be happy to answer any questions.
Thank you very much, Ms. Jarrett. Next, we are going to turn to Danielle Del Pialago, Housing Director from Empower DC.
Thank you so much. Are you able to hear me?
Yes, I can.
Wonderful. Thank you. And thank you for allowing me to cut in line here. My name is Daniel Del Pialago. I am the Housing Director for Empower DC. We partner with Rising for Justice, longtime Access to Justice grantee in their eviction diversion work. Going on 3 years now, the Access to Justice grant has allowed us and a coalition of legal service providers and community-based organizations to inform district residents about their tenant rights and available supports for people facing an eviction. As we understand it, in this past year, 2023, we had a very low number of defaults, people not appearing to their initial court hearing. We believe that along with virtual options to appear in court, our collective efforts are helping district residents traverse these often complicated waters. The work is important in several ways. As mentioned, it provides district residents with real resources they can avail themselves of, but it also is helping to grow a better informed community. We've received several calls from people who got our information from a neighbor, friend who we outreach to that referred them to us. And Councilwoman Pinto, you had asked how how the word is getting out about the LT landline, and part of it is these efforts where we go door to door, letting folks who are on the court, who have been summoned to court, know that they have this support, but we also will leave flyers in general at the buildings where these folks live. As a coalition, we have strengthened our connectivity and can problem solve, identify issues, and provide better advice and support for district residents. Another added value to this work is that it sends a clear message to landlords that there is a process in place to try to evict the district residents. There are laws and processes that they must follow. On a more somber note, this past year, we saw a total of 1,194 families evicted, a large number of district residents who have gone through this traumatic experience. Many have few housing options, and some even are potentially experiencing homelessness. While we haven't found a solution to this great problem, we know that the ground we've gained in eviction diversion wouldn't be possible without the funding from the Access to Justice grant. It has allowed us to build this network of support that is still very needed in Washington, D.C. We are thankful for the council's support in making this work not only a reality, but ensuring its longevity. As we embark on this new year, we know that there will be challenges, but glad that this extensive network exists to support district residents facing these challenges. Thank you so much.
Thank you, Mr. Del Pialago. Diana Fitz, Senior Case Manager at IUTA.
Good afternoon. Thank you, Chairperson Pinto and members of the committee for the opportunity to testify today. My name is Diana Fitz and I'm a Senior Case Manager at IUTA. Ayuda has been serving immigrant communities for 50 years. Ayuda offers a full range of social services, immigration, family law, consumer fraud assistance, as well as language access support for low-income immigrants from anywhere in the world. Ayuda's clients include survivors of human trafficking, domestic violence, sexual assault, and other violent crimes. My testimony today will focus on the key role that the Office of Victim Services and the Justice Grants plays in ensuring that immigrant victims of crime receive culturally competent services. Last fiscal year, through the VOCA grant, Ayuda provided holistic wraparound legal social services to 240 victims of crime in the district. Additionally, in fiscal year 23, through the Violence Against Women Act funding, Ayuda Domestic Violence, Sexual Assault, stacking programs, provided legal services to 175 immigrant victims and case management service to 130 immigrant victims. Immigrant victims are often unable to access victim services due to fear of the criminal justice system, limited language proficiency, lack of knowledge about their legal rights, and available service and transportation barriers. With the OVSJG funding, Ayuda ensures that the district immigrant crime victims have access to low barrier, culturally specific supportive services. Ayuda's legal services include advice, counsel, and extended representation in immigration matters relating to victims in their restoration. Our social services consist of wraparound case management services that help survivors achieve their unique goals and work through trauma. Case management services include emotional support, crisis intervention, safety planning, food assistance, diaper and other infant and child needs assistance, criminal justice and legal advocacy, and accompaniment, financial, educational, and employment counseling referrals, housing advocacy and support, emergency financial assistance, and a variety of information and referral services to meet specific needs. With the rise of crime in the district and the continuing economic impact of inflation, the increase in the newly arrived immigrants, Ayuda anticipates that the demand for low barrier legal and social services for immigrant survivors will continue growing. Although we serve hundreds of survivors annually in DC, we must refer many survivors to other organizations due to funding constraints and capacity constraints. We receive multiple phone calls every day from individuals seeking assistance who unfortunately lack capacity to serve. Many partner organizations also face similar challenges. We remain committed to helping meet the increased demand for legal and social services during this time, but our ability to do so depends on the ongoing support of the OVSJG to ensure that immigrant survivors can build safe and secure lives. We urge the committee to continue to support the critical role that the OVSJG plays in funding of core services for victims of crime. I'm joined today by Sandy Escobar, one of my clients served through the OVSJG VOCA grant. I'm proud of all Sandy has accomplished and happy that she's here to share her story. Thank you for your time today.
Thank you so much. Next, we will hear from Sandy Marifer Hernandez Escobar, client at Ayuda. We have a Spanish interpreter with us today, so we're going to double your time to make sure that we can hear your testimony. For the interpreter who's here as well, you both online?
Yes, I am.
Wonderful. Thank you for joining us. Please go ahead.
Por favor, comienza.
Hola, buenas tardes. Mi nombre es Sandy Marifer Hernández Escobar.
Hello, good afternoon. My name is Sandy Escobar. There's a little bit of an echo. I don't know if
Tengo 24 años y soy de El Salvador.
I'm 20 years old and I'm from El Salvador.
Inicié en ayuda hace 1 año y medio. Me refirieron de la escuela Next Step por el motivo que fui víctima de violencia doméstica.
I started getting involved with Ayuda about a year and a half ago. I was referred to Ayuda through Next Step, the school's Next Step, mainly because I was victim of domestic violence.
Cuando yo llegué, conocí a mi trabajadora social. Yo tenía mucho miedo de hablar, pero ella comenzó a tratar conmigo como para hacerme sentir en confianza y haciéndome sentirme segura con ella. Comenzamos con unas clases de yoga, de relajación.
When I first arrived to Ayuda,
Eso me ayudó mucho y fue por unos meses. Luego ella me preguntó qué era lo que más me gustaba, cuál era mi pasión, cuál era mi sueño. Yo le dije que siempre inspiraba la cosmetología y ella me inscribió en unas clases de corte y extensión. Y como en ese tiempo no tenía trabajo, me ayudaron con asistencia de vivienda y comida y con tarjetas de Uber. Luego de eso me llevó a unas clases presenciales de corte y extensiones. Fue fantástico, ya que en cada evento que ella me inscribía, yo iba teniendo más confianza en
Bueno,
mí, descubriendo mi
señorita, un
potencial y
ratito.
ayudándome
Señorita,
a vencer mis miedos.
tiene que parar cada 2 oraciones, por favor, para que
Diana
pueda
me
interpretar.
inscribió en la Academia Ball para clases de microshading. Ahora que me gradué, lo que más deseo y anhelo es trabajar y poder lograr tener mi propio salón y poder ayudar a más chicas que rompan el silencio. Y le doy gracias a Dios por el apoyo de ayuda y de Diana Fitz. Ella siempre me brinda confianza y sobre todo seguridad de lo que yo soy y puedo lograr. Los servicios de ayuda apoyan a sobrevivientes de violencia doméstica a romper esa barrera del silencio y miedo. Con este apoyo todos somos capaces de seguir luchando y nunca quedarse atrás. Agradezco esta oportunidad de compartir con ustedes el impacto positivo que he tenido en mi vida los fondos de la Oficina de Servicios de Víctimas y Justicia. Muchísimas gracias.
Can you hear me? She didn't stop anywhere, so I'm gonna start from the beginning. When I first arrived to Ayuda, I first encountered my social worker. I was very fearful back then, but she made me feel welcome and comfortable in the space so that we shared. She put me through yoga and relaxation activities that made me feel more in tune and comfortable with her presence. This helped us to bond a little bit more. And then I also told her about my passions. She enrolled me in a cosmetics courses where I was able to learn about cutting hair and extensions. They also Ayuda also helped me with housing in the district because I was not able to afford it back then. After I took all of the in-person classes for cutting hair and extension, I was able to graduate from the micro shading certification. My dream is to have my own salon, open my own business, and help other girls to break their silence, other people who might be going through the same thing that I was. Thank you so much to Diana Fit. She always gave me confidence, to me and other survivors of domestic violence. My main goal and Ayuda's as well is to allow and help other people to break through the barrier of fear and silence. And I really appreciate this opportunity for sharing the positive impact that Ayuda has had on me.
Wonderful. Thank you so much, Ms. Escobar and Mr. Sarmiento, for your translation. Appreciate your testimony.
Maravilloso. Muchísimas gracias, señorita Escobar, y gracias al intérprete por la interpretación. Thank you, Your Honor.
Okay, we will now turn to Tatiana Santos, Language Access Coordinator at Ayuda.
Thank you, Chair Pinto and members of the council. My name is Tatiana Santos, and I am a language access coordinator at Ayuda. I greatly appreciate the opportunity to testify to the Committee on the Judiciary and Public Safety regarding the funding provided to the Office of Victim Services and Justice Grants. Ayuda is a nonprofit organization that helps immigrants from across the world overcome obstacles to succeed and thrive in the United States. Our services include legal representation, therapy, case management, advocacy, and language access. Today, we are urging the council to continue supporting the Office of Victim Services and Justice Grants in its work to serve marginalized communities. One of the projects funded by OVSJG is Ayuda's Victim Services Interpreter Bank, as I will be referring to it as VSIB. VSIB launched nearly 10 years ago and reaches some of DC's most vulnerable residents by breaking down the language barrier that stands in the way of accessing help for limited English proficient and deaf and hard of hearing individuals. This is achieved through providing access to local specially trained interpreters, on-demand telephonic interpretation, and document translations. VSIB serves victims throughout the city, helping advocates in a variety of ways, whether by providing interpretation for client intakes, ongoing one-on-one therapy sessions for domestic violence and trauma victims, forensic interviews and exams for sexual assault victims, and much more. Each time a victim receives culturally appropriate services in their language, faith in the system is restored. That victim will relay to members of their community that help is available, even for those who cannot speak English. In 10 years, VSIP has grown to serve nearly 40 different organizations that provide victim services. There are over 90 specially trained interpreters accepting VSIP assignments in about 30 different languages, including Spanish, Amharic, French, Chinese, Arabic, and American Sign Language. During the 2023 fiscal year, VSIP provided local specially trained interpreters on 264 occasions and on-demand telephonic interpretation in 1,715 instances. Most requests were for interpreters working in Spanish, Amharic, Arabic, American Sign Language, and Dari. VSIP also arranged for the translation of 34 documents, and these services were free of charge for victim service providers because of the funding from OVSJG. VSIP is clearly meeting an urgent need, as recent census data for the district indicates that nearly 13.3% of DC's population are foreign-born. Significantly, 5% of the district's population is limited English proficient, speaking a broad range of languages, and the district is also home to one of the largest per capita populations of deaf and hard of hearing people in the US, many of whom communicate in sign language. As a member organization of the DC Coalition Against Domestic Violence, we join the coalition's request and for increased funding for providers offering culturally specific services to respond to the ever-growing and ongoing needs of crime victims, including funding for language access services, which are vital to the provisions of victim services. Again, I thank you for your time and for holding this hearing. Thank you so much.
Thank you, Ms. Santos. Karen Newton Cole, co-chair of the DC Consortium of Legal Service Providers.
Good afternoon, Chairman Pinto and members of the council. My name is Karen Newton Cole, and I am the Executive Director of Neighborhood Legal Services Program of the District of Columbia, and I am the co-chair of the DC Consortium of Legal Services Providers. It is in my role as the co-chair of the consortium that I submit this testimony regarding the impact of the Access to Justice Initiative, which is under the purview of the Office of Victim Services and Justice Grants. I would like to take this opportunity to thank the members of the council and the mayor for recognizing the importance of this funding and strengthening the fabric of our communities. I would also like to thank Chairman Pinto for her leadership and the council for their unwavering support over the years. The consortium is a coalition of 35 legal services organizations that provide direct legal services to DC residents. I, along with my co-chair, Ariel Levinson-Waldman, the founding president and director council of CESDAC DC, am responsible for advancing the consortium's mission to coordinate delivery, expand the availability, and improve the quality of legal services and advocacy for the poor and disadvantaged people and groups of people in the District of Columbia. Many consortium members receive funding from the Access to Justice Initiative, and we are able to leverage these grants to meet our collective missions. This year, our clients have benefited from the council's wisdom and the continued funding of the Access to Justice Initiative. With this funding, our member organizations are able to keep families in their homes, prevent homelessness, address consumer debt, ensure quality education, obtain benefits for disabled residents and students and seniors, address domestic violence, ensure the safety of our children, remove barriers to work, and to improve the lives of DC residents in numerous other ways. Your foresight in providing this sustained investment has ensured that many low-income residents of the District of Columbia have their voices heard, and just as important, have their essential needs met. It is only through this investment that we can continue to work together and to ensure access to justice for the most underserved populations in our city. Critical to this sustained effort are the talented, dedicated attorneys that work to resolve legal issues confronting our communities. Funding for the DC Poverty Lawyers Loan Repayment Program, or LRAP, provides legal services organizations with an important tool to recruit and retain needed talent. Attorneys that work for our member organizations make less than their counterparts in private law firms, corporations, and even the government. LRAP assists them in deferring some of the expense of the oftentimes crippling law school debt. Additionally, through your support of the Civil Legal Counsel Projects Program, legal services organizations have maintained and expanded the reach of the Landlord-Tenant Legal Assistant Network, or LT-LAN. LT-LAN is a single intake point for those with landlord and tenant problems. It provides advice, counsel, and extended representation to people and families threatened with eviction. Legal services organizations work together to man LT-LAN line, answering questions, providing advice, and guiding potential clients through the legal process. As a result of this funding, over the last couple of years, this collaborative has been able to expand its reach, working with partner organizations to obtain resources and support to ensure housing stability and ultimately to prevent eviction. This funding also supports another critical resource, the Language Access Line. It is through the Language Access Line that many of our provider members are afforded the opportunity to represent people with different language orientations. Having access to trained interpreters allows these clients to fully participate in their representation and to understand the issues and choices available to them. This resource has been critical to ensuring access to justice for all. The legal aid community continues to explore ways to improve our service delivery. As I testified last year, we have been working to develop a coordinated intake and referral system. I am happy to report that under the leadership of the DC Bar Foundation, the project is advancing. In collaboration with the foundation, many of our members are working hard to turn that concept into a reality. It is anticipated that a pilot will be launched to test the system in the near future. Thank you once again for the opportunity to testify on behalf of the DC Consortium of Legal Services Providers, and I thank you for your continued support.
Thank you very much for your testimony. We will now hear from Marilyn Lovo, Language Access Director at IUDA.
Good afternoon, buenas tardes. My name is Marilyn Lovo, and I am the Language Access Director at IUDA. I would like to thank Chair Pinto and the committee for allowing IUDA to testify on the vital role that the Access to Justice Initiative plays in bolstering the district's safety net. Earlier, my colleague spoke about one of the initiative's projects, IUDA's Victim Services Interpreter Bank. I will be speaking about another one of its projects, IUDA's Community Legal Interpreter Bank, to which I'll be referring to as CLIB. When the DC Council passed legislation creating the initiative, it included a shared legal interpreter bank as an essential component. For 17 years, IUDA has administered that bank and become a trusted language access expert and resource. IUDA is a unique national model CLIB is a unique national model that has been extremely effective in creating equitable access to civil legal services for limited English proficient and deaf individuals. Organizations across the country contact IUDA looking to replicate CLIB. And in DC, we worked with OVSJG to replicate CLIB in the victim services setting, thus resulting in the Victim Services Interpreter Bank. CLIB uses an original curriculum, the language of justice, to train professional interpreters to work with lawyers and their clients in out-of-court settings. We then pay these specially trained interpreters to accept both on-site and remote requests from 44 nonprofits. In addition, we provide nonprofits with access to on-demand telephonic interpretation and document translations. All of our services are free of cost thanks to the grant funding we receive, including an award from the initiative. CLIB has grown to serve 44 different organizations. The 117 interpreters who accept assignments work in 25 different languages. During the last fiscal year, we provided specially trained interpreters on more than 400 occasions, on-demand telephonic interpreters in more than 7,500 instances, and arranged for the translation of 440 documents. We regularly train staff not only on language access, best practices, and navigating our services, but on the complicated technological solutions, including hosting remote meetings. When simultaneous interpretation is requested for on-site assignments, we provide simultaneous equipment free of cost to the nonprofit. We go to great lengths to ensure that those who benefit from CLIB have positive experiences and receive services of the highest quality. And after 17 years of working with the legal services community, CLIB has normalized serving clients in languages other than English. New funding for the Access to Justice initiative in the last few years has allowed CLIB to realize its purpose more fully, and the need for language access in legal services has never been greater and continues to grow. We must build on our progress to avoid abandoning linguistically isolated communities in need of legal services. And we are grateful to OVSJG and the DC Bar Foundation as grantors of the Access to Justice Initiative for the vital role they play in ensuring equal access to justice for all DC residents. Thank you.
Thank you very much, Slovo. Next, we will hear from Caroline Fair, Senior Staff Attorney at Legal Aid DC.
Good afternoon, Chairperson Pinto and committee staff. My name is Caroline Fear, and I'm a senior staff attorney in the Domestic Violence and Family Unit at Legal Aid DC. With OVSJG support, Legal Aid provides legal services to domestic violence survivors, ranging from legal advice to full representation in court, for civil protection order cases, related custody and divorce proceedings, and more. Through OVSJG, Legal Aid meets with low-income domestic violence survivors at the Domestic Violence Intake Center Southeast, or the DVIC Southeast. The DVIC is an invaluable resource for our client population because it provides a myriad of services in one convenient location, effectively serving as a one-stop shop. Legal Aid has staffed the DVIC Southeast physical location for over 20 years and has been staffing 4 days a week since the center's reopening in December 2022 at the Anacostia Professional Building in Ward 8. Legal Aid attorneys meet with survivors remotely and in person to provide on-the-spot legal advice. And through these efforts in fiscal year 2023, we provided advice or representation to over 300 survivors through OVSJG. I'd like to share a brief story to highlight the important services we provide and why OVSJG is so critical. Legal Aid met Anna Green through the DVIC Remote Assistance Project and assisted her with her CPO. Ms. Green, whose name has been changed to protect her privacy, endured years of physical and emotional abuse from her husband. Legal Aid worked closely with Ms. Green to gather evidence and file a comprehensive petition for a CPO, which was eventually granted. But Ms. Green's legal needs did not stop there. Ms. Green's husband continued contacting her incessantly and then filed for divorce, where he asked that Ms. Green be ordered to pay him spousal support. Legal Aid represented Ms. Green in her case, and after several difficult and contentious hearings, Ms. Green's husband stopped participating in the case, and the court granted all of Ms. Green's requests, including an absolute divorce without having to pay financial support, and she was granted sole custody of their child. Because she endured years of violence and coercive control, Ms. Green suffered from PTSD and depression and experienced extreme anxiety leading up to her court dates. Legal Aid worked with Ms. Green to ensure she felt prepared, supported, and heard so that she could achieve her goals. And our work with Ms. Green and other survivors would not be possible without the support of OVSJG. OVSJG recognizes that many survivors have complex legal needs, both immediate and long-term, and we are proud to work with them. We thank the Council for the opportunity to testify today and for the Council's continued support of OVSJG. Legal Aid is proud to have worked with OVSJG for over 20 years now, and we ask that the DC Council and the administration continue to support the critical role OVSJG plays in the funding of core services for domestic violence survivors. Thank you.
Thank you, Ms. Fear. Next and last on this panel, we will hear from Elena Bowers, Supervising Attorney at Legal Aid DC.
Good afternoon, Chair Pinto and members of the committee. My name is Elena Bowers, and I'm a supervising attorney in the housing unit at Legal Aid. OVSJG, through the Access to Justice funding and the DC Bar Foundation grant process, is the largest funder of the Legal Aid housing unit. It funds 24 staff, including 17 attorneys, and is vital to providing legal advice and representation to thousands of district residents each year. Housing displacement continues to be at record levels in the district, caused in part by increased evictions and resulting in skyrocketing demands for legal services. The total number of scheduled evictions in DC increased more than 250% between 2022 and 2023. 1 in 4 district renters live in Ward 7 or 8, and they account for more than half of all eviction cases filed and half of all executed evictions. The affordable housing crisis is a racial justice issue. Legal Aid works in close coordination with the other legal services grantees, including fellow panelists from NLSP and the Legal Counsel for the Elderly, who will be testifying shortly, to design and implement strategies like the Landlord-Tenant Legal Assistance Network that you have already heard about today, in order to ensure that as many tenants as possible have the benefit of counsel. In 2023, Legal Aid alone provided advice or representation in 924 cases, impacting 1,876 DC residents. In more than 300 of these cases, a legal aid attorney represented a tenant in all or part of their eviction case in court. My written testimony focuses on the work that Legal Aid has done with partners to ensure that we're able to meet tenants at the landlord-tenant courthouse where they need us the most, and leverage our collective resources through the Right to Counsel project with the participation of law firms across the city. I would be happy to answer questions about either of those projects, but would like to use the remainder of my time to share the story of just one of the residents we helped this year. In November of 2023, one of my colleagues met a tenant at the landlord-tenant courthouse who was scheduled for eviction that same day. The tenant had a default entered against her when she failed to appear at trial after the death of a family member and receiving some bad advice. The legal aid attorney was able to counsel her about her options, provide legal advice, assist her with filling out and filing the application to stay in eviction and a motion to vacate a judgment that had been entered against her, and ensure that a hearing was set for the same day, and the marshals were notified to stand down until the hearing concluded. Each of these steps may have been a barrier for this tenant had she not had counsel. At the same day hearing, the eviction was canceled, and that tenant now has the opportunity to fight to keep her home. Legal Aid is only able to do this important work with support from the Office of Victim Services and Justice Grants. We appreciate the offices and the council's dedication to ensuring our neighbors are able to access justice through the courts. Thank you.
Thank you very much, Ms. Bowers, and thank you to all of the witnesses on this panel. I think really each of you and as a whole demonstrating the importance of legal services to provide to so many residents across the district. And I really appreciate all of the work that you all and your teams do every day to serve some of our most vulnerable neighbors. So thank you very much. We're now going to call our next panel of virtual public witnesses: Kelly Jarvis, Sunny Desai, Sonia Connolly, Lindsay Silverberg, Sarah Tenen, Natalia Otero, Kylie Hogan, and Catherine Arndell. Give you all a moment to join. And we can start with Kelly Jarvis, the Director of Research and Community Health from NPC Research.
Hi, good afternoon, Chair Pinto and members of the community. and the committee. My name is Kelly Jarvis, and I'm the Director of Research and Community Health at NPC Research. I work with the DC Bar Foundation to evaluate some of the programs funded through the Access to Justice Initiative. And I'll use my time today to mention a few key learnings that highlight 3 themes that I think uniquely distinguish work being done through the initiative. And those themes are collaboration, innovation, and evaluation. As part of the initiative, as you've heard earlier, the Civil Legal Counsel Projects Program funds 7 legal aid organizations to assist low-income district residents who are facing eviction. From August 2019 until now, these organizations have provided legal services to nearly 10,000 low-income tenants. The services are used by tenants in all 8 wards of the district, and they reach the most vulnerable renters. In 2023, 1 in 5 clients experienced a disability or a chronic health condition. 1 in 3 lived in a household with children. The average income across clients was just over $1,000 a month. And those with an active eviction lawsuit, 93% of them faced a landlord with an attorney. These direct legal services are critical, and our data show that they're effective at helping tenants understand their rights, navigate the court process, and in many cases stay housed. Of those renters represented by a legal aid attorney in court, more than 3/4 kept their homes. And in most jurisdictions, this would be the end of the story. Legal aid providers use their grant money to legally advise and represent as many people as they can on their own. However, the story in the District of Columbia goes further because, frankly, the providers have gone further. They've used initiative funding not only to offer these critical legal services, but also to engage each other in building a better system. They've developed and sustained a robust collaboration through which they have shared data and accelerated the flow of information across organizations. They've leveraged available resources and reduced duplication of effort. They've established partnerships with other important entities like the Housing Authority, rental assistance providers, and the court. They've collaborated on key legislative and policy advocacy efforts. They've coordinated broad community outreach efforts to ensure that tenants are aware of their services. And they've increased the system capacity by jointly training more than 100 pro bono attorneys in housing law. To be clear, and to be frank, the eviction defense service system in the district is better organized, better coordinated, and more responsive to tenant needs because of the providers' collective efforts. This collaboration has led to notable innovations, such as the Landlord-Tenant Legal Assistance Network, or the LTLAN, which you've heard about this morning. Our data show that the LTLAN has become a trusted and widely used community resource. In the past year, 65% of the clients who accessed eviction legal services did so by calling the LTLAN. And when we surveyed clients about their experience with the LTLAN, they overwhelmingly reported feeling grateful for and satisfied with this service. Another more recent innovation is the Eviction Prevention in the Community, or the EPIC project, which involves these same legal aid providers now partnering with community-based organizations to reach tenants early before they end up in court. In addition to this work, the funded providers have also participated in a comprehensive evaluation of the program, which has yielded substantial data allowing the DC Bar Foundation, OVSJG, and the providers to assess the effectiveness of their services, to understand what's working, and to identify any potential improvements or emerging needs. As a result, we're able to tell a nuanced story of how the Access to Justice Initiative funded work has fundamentally improved the system for low-income district renters. The DC Bar Foundation has leveraged these learnings to support another important innovation, the development of a district-wide coordinated intake and referral system for the full range of civil legal issues that district residents face. This effort is also rooted in collaboration, as it involves the participation of dozens of legal aid organizations, and the effort is also supported by data and evaluation. To date, we have systematically gathered input from more than 100 district residents and used this information to guide the design of the system to ensure that it's built to meet the needs of the people using it. In short, the Access to Justice Initiative is not about sustaining business as usual. With this investment, legal aid providers are actively manifesting a better and stronger system to support justice for all district residents. They're effectively collaborating, they are creatively innovating, and we're evaluating the progress of these efforts so we can learn what works. The providers are leveraging district resources well by doing more together than any of their organizations could do alone. Thank you for your time today and for your continued investment in this important initiative.
Thank you very much. Next, we'll hear from Sunny Desai, Manager and Legal Aid Attorney at the Legal Counsel for the Elderly.
Good afternoon, Chairwoman Pinto and members of the committee, and thank you for the opportunity to testify today. I am Sunny Desai, the Managing Attorney of the Tenant Advocacy and Support Practice at Legal Counsel for the Elderly, or LCE. We are one part of the Landlord Tenant Legal Assistance Network, or LTLAN, along with Legal Aid Society of DC, Neighborhood Legal Services Program, Rising for Justice, Bread for the City, and the DC Bar Pro Bono Center. Thanks to your leadership and the Council's continuing support to the Access to Justice Initiative, my colleagues and I are able to assist the district's most vulnerable tenants in navigating the landlord-tenant court system. DC has some of the strongest tenant protections in the country, but those protections only work if tenants are able to assert them. Thanks to the initiative, nearly 3,500 low-income residents were routed through LTLAN last year and received some form of legal, social work, or case management services. That is 3,500 DC households that received help in preventing homelessness, securing affordable housing, and addressing substandard housing conditions. You have already heard from one such DC resident, Ms. Swinton, about the value of the service. Her case involved a highly technical argument that would be difficult to make in court without the assistance of an attorney. Luckily, my colleague Sarah Cho was able to provide that assistance and stop her eviction. We truly appreciate Ms. Swinton's kind words today, but the truth is Sarah is just one of nearly 50 such attorneys across 6 different LTLAN organizations that come to the defense of low-income DC residents every day. Their work has an outsized impact in promoting housing stability and preventing a cascade of negative outcomes that follows an eviction. That's compounded by the fact that DC has a dearth of affordable housing options. You will later hear from my colleague Sonia Connolly, a tenant empowerment specialist at LCE. She and her counterparts at other legal service organizations help tenants access crucial lifelines like rental assistance, food stamps, and energy assistance. It's safe to say that without their help, many of our clients would have missed their chance to access rental assistance during the few hours that the portal was open on January 2nd. Finally, thanks to new funding provided by the initiative in FY22 and FY23, we were able to create the Eviction Prevention in the Community Project, or EPIC. Daniel Del Pilago testified a bit about that, but this is a growing effort between legal service providers and community-based organizations to educate tenants about their rights and connect tenants to resources. As you can see, the initiative is a positive step toward increasing access to justice for low-income DC residents. The initiative helps, the initiative works, and the initiative provides indispensable services to some of the most vulnerable DC residents. We thank the DC Access to Justice Commission, the DC Bar Foundation, and the DC Council for their support in this endeavor. Thank you again for the opportunity to testify, and I'm happy to answer any questions.
Thank you very much. Sonia Connolly, Tenant Empowerment Specialist from the Legal Counsel for the Elderly.
Good afternoon, Chairwoman Pinto and committee members. I want to thank you for the opportunity to testify. I'm Sonia Connolly, Tenant Empowerment Specialist with Legal Counsel for the Elderly during the last year, thanks to the Access to Justice Initiative program. My testimony will focus on how the 5 tenant empowerment specialists across the district support DC residents in accessing justice and stable housing. The application process can present a major barrier to access for many low-income residents. Many of our low-income residents, especially seniors, lack the technology or technological experience to request social services and resources to which they are entitled. Often these programs require significant document submission into systems that often shut down, and when they do work, are not user-friendly. So many of my tenant empowerment, especially colleagues in the Landlord Tenant Legal Assistance Network, and I assist our most vulnerable residents navigate the application process for DC social services and subsidies for which they are eligible. These services on their own, including emergency rental assistance, emergency rental assistance program, supplemental nutrition assistance, the low-income home energy assistance program, and Medicaid. Can you hear me?
Yes, we can.
Okay, great. and Medicaid are essential to assist our clients maintain housing and financial stability. My colleagues and I also assist our clients with housing searches, which are increasingly more difficult as the affordable housing crisis in DC expands. These, or a combination of all programs, are vital to ensure that DC residents avoid the threat of eviction, but also ensure that they have the resources for stable housing, safe and resilient communities, promoting economic opportunity for communities, and provide equal access to justice. To promote and provide equal access to housing and justice, my colleagues and I improve our services to clients through monthly meetings and a listserv. My colleagues and I also share resources and brain strategies to access the initiative. Again, I'd like to thank you for allowing me this opportunity to testify and welcome any questions.
Thank you very much, Ms. Conley. I do want to note we're adding some other names to this panel that we're going to be on the next panel. So just to confirm, we'll move to Lindsay Silverberg next. But then after Catherine Arundel, we're also going to add Latifa Sutton, Candace Lewis, and Kobe Najee to this current panel. So next we'll hear from Lindsay Silverberg, Deputy Director for the Network for Victim Recovery of DC.
Thank you, Chairwoman Pinto, other committee members and staff. I am Lindsay Silverberg, Deputy Director at Network for Victim Recovery of DC. NVRDC is unique in that we support survivors of any type of victimization and do so from the philosophy of survivor-defined justice, meaning that we do not try to influence our clients into thinking what is right or wrong way to react to crime, but instead support them in how they envision justice in their specific case. OVSJG provides NVRDC with funding for several of our core programs, including free legal and advocacy support for crime victims. Additionally, OVSJG supports other innovation projects, including free crime victims' rights representation and advice through our partnership with MedStar's Community Violence Intervention Program, our youth-focused advocacy and legal services, and coordination of the district's Collaborative Training and Response for Older Victims Coalition, DC Trove. In total, in the past year, NVRDC staff served over 1,100 survivors. 75% of those were served using OVSJG funds, and more than 900 of which were new clients. OVSJG supports many of our most innovative partnerships. The Victim Legal Network of DC is a project of NVRDC and the oldest legal services network in the district. We boast 27 member organizations, and with a lean staffing model of only 2 FTEs, VLNDC manages to cut down the average intake time for multiple legal issues from over a week to just 2 days. And this is for the nearly 600 crime victims they assist in connecting to various legal aid needs each year. We continue to believe that investing in proven and formally evaluated wraparound models would be an effective way to better reach all survivors of violence and quickly connect them to the varied needed services in a trauma-informed way. We're very grateful for funding priorities like access to justice, which has helped support the work like VLN and our appellate advocacy work, making the law work for survivors of domestic and sexual violence. Last fiscal year, NVRDC took steps towards making DC a more restorative ecosystem by building capacity for local providers to offer restorative justice services to survivors and those who have caused harm. OVSJG supported some of the seed costs of this groundbreaking partnership with justice grantees like Free Minds and DC Justice Lab, among others. But this work is historically and currently underfunded to reach its full impact. And based on the limitations of that particular funding, NVRDC did not seek the support from OVSJG in FY24. And instead, it was supported by the DC's Office of the Attorney General and continues to receive funding from the Department of Justice's Office for Victims of Crime. NVRDC believes that it is our responsibility to find ways to derive federal resources into DC when existing systems are failing to solve the challenges victims face. Broadening OVSJG's federal portfolio would benefit our community, in particular culturally specific service providers. Given this, we've partnered with some of these providers on federal projects that we've received in the past 2 years to support youth services and access to restorative justice. We would welcome OVSJG's leadership in coordinating collaborations that result in more federal dollars being invested in our city. We hope that under the new leadership of OVSJG, will work to implement transparency around funding priorities and rebuild trust with grantees. As part of this, we need OVSJG to strengthen its advocacy beyond its grantees and holistically consider the issues affecting survivors in the district. As an example, each year, the Domestic Violence Coalition surveys members to gauge the most under-resourced and overtaxed services. For years, mental health therapy for survivors has been under-resourced, causing long wait lists and not enough trauma-informed therapists. Despite the clear evidence of need, OVSJG required us to reallocate funds in our FY24 budget intended to pay for part of our therapists and encourage us to work with other organizations who are already receiving these funds for mental health. Our Director of Therapeutic Services saw a 132% increase in the need from FY22 to FY23, providing over 358 sessions as a solo practitioner. We're hopeful about OVSJG's current leadership and a clear effort to enhance communication with grantees, and will continue to offer recommendations around how this office can improve its strategic support of survivors by moving towards flexible multi-year funding, streamlining and enhancing reporting processes, and leading an example of transparency around equitable pay. We appreciate your continued support and thank you for the opportunity to testify.
Thank you so much. Sarah Tenen, Executive Director of the DC Volunteer Lawyers Project.
Good afternoon. My name is Sarah Tenen, and I am the Executive Director of DC Volunteer Lawyers Project. I would like to thank the Mayor and the Council for the continued investment in services for victims and for civil legal services for low-income individuals in the district. Specifically, I want to note with gratitude, Councilmember Pinto, the significant efforts made by you and your colleagues to ensure sufficient funding for victim services and access to justice this year. Your leadership was exceptional, and we are grateful. People in the district are suffering deeply, and I know you don't need me to tell you that. As we continue to redefine our whole post-pandemic normal, investing in funding for victim services and the Access to Justice initiative continues to make a tremendous difference for domestic violence victims, immigrant survivors of gender-based violence, and at-risk children. At DC Volunteer Lawyers Project, we believe that a life free of violence and abuse is a basic human right. In 2023, DCVLP provided comprehensive legal services on almost 2,500 legal matters for domestic violence victims, immigrant survivors of gender-based violence, and children experiencing abuse, neglect, and other dangerous circumstances. Our clients come from all 8 wards of the district. We provide legal assistance and support services to domestic violence victims who are seeking civil protection orders. We also represent survivors in family court as they seek a divorce from their abuser and a custody arrangement that is safe for the survivor and her children. In our immigration cases, we provide legal assistance to immigrant survivors of gender-based violence seeking various forms of humanitarian relief. And in our child advocacy practice, we represent the best interests. We're appointed by DC Superior Court judges in the Domestic Relations Branch to represent the best interests of children experiencing abuse, neglect, and extensive trauma. So that individuals in the community can access our services, we have 10 clinics each week throughout the district. Some are virtual, but most are in person. In addition to our direct legal services, we partner with dozens of organizations and agencies, many of whom are here today, to ensure that this holistic and high-quality safety net exists in the district for those in need of support. In addition to partnering with other victim services and legal services organizations, we partner with the U.S. Attorney's Office, the Office of the Attorney General, and the Metropolitan Police Department. We partner on specific cases, and we partner on high-level trainings. We leverage every dollar that you invest in DCVLP by training and supporting volunteer lawyers. In 2023, we supported approximately 600 volunteer lawyers. They contributed 48,000 hours of free legal services valued at $18 million. Through this model, every dollar invested in DCVLP turns into $6 in free legal services for people here in our community. We receive funding from the Office of Victim Services Justice Grants to support our domestic violence program and our child advocacy program. And for the first time in FY24, also support for our immigration program. We also receive significant funding through the Access to Justice Initiative and the DC Bar Foundation to support all three of our programs. We're grateful for our longstanding relationship with OVSJG and the DC Bar Foundation. Our grant managers are wonderful thought partners for us, and we could not do our work without the support of this funding. The impact of having a lawyer is tremendous. For our clients, having a lawyer means safety, arguably the most basic human right. Having access to a lawyer means stability for the client and their children, and so very significantly, it also means breaking the cycle of violence. I hope at another time we'll have a chance to talk with you about the work we are doing regarding extreme risk protection orders and the intersection of gun violence and domestic violence, which we know are inextricably connected. It's just one more example of how legal services are a critical piece of the puzzle in ensuring a safe and healthy and thriving District of Columbia. To illustrate the important work that DCVLP does with the partnership of OVSJG and Access to Justice, I want to share Selena's story with you. In early 2023, while holding their daughter in his hands, Selena's abuser threatened her with a knife. Shortly after, she came to a DCVLP clinic seeking help with obtaining a protective order. This was not the first time that she had sought a protective order against her abuser, having experienced years of physical and emotional violence, including being stabbed by him in the past. DCVLP attorneys took Selena's case right away. Because she was deeply traumatized, her attorneys made extensive efforts to settle the case, but her abuser refused and the case went to trial. As they prepared for trial, Selena's attorneys used trauma-informed lawyering skills to make sure she would not have to relive the abuse that she endured. Her attorneys worked closely with MPD officers to use the body-worn camera footage as evidence of the offense her abuser committed against her. She was granted a 2-year protection order, and with her protective order in place, Selena is now moving forward with her attorneys to obtain permanent custody of her daughter. She and her daughter are now on a path to safety and stability. We ask that DC Council, I'm over, so I'll just say I'm here to answer any questions, and the rest of my testimony is in writing.
Thank you so much. Appreciate that. Natalia Otero, co-founder and executive director of DC Survivors and Advocates for Empowerment, or DC SAFE. Kylie Hogan, Crisis Intervention Team Director, DC Survivors and Advocates for Empowerment, DC SAFE.
Sorry about that. Thank you, Chairperson Pinto and members of the committee. My name is Kylie Hogan, and I'm the Crisis Response Team Director for DC SAFE. I'm hoping that you'll be able to hear from Natalia Otero, our Director of our executive director, a little bit later on. She's going to speak a bit to kind of our volume of referrals and the scope of agencies that we work with at DC SAFE. But I do want to highlight that since our inception of our 24/7 services, our partnerships with DC agencies, nonprofits, the courts, other community organizations has been essential to serving survivors in the district. Our approach removes the burden from survivors and having to seek out help, and instead brings help to them proactively so we can quickly and easily provide information, tangible resources, and just general needs for someone's immediate safety, as well as leveraging those partnerships and our expertise for clients as they navigate many intersecting systems. OVSJG is a major resource for DC SAFE, and we have a long history with them as a grantee. Certainly, their support contributes substantially to our ability to provide immediate and critical services to survivors in the district. But I want to add my voice to what you'll hear from Natalia later about concerns about a seeming reluctance or disregard, both financially and politically, around substantial and sustained collaborations from OVSJG. I see this directly in limited funding for administrative or system advocacy positions, which lay the groundwork in creating and sustaining relationships across service providers, work that is no less essential or beneficial to survivors despite the lack of one-on-one interactions with them. But also what I see as a pattern of active discouragement of collaboration among funded organizations. An excellent example of this is the development of the Hospital Violence Intervention Program through Project Change. This was a program created to support individuals exposed to some of the most severe violence in the community that is landing them in trauma bays or with extended hospital stays, severely escalated, life-changing violence. Despite the development of this program, there was no effort to proactively establish coordinated services between our programs. Instead, I've witnessed actual resistance to allowing the HVIC programs and staff to coordinate with DC SAFE. DC receives over 40,000 911 calls related to domestic violence a year, and we know that nationally DV accounts for about 15% of violent crime. So it's unfathomable that there would be no overlap between our programming. As further evidence, just this past week, we got a contact from OVSJG specifically about a client that was seen through HVIP and had a potential need to file an order of protection and could benefit from our expertise in the process. There was no direct referral, specific contact information shared, and the obligation was left with the victim to reach out. We've worked very hard over the years to create a streamlined, easily accessible resource for first responders and members of the community for situations just like this. But cooperation and communication seems to me at least to be actively discouraged or at least overlooked. And it's saddening to me that some of those most severely impacted by violence are not getting the same ease of access and coordinated support they deserve. Another example is from 2019 when revisions for the SABRA when revisions for SABRA came out mandating access to an advocate for sexual assault survivors reporting to MPD. We had worked closely with MVRDC for many years to support sexual assault survivors, and that was something we were interested in being part of. While we fully acknowledge that working with sexual assault survivors has its own distinct challenges and need for focused expertise, we also know that research shows that perpetrators of sexual violence are overwhelmingly someone the survivor knows, including family members, roommates, and intimate partners. In other words, interfamily relationships that are considered domestic violence by the district. We also know that sexual assault perpetrated by an intimate partner is a major indicator of increased risk for DV survivors. So we felt this was a natural fit, but we're turned down for funding and inclusion in this continuum in general. While we might have been turned down for formal inclusion or funding, that didn't, however, mean that we were not without responsibility to this population. Part of our collaboration with NVRDC over the years historically has been around crisis housing, as that was not a process that they had in place or they had funding for. The new grantee that was brought in to fulfill the SABRA requirements, DCRCC, also looked to us for housing and other immediate needs that survivors might have, such as home security or technical expertise in the civil protection order process. So while we felt obligated to ensure these survivors were served and supported with essential needs such as emergency shelter, we weren't considered part of the continuum. And in fact, we were told explicitly that we were not to interact with the continuum of care and that these things were entirely separate. This is not the reality on the ground for those of us doing the work, and we have continued to receive calls and house clients in this continuum. Serving victims of domestic violence is incredibly challenging work, and indeed providing community support for crime victims as a whole is an immense undertaking. Safety and success takes a village. Best practices bring us coalition review boards and other chances at collaboration to ensure that services are
Sorry to interrupt. You're a bit over time. I'm going to ask.
Okay, sorry. I'm happy to take any questions that you may have, and thank you for the opportunity to speak today.
Thank you so much. Catherine Arndell, Interim Associate Director, Community Housing Programs at District Alliance for Safe Housing.
Chairperson Pinto and members of the committee, thank you for the opportunity to testify. My name is Catherine Arndell, and I am the Interim Associate Director for Community Housing Programs at the District Alliance for Safe Housing, also known as DASH. Thank you to the committee, Mayor, and Director Porter for your ongoing support for survivors. as the largest dedicated safe housing provider for survivors and their children in the district, Dash safely housed and prevented housing instability for 222 individuals in FY23, including 69 adults and 54 children in our OVSJG funded housing programs, Cornerstone and Empowerment Project. I oversee the Empowerment Project, which is our scattered site transitional housing program that places survivors in housing solutions within the community. The Empowerment Project, or EP, gives many their first opportunity to establish a housing history by having their name on the lease out of the control of their abuser. Congregate shelter and communal living can be a substantial challenge for some. Scatter site programs like EP give survivors opportunities to live safely and with autonomy over their own lives. By partnering with OVSJG, other victim service grantees, and the district's full continuum of care, we provide resources and stability to survivors and meet a range of needs that any one organization would struggle to meet on its own. I want to share a story about a survivor I will call Joy, a story about partnership with our social service community and the importance of OVSJG funding. Joy is an immigrant with a disability and a school-aged daughter who fled from domestic violence into shelter. Joy's daughter was attending a private school and they fell behind on tuition. After Joy entered the Empowerment Project, she partnered with her Dash coach, the OVSJG funded language access line, and other community partners to ensure Joy's daughter could continue her education in the school community that supported her. Through OVSJG funding, Dash, and the full continuum of care, Joy and her daughter are building a better life in the community. OVSJG funding is critical to the stability of community-based organizations. Dash relies on the funding we receive to provide life-saving services. Funding delays like we saw in the transition to the district's new payment system at the end of FY23 undercut the well-being of both staff and survivors. Scatter site housing programs are partnerships with community landlords. When rent is late, because of district system delays, landlords become less willing to continue those partnerships, placing survivors at risk. In our FY25 budget request, we joined the other member agencies of the DC Victims Assistance Network, or VAN, in urging you to provide $73.4 million for victim services through OVSJG, funding for $21.53 million for new and expanded programming. With funds for expanded programming, victim services providers will be able to increase access to legal language services and bring on new victim services housing opportunities. Our sincere thank you to Chairperson Pinto and the entire committee, Director Porter and Mayor Bowser for your support of victim services. We call on you once more to boldly lead the charge with continued funding for domestic violence housing services. Thank you for the opportunity to testify.
Thank you very much. Latifa Sutton, Associate Director, Residential Programs, District Alliance for Safe Housing.
Chairperson Pinto and members of the committee, thank you for the opportunity to testify. My name is Latifa Sutton, and I am the Associate Director for Residential Programs at Dash. I am also a DC native and currently a Ward 5 resident. I join my colleague Catherine in expressing our sincere appreciation to this committee, Mayor Bowser, and Director Porter for your ongoing support of the domestic violence community. Thank you for your partnership as we work to provide the district's most vulnerable. I want to begin by introducing both myself and Dash Cornerstone's housing program. Before I came to work with Dash, my goal was to find a place that aligns services and policies in a way that meets survivors where they are and partners with them to secure available resources without making them jump through hoops. By providing up to 2 years of housing and wraparound supports, our programs give everyone a foundation to survive from which to grow and build skills of independent and empowered individuals. I would like to share a story of a survivor who I may call Miss Quinn. Miss Quinn was fleeing from a life-threatening situation in a Midwestern state. She made it to the district, but did not have a network and had very few resources. She was sleeping in her car parking lots a lot, relying on out-of-state friends to send funds for brief hotel stays. When Miss Quinn finally connected to Dash, I spoke with her on the phone to assess if Cornerstone would fit her needs and helped her create a safety plan. Through her tears, she told me, I just need a few months to get myself together. I was honored to be able to reassure her and tell her that she would have years to get acclimated and process the trauma she had been through. After Ms. Quinn moved into Cornerstone, she arranged job interviews within her first week and secured employment within 30 days. In less than 6 months, Ms. Quinn moved out into her own apartment, securing the foundation that Dash and OVSJG's funding had helped her rebuild. Survivors and families are welcome at Cornerstone with a furnished apartment of their own for up to 2 years at no cost. As needed, Dash supports the residents of Cornerstone with groceries and safe travels to interviews, appointments, and work. Throughout their stay, survivors receive tailored support from Dash's on-site resident coaches who help them plan for the future and meet their own identified goals. Thanks to the funding from OVSJG, this support leads to outstanding successes. In our first quarter of this fiscal year, we had 3 survivors exit Cornerstone into their own homes, not other shelter programs. But when funding and payments from OVSJG and other city funders are delayed, that can seriously damage survivors' journey to autonomy. While 3 residents were able to move from Cornerstone in the first quarter, 2 others had their progress installed by payment delays caused by issues with the district's new payment system, including a survivor who had a housing voucher in hand and was ready to move out. The limitation on our resources leads to the inability, to provide services to our clients, the majority of whom are women and children of color. We urge the council and Mayor Bowser to invest in survivors so we can partner to protect the district's most vulnerable. Thank you again for the opportunity to testify, and I'm happy to answer any questions.
Thank you very much. Candace Lewis, Senior Director Programs, District Alliance for Safe Housing. And I'll ask again that folks try to monitor their time.
Absolutely. Thank you. Chairperson Pinto, and members of the committee, thank you for the opportunity to testify. My name is Candace Lewis, and I'm the Senior Director of Programs at DASH. I join my colleagues in expressing our sincere appreciation to this committee, Mayor Bowser, and Director Porter. Through your partnership, we deliver life-saving services to some of the most vulnerable members of this community. In FY23, DASH received time-limited ARPA dollars to support holistic programming and activities for survivors, including trauma-sensitive art therapy, workshops on physical and mental well-being for survivors and families, and regular communal activities such as yoga and walking groups. Participants have told us that they feel seen, they feel supported, and by having access to these resources, including having the opportunity to connect with other survivors, affirming that they are not alone in their journey of healing. In addition to funding DASH's holistic services, I'll applaud OVSJG for recognizing the vital need for flexible funding for victims and services of domestic violence. In FY23, we funded, with OVSJG and other sources, DASH supported 38 individuals, including 16 children, with our Safe Night Fund, 100% of whom transitioned to long-term housings following their hotel stay. Additionally, 41 survivors received financial assistance through our Survivor Resilience Fund. This flexible financial support assisted survivors to protect themselves, maintain access to employment, and become or remain housed. In one case, the survivor's abuser had damaged their car, preventing them from getting back and forth to work or taking care of their child. With funding from OVSJG, we supported the survivor in repairing the car so that they could maintain their employment and housing, helping them avoid having to go into shelter. In many cases, survivors requested support with getting security cameras for their homes as part of their safety plan. While we greatly appreciate that OVSJG has come to understand that the city's existing security camera resources creates challenges that are not appropriately responsive to the urgent life safety issues involved in many domestic and sexual violence cases. This year, it has been so important that OVSJG understood that the work that DASH and other victim service agencies do is not duplicative of other city resources, because the functionality and accessibility of these programs are key determining factors for survivors. Just as we call on the district agencies to commit to genuine partnership in the daily work of service provision, we also call on mayor and council to recognize when there are budget cuts or decrease in funding, it hits organizations led and serving people of color harder than any other organization, and to commit to funding the true cost of providing these services in FY25 and beyond. In our FY25 budget requests, we join with the other VAN members in urging you to provide $73.4 million for victim services through OVSJG. Our sincere thanks goes out to Chairperson Pinto and the entire committee, Mayor Bowser and Director Porter for your current support of preserving affordable housing for our communities most vulnerable. Thank you, Chairperson Pinto, for helping to ensure that every district resident has access to safe and secure housing, free from the threat of abuse, and to the city for elevating protecting survivors and victims of domestic and sexual violence as a top priority. Thank you again for the opportunity to provide this testimony. We are all happy to answer any questions that you may have. Thank you.
Thank you so much. Kobe Gage, President and CEO of District Alliance for Safe Housing.
Chair Pinto and committee members, thank you so much for the opportunity to testify. My name is Kuben Gaje, and I'm the president and CEO at DASH. Our sincere thanks to this committee, Mayor Bowser, Director Porter, and the entire OVSJG team for your leadership and ongoing support of the victim services community. We are proud to do this work alongside each of you. DASH's mission is to be an innovator in providing access to safe housing and wraparound services to survivors of domestic and sexual violence. We hold leadership seats on the DC Coalition Against Domestic Violence and Domestic Violence Housing Continuum and serve on the DC Victims Assistance Network and the DC Access to Justice Commission. I am focusing my time today on the forward-facing successes we can have partnering to protect the district's most vulnerable and the importance of transparency and collaboration to do this life-saving work. In addition to the impact you've heard about, and as we look forward to fiscal 25, I call on the district to engage in the spirit of true partnership that honors the work and expertise of Black and Brown leaders in community-based service organizations who are constantly called upon and asked to do more with less, leading to significant burnout and pushing many leaders of color to leave the sector entirely. Partnership requires transparency in communication, honesty and dialogue, not unilateral action. When OVSJG released the fiscal 24 grant awards, as you've heard, grantees noted that the agency had inserted a new termination clause without notice or discussion, stating that the agency could terminate grant agreements without cause and with only 30 days of written notice. When we objected as grantees, the agency informed us that no revision or negotiation would be permitted. These terms put survivors and the organizations that we support at risk, contradicting the fundamental principle of true partnership. DASH and other grantees repeatedly requested a formal explanation of why this clause had been included and on what legal basis the city was taking this position. For 4 months, agency representatives, including Director Porter, spoke about the standardization and general contracting rules, but unfortunately, no formal confirmation came. That is not true partnership. In the end, Director Porter did send a formal statement 13 days ago, confirming that the change was to bring all OVSJG grant agreements in line with standard district practice, that adding this clause was meant to clarify the notification process, and lastly, that the grant agreements were being updated with district regulation in mind, including DCMR 273700. We respectfully disagree with OVSJG's stance that DCMR 273700 applies, as our grant awards are managed as grants and not contract procurements. No other grant that DASH has ever received from any district agency has included a no-cost termination. A 30-day notification period is insufficient to support clients with safe and effective transition into other programs. And further, previous termination clauses that have been used in the district have very clearly outlined notification procedures, which are missing in DCMR 3700. Finally, this statute does not allow for the termination without cause. We join our fellow OVSJG grantees in expressing deep and continued concern. We cannot plan annual budgets, hire and retain dedicated staff, or provide quality services when mid-year funding cuts, as was the case last year with mid-year budget sweeps in OVSJG's budget lines, can be made with little notice and no reason. knowing that funding decreases and cuts disproportionately impact marginalized communities and organizations led by people of color. Such uncertainty destabilizes organizations and diverts our focus from providing the life-saving services that our survivors and the district deserve. We ask Council to take immediate action to have the clause removed or nullified from all OVSJG grant agreements. Further, we call on Mayor and Council to recognize that the constant fight to ensure sufficient funding is taking a profound toll on our leaders of color in the sector. As part of protecting the institutional stability of services for survivors of domestic and sexual violence in fiscal 25, we ask Mayor and Council to commit to setting a baseline of funding for victim services. Our collective successes require ongoing and renewed dedication to ensure that all systems of care and the systems of care we have built can be maintained. I join my DASH colleagues, the DC Coalition Against Domestic Violence, the Fair Budget Coalition, and 70 victim service providers of the VAN in urging you to provide $73.4 million for victim services through OVSJG. We further ask for a 25% increase in fiscal 24 funding levels for all district agency budgets that serve victim services, including DHS. Thank you again, Chairperson Pinto and Committee, Mayor Bowser, Director Porter, and OVSJG for your continued support and the opportunity to provide this testimony. I'm happy to answer any questions you may have.
Thank you very much. I want to recognize Natalia Otero has joined us, so we'll turn to you for your testimony and then we'll have some questions for this panel. And we've also been joined by our at-large council member, Christina Henderson, who's also a member of the committee. And so council member, we'll turn to you if you have any statement or questions for this panel in a few moments. Ms. Otero?
Hi, I'm sorry. I had a bit of a technical difficulty. Thank you so much, Chairman Pinto and distinguished members of the committee. My name is Natalia Otero, and I'm the co-founder of DC Safe. We are the largest entry point for all acute domestic violence incidents. We served 12,328 families last year, with our bilingual crisis response line receiving approximately 17,000 unique referrals from first responders citywide. As a 24/7 crisis intervention agency, our services are deeply integrated with the city's public safety infrastructure. As appreciative as we are of their ongoing support and shared commitment to public safety, I must address a few recent challenges with our partnership that we face with OVSJG. I was going to discuss the no-cost termination clause, but I will say that my colleague Kube wrapped it up very nicely. So I will focus my testimony on our serious concerns around OVSJG's overall compliance with the Transparency Act of 2022. Upholding the spirit and letter of this legislation is tremendously important and crucial to our community. Ideally, we envision the information mandated by the Transparency Act to be detailed in the OVSJG section of the city budget, explicitly covering previously muddied areas such as OVSJG's multi-year strategic plan, the fiscal risk rating determination process, the grant application review process, and the utilization of collected data. If the promise of an expedited application process, the compliance with the Nonprofit Fair Compensation Act of 2020, and at least a one-year strategic plan were implemented in FY25, we would be more confident in the prospect of change. With that said, even if OVSJG fully and immediately complied with all these requests tomorrow, I have reservations about their effectiveness in the current political climate. My team and I, who you've already heard from, Kylie Hogan, have observed a troubling shift in government ideology, shifting away from the coordinated community response towards strict government ownership and a top-down approach. For instance, we've observed direct interference with continuums of care, with the city insisting on siloing issues of sexual assault, domestic violence, community violence, and human trafficking. We should all be working collaboratively, but instead, OVSJG's participation in the construction and implementation of these systems have created boundaries that harm survivors. As I say this, I do want to give credit where credit is due, and Director Porter has been amenable and open to information and criticism. However, she does have an unfortunately large hill to climb. One stark example of the lack of effectiveness in the creation and sustained support of its mandates and investments is the Domestic Violence Systems Review Team that we manage in collaboration with OVSJG. For the purposes of time, and because I testified about this extensively last year, the remainder of my testimony will be provided in writing. Thank you so much for having me, and I am here to answer any questions you may have.
Thank you so much, Ms. Otero, and thank you to all of you on this panel. I do want to ask you, Ms. Gage, about your specific experiences and conversations with OVSJG about this no cause termination clause. This is something we're certainly going to get into with the director this afternoon. And from the perspective of performance oversight, which is today's topic, it would be helpful to the committee to hear specifically how that information was communicated to you and what those conversations looked like around getting this clause removed.
Thank you, Chairperson Pinto, and happy to share Dash's experience. And first and foremost, just want to give Director Porter and the OVSJG team their due. While we didn't get the responses we were seeking, I will say, as my colleague Natalia mentioned, that they were amenable to having conversations. Specifically to the grant termination language, Dash, along with all OVSJG grantees, were not aware of this new clause being included in our grants. We identified it during the review process of our grant agreements and reached out to Director Porter at the very beginning, and we had ongoing email conversations with Director Porter between October 10th and October 23rd. Went on record providing a memo to our grant file, that objecting unilaterally to the inclusion of the termination clause, and also very clearly stating our objections and the reason why we were objecting. We requested formal and written confirmation from OVSJG starting in October. As an organization, but also from the VAN perspective, the full VAN, the VAN Policy and Advisory Committee made a request to Director Porter and the agency asking for the reason for this no clause termination. And that went on for 4 months, and nothing, we didn't receive the formal results from Director Porter until a couple of days ago, earlier in January. And so for Dash, we requested that our explicit objection to the clause be filed on memo with our grant agreement files, so that should anything happen, we had that to go back to. And something that is particularly of concern is just knowing that last year during the budget oversight process, there was a significant amount of dollars that was swept away from OVSJG's budget. We could never get a very clear answer as a community about what happened. Somehow the funds were restored, but with this clause in place, what we are concerned about is really to make sure that if something like that happens again, Dash and many other organizations who do this life-saving work are not in a position of having to have the grants turned away and canceled with no notice, and certainly with no cause.
Thank you very much for that. Appreciate that additional context for the record. I want to turn to my colleague, Councilmember Christina Henderson, if you have any statement or questions for this panel. I have just dropped off. One moment. Okay, thank you all very much, again, for your testimony today and for your crucial work throughout the year. Really appreciate you all being here.
Thank you.
We are going to call our next panel of public witnesses, likely our last panel of public witnesses today. Kathy Zeisel, Stephanie McGill, Gabrielle Majewski, Witness A, Michelle Cole, Jocelyn Jacoby, Tina Front, Melissa Millar, Elizabeth Davis, Penelope Spain, Christina Jackson, Indira Hennard, Jody Ovka, and Santos Amaya. It's a reminder to accept the invitation to join as a panelist. Okay. Kathy Zeisel, are you here? All right, we will start with witness A, public witness.
Thank you so much. Thank you for giving me this opportunity. I'm a domestic violence survivor and a member of the Survivor Advisory Board of DC Coalition Against Domestic Violence. I want more support for programs like the Survivor Advisory Board. When I joined the board, my mind was still clouded by what my abuser forced me to believe. He was excellent at convincing me he was the victim who was unwillingly correcting me because I was wrong. It was as if when you see gray in a pitch dark, it looks like white. The abuse was covered, disguised by his logic. I was always walking on eggshells, trying to read his face and find how to behave in a way that best pleased him. My thoughts overrode my natural feelings and instincts. I lost my voice, and I feel like I lost my identity. The Survivor Advisory Board works toward a common cause and a way to heal. Being a board member helped me grow in two profound ways. First, it turns me into an advocate out of the victim. Yes, I became a victim, but when I talk about my experience in the board, it is not for me as a victim, but for others as an advocate. All our members are the same. We never want anyone to go through what we have been through, and we want anyone to heal much faster and more profoundly than we have. Second, I find my voice. Before I joined the board, I never imagined myself talking here. I didn't like public speaking, but here I am voluntarily doing this. Speaking for others empowers me. Other board members grew in their own ways. Our growth has a ripple effect throughout the community and our society. Doing for the betterment for others creates a shift in me. The shift turns my wound into a seed of changing for the better. It is a genuine liberation from abuse to me, thriving from just surviving after abuse. Opportunities like this program benefit not only survivors, but society as a whole. I want more support for programs like the Survivor Advisory Board of DCCADV. Thank you so much for giving me this opportunity.
Thank you very much. Thank you for your bravery to testify today. Appreciate you sharing your story. We will turn to Kathy Zeisel, Director of Special Legal Projects, Children's Law Center.
Thank you, and good afternoon, Chairperson Pinto. My name is Kathy Zeisel. I'm a Ward 7 resident and the Director of Special Legal Projects at Children's Law Center. I'm also a Commissioner on the Access to Justice Commission. Children's Law Center believes every child should grow up with a strong foundation of family, health, and education, and live in a world free from poverty, trauma, racism, and other forms of oppression. Our more than 100 staff, together with DC children and families, community partners, and pro bono attorneys, use the law to solve children's urgent problems today and improve the systems that will affect their lives tomorrow. Since our founding in 1996, we've reached more than 50,000 children and families directly and multiplied our impact by advocating for citywide solutions that benefit hundreds of thousands more. Thank you for giving me the opportunity to provide testimony today to highlight the significant impact of the funding that OVSJG gives through the DC Bar Foundation. First, I want to thank the council for continuing level funding last year, because that funding is the cornerstone of legal services in DC. Without it, many residents would be without lawyers in critical, life-changing cases. And that funding protects access to lawyers for non-native English speakers through the Community Legal Interpreter Bank, and by making sure that lawyers can continue to practice law through the Loan Repayment Assistance Program. Children's Law Center has been the recipient for many years of the Access to Justice Grant, and for the first time last year received CLCPP funds as well. At Children's Law Center, the Access to Justice Grant funds part of our medical legal partnership, an innovative collaboration that puts attorneys in community pediatric primary care locations with Children's National, Unity Healthcare, and Mary Center. Last year, just through our medical legal partnership, we received over 1,300 new referrals and opened 500 cases, with over 50% of our clients coming from wards 7 and 8. We also use these grants to train our medical partners, parents and caregivers, and community members. I want to share some examples of how our work specifically helps DC residents by accessing lawyers. Through our ATJ work, we often help children referred to us by doctors when they're not receiving the supports they need in school. In one case, we worked with Miss Jeffries after her daughter Marina was diagnosed with post-concussion syndrome after an assault at school, but her school did not give her the necessary accommodations. She feared for her safety, which exacerbated her anxiety and depression, and she suffered from severe migraines after her concussion. She went from being an honor roll student to not being able to go to school. Although her mother was fighting for her, it was not until a Children's Law Center advocate stood alongside her mother that they were able to get an appropriate plan in place, and now Marina's back on track to graduate. The ATJ grant funds also provide attorneys to represent children and families in complex custody cases. We worked with pro bono attorneys to help Ms. Robertson obtain custody of her niece and nephew after her sister passed away, and we continue to support the family with other legal needs that have arisen. Our CLCPP funds allow us to advocate for families whose health is being impacted by the housing conditions they live in. Most often when the landlord's failure to report mold or properly exterminate for mice, rats, and roaches leads to a child's asthma being exacerbated in the home, and they end up in the emergency room or hospitalized. Just last week, a client shared their happy news. She found a healthier home in an interview with ABC News. We met her last summer after she'd already spent 3 years fighting the Housing Authority for healthy housing. We pursued a housing and conditions case and pressured DCHA to look at other options, and she was finally able to secure healthier housing. We also use the data we get from our cases to understand how to serve our clients better. We've worked with Children's National to map where children with asthma live in DC and where the unhealthy housing conditions are, and we use that data to drive our work. Through our evaluation and learning team, we know that we've worked with AmeriHealth to know that getting remediation done in homes stops children from going to the emergency room, and it saves Medicaid money. We know that stabilizing children with permanent homes and getting them the education they need has long-term positive effects for them and long-term cost savings for DC. We do all of this work because the DC Bar Foundation, using the money provided through OVSJG from the council, sees the value in our work and understands how we help DC families access justice. And we are just one program funded by DC Bar Foundation, working to help DC residents access justice in a myriad of ways. All this is to say that the money that the council provides to the DC Bar Foundation through the Office of Victim Services and Justice grants is critically important. It changes the lives of the residents of DC for the better. And as a grantee, we thank the council for their work, and we thank OVSJG for the work that they do to ensure that we can all have this funding and help the DC residents access justice. Thank you.
Thank you very much. Stephanie McGill, founder of the Soul Train. Gabrielle Majewski, Public Executive Director of DC Affordable Law Firm.
Good afternoon, Chairwoman Pinto and committee members. My name is Gabby Molnick-Majewski. I am a proud Ward 5 resident, and it's my privilege to serve as the Executive Director of DC Affordable Law Firm. Every day, we help DC residents from low and modest income households facing potentially life-changing civil legal problems. We are incredibly grateful for the Council's longstanding support of civil access to justice in the district, and specifically the Access to Justice program. At DC Affordable Law Firm, we believe everyone deserves justice and that income should never be a barrier to an individual or a family's receipt of high-quality legal representation. DCALF is an Access to Justice organization providing free and low-cost legal services to hardworking, modest, and lower-income DC residents, those who fall into the forgotten middle in civil legal services, and others for whom legal representation would otherwise be out of reach. Our vision is twofold: to eliminate inequities in DC's civil legal system while launching the careers of the next generation of public interest attorneys committed to accessible justice. Each year, we serve upwards of 450 DC residents in more than 600 legal matters and have served more than 1,800 hardworking Washingtonians since DCALF's inception in 2015. Access to justice funding has been indispensable in enabling DC Affordable Law Firm to transform our legal services delivery model and now provide free family law, probate, and estate planning and immigration legal services to underpaid, modest, and lower-income DC workers. Our clients are individuals working in essential, low-paying industries as retail employees, housekeepers, professional caregivers, and DC public school staff. The majority of clients across all of our practice areas are hardworking single parents who are the heads of their household and individuals who have fixed incomes and fixed budgets. Though DCALF was originally designed to derive fees from the clients for our services, the reality is that 98% of the clients we serve live in households that are considered low income or lower based on median family income and the disproportionately high costs of living in our fair city. Since 2022, Access to Justice funding has enabled us to embrace a new approach that honors and acknowledges the fixed and finite economic realities experienced by our client base. We are now able to serve more than 98% of our clients for free through OVSJG funded representation. And this, I would submit, is an investment in the hardworking DC residents who make our city great, putting them on better footing to secure justice for themselves and their families. Our services span many practice areas, all of which advance economic security for the primarily Black and Brown families we serve, narrowing racial and gender wealth gaps that pervade our society. Our family law work advances economic security as we work hard on child support, alimony, distribution of property, and securing the custodial rights to children that protect their best interests. It is also well known that the passage of intergenerational wealth, even of modest assets, hinges on effective planning, and modest and lower income Black and Brown residents deserve to plan for their futures and subsequent generations through critical legal avenues. And as we focus on transfer of deaths in our probate practice, we are helping to protect current and future generations and solidifying the base of homeowners in the district who can remain homeowners living in DC. We have experienced tremendous increases in demand for representation across all of our practice areas. From 2019 to 2023, we saw a 238% increase in the family matters handled by our organization in a given year. Our probate practice has grown by 330% since 2019, and in 2023 alone, we delivered close to 4,000 hours of direct legal services representation to immigrants who have chosen to make DC their home. The work that we are doing is tremendously important, and DC residents are increasingly turning to legal services providers for assistance because the laws and the circumstances families are facing are simply too complicated for individuals to manage on their own. I would submit as well that the innovation we have embraced as a community has been transformative in bridging gaps for litigants by creating new systems such as single stream intake, rapid response services, to pair litigants with lawyers at points before their issues become that much more critical. We are energized by the efforts to create coordinated intake and referral in the district, a new program spearheaded by the DC Bar Foundation. And we appreciate and look forward to and hope for continued access to funding access to justice funding at current levels to enable organizations like DCALF to be able to meet the needs within our community for the long haul and help our community members thrive. Thank you very much for for the opportunity to testify, and I look forward to any questions you may have.
Thank you so much, Ms. Mayeski. Michelle Booth Cole, Executive Director of Safe Shores, the DC Children's Advocacy Center.
Can you hear me? If I can't see anything on this screen. Okay. Chairwoman Pinto and other members of the committee, my name is Michelle Booth Cole, and I serve as Executive Director of Safe Shores, the District of Columbia Children's Advocacy Center, a nonprofit organization known as the CAC. I appreciate this opportunity to elevate children's needs and urge every adult in DC to prioritize caring for our youngest and most vulnerable residents. As the Children's Advocacy Center for DC, Safe Shores helps the District of Columbia implement 2 critical laws impacting young victims of crime. We serve approximately 1,200 children and families each year. The first law, DC Code 4-1301.51, requires that child sexual abuse cases be investigated by a multidisciplinary team. Safe Shores coordinates the work of that multidisciplinary team, which includes the Metropolitan Police Department, Child and Family Services Agency, the Office of the Attorney General for the District of Columbia, the U.S. Attorney's Office for the District of Columbia, and the Child and Adolescent Protection Center of Children's Hospital. The work of the Child Advocacy Center and the MDT is critical because 1 in 10 children in the United States will be sexually abused by the time they turn 18. Child sexual abuse is a highly prevalent crime, and yet it's also an underreported crime. The second DC law Safe Shores helps implement is the Sexual Assault and Victims' Rights Amendment Act of 2019, or SAVRA 2019. Among other things, this law requires that victims of sexual assault, ages 13 to 17, be provided with a victim advocate who specializes in working with adolescents. Safe Shores sexual assault youth victim advocates help young victims know their rights and support them through all that can happen in the wake of a sexual assault. I'm with you today because Safe Shores work is made possible in significant part by annual grants through OVSJG. We are fortunate to have capable and dedicated program managers from that office who share our unwavering commitment to supporting young victims of crime in the unique ways that children need. I'll note here that Safe Shores must apply annually for grants to support our services, even though these services are required by law. So let me underscore how helpful it would be for OVSJG to fund multi-year grants for victim-serving organizations, because our services are ongoing and essential for DC residents. While there's much more I could share today about Safe Shores and the scourge of child abuse, I want to use my remaining time to urge adults to prioritize children. Research suggests that most human brains take about 25 years to develop, though these rates can vary. Although the human brain matures in size during adolescence, essential developments within the prefrontal cortex and other regions still take place well into one's 20s. These findings raise complex ethical questions about the way our criminal legal system punishes people in their teens. At the DC Children's Advocacy Center, we center the needs of children in the midst of investigations of abuse. We understand the science of human development and apply it to our work aiding child victims of crime and their families. The fundamental reason adults must prioritize the care and safety of children is that children cannot do it for themselves. It's that simple. They are not developmentally capable of protecting themselves. Unless we prioritize children in our budgets, in our policies, in our daily lives, we will continue to see more of what we're seeing in our streets and our neighborhoods and in the news. We will see children who have not and are not being properly cared for, desperately trying to meet their own needs. Effectively, these children are doing the work of adults. And as we know, children are not equipped mentally or emotionally to carry the burden of adult responsibility and should not have to. In the paraphrased words of Frederick Douglass, it's easier to build strong children than repair broken men and women, and for the record, non-binary folk. Building strong children means keeping them safe and protecting them from abuse, making sure they have enough of all the things they need to grow into healthy adults, from nutritious food to providing them and their families with safe places to live, play, learn, and explore, building their bodies, hearts, and minds with exposure to sports, science, and art, helping and inspiring them to learn and love learning. And finally, accepting them for who they are and letting children know we see them and we know they are worthy and they matter. In closing, I invite committee members and others to learn more about our work by coming to visit and tour the CAC, sign up for trainings to prevent child abuse, and just even the public visit our website so you can see what we do for children and access our services. DC's children desperately need grown-ups to stand on business in the current vernacular. And my 19-year-old approved my using this phrase. Standing on business for children means adults must meet our individual and collective responsibilities to ensure that every child in DC makes it to adulthood, is equipped for adulthood, and is ready to build the next generation of strong people. Thank you for your attention. I'd be pleased to answer any questions you might have.
Thank you very much. Jocelyn Jacoby, Program Director and Psychotherapist, the DC LGBTQ+ Community Center.
Good day, Chairperson Pinto and members of the committee. Thank you for the opportunity to testify today. My name is Jocelyn Jacoby, pronouns she, her, and I serve as the Program Director and Psychotherapist at the DC LGBTQ+ Community Center, overseeing our behavioral health and anti-violence project programs. I am also a proud resident of Washington, D.C. and live in Ward 1. The center is currently located on the border of Ward 1 and 2, but we are embarking upon a new chapter in creating a new home in Ward 2 by the Howard Theater. This new LGBTQ+ community center will be a game-changing and monumental resource in Washington, D.C. We will be able to expand our current life and human services, as well as be co-housed with several other impactful community-based organizations and services providers. We need the Council's continued financial investment in our community to continue making the new LGBTQ+ Community Center a reality. The center is a member of the DC LGBTQ+ Budget Coalition, and we are calling for continued funding and dedicated resources for our community, and more specifically for our Black and Brown trans, gender nonconforming community, and those struggling with low or no income. The DC Anti-Violence Project was funded by OVSJG for $298,000 for fiscal year 2023. I want to sincerely thank the Council for their support, which allows us to address the health and safety needs of the LGBTQ community in Washington, D.C. One program funded through this grant is free short-term trauma-informed therapy for LGBTQ+ survivors of violence, abuse, or trauma. In fiscal year 2023, 69 clients were served through 992 individual and group sessions. Over half of these survivors were people of color, and 85% disclosed surviving bullying, 68% emotional and verbal abuse, 57% hate or bias crimes, 48% intimate partner violence, 46% sexual assault and harassment, and 40% disclosed surviving childhood abuse. While it is not a criterion for services, many of our clients have low or no income, including people who are currently experiencing homelessness or living in dangerous environments. We have actively suicidal clients in desperate need of ongoing support. We currently have just 2 clinicians to meet an ever-growing need and often run a wait list. The anti-violence program helped an additional 184 individuals by phone, email, walk-in case management, warm handoffs, and crisis intervention. We also host monthly community and advocacy meetings, run weekly wellness programs, and work with community organizations to build partnerships and train others on working with this population. The need for a full-time caseworker advocate has been established by surpassing our annual goal for client referrals multiple years in a row. The funding for fiscal year 2024 did not meet our need for a full-time salary. We're in the process of hiring a part-time caseworker advocate, and we continue to ask for more funding to provide more individuals with the dedicated case coordination they need. The people we serve have provided invaluable feedback. I want to share a few excerpts, but for full quotes, please refer to my written testimony. One client described the difficulty of finding any support during their crisis, which led them to feel isolated and hopeless. They said, "When I came across the DC Center, I immediately felt seen, safe, and at home. Finding the center has been a true blessing in my life, and I wish for all people in the LGBTQ plus community to have this kind of invaluable support. Another client said, "The services at the DC Center gave me a new life. I wouldn't have gotten the help I needed if I had to pay out of pocket. I am so grateful." A client from our therapy group shared, "I'm really thankful to have found a space that is so gender affirming. In non-LGBTQ plus specific survivor spaces, I nearly always experience some form of transphobia. That's why we need groups dedicated to serving trans and gender nonconforming populations so that we aren't further harmed in an environment where we're trying to heal." When asked what might be the consequences had they not been able to receive services at the center, clients answered with homelessness, substance use relapse, incarceration, continuing to be in abusive and unsafe relationships, and even suicide and death. These are quick anecdotes that show the impact that the DC Anti-Violence Project has been able to have thanks to the support from OVSJG. Our community is resilient, but we rely on the continued and strengthened investment from the Council to continue to heal and thrive. Thank you for the chance to testify, and I'm happy to answer any questions.
Thank you. Tina Front, founder, Courtney's House. Okay. Melissa Millar, policy director, SEDEC DC.
Good afternoon, Chairperson Pinto and members and staff of the Committee on the Judiciary and Public Safety. My name is Melissa Millar, and I'm the Policy Director for ZEDEC DC and a Ward 7 homeowner. ZEDEC DC is an independent public interest law center headquartered at the UDC David A. Clark School of Law in Ward 3, with a second location in Ward 8. Our mission is to safeguard the legal rights and financial health of DC residents with low incomes dealing with the often devastating consequences of abusive debt collection practices and other consumer-related issues. We offer direct legal and financial counseling services at no cost to DC residents within 400% of federal poverty guidelines. We engage with a broad range of coalition partners in advocating for systemic reforms that will advance racial equity, expand access to justice, and broaden economic opportunities as unpaid debt reported to credit reporting agencies dramatically and disproportionately impacts residents of color, causing harm to their abilities to rent an apartment, secure a mortgage, get a loan, or even get a job. ZEDEC DC receives funding from the Office of Victim Services and Justice Grants, or OVSJG, via the DC Bar Foundation through the Access to Justice Initiative and directly from OVSJG to support victims of crime. The Access to Justice Initiative funds two critical ZEDEC DC projects, the Debt-Related Legal Services Project and the Disabilities Community Project. This work includes helping people address their medical debt, credit report issues, residents who have been harmed by abusive and illegal debt collection practices, and residents with disabilities with their debt-related legal issues. Our annual goals directly with OVSJG include provision of high-quality legal services to victims of economic exploitation and fraud in DC, raising awareness of these issues and the availability of legal services, and helping increase allied service organizations and pro bono attorney capacity to detect, document, and deter economic exploitation and fraud. To that end, we note for the committee an upcoming FY25 budget ask from advocates for OVSJG legal services of $1.925 million, which would provide legal services for an additional 685 survivors of domestic violence, and a budget ask for the Access to Justice Initiative of $31.7 million, of which $20.35 million is for Access to Justice grants specifically. Without these critical funds, DC residents would be vulnerable to abusive debt collectors, credit report mistakes, financial crime and exploitation, and could imperil the life-changing services provided by a variety of legal service organizations, the initiative funds that district residents with low incomes rely on for their safety, health, housing, and economic stability. We are grateful for the strong support from the DC Bar Foundation, the DC Access to Justice Commission, the leadership of the DC courts, the DC Legal Services Consortium, OVSJG, and especially our grants manager, and numerous stakeholders and community members who have been such strong voices for both access to justice in DC and support for victims of crime and exploitation, as has this committee and the full council. We'd like to highlight our work with OVSJG and the Access to Justice Initiative's positive impact on consumer justice for DC residents. To that end, in FY23, 2023 and 24 to date, we've served hundreds of DC residents with their legal needs, resulting in savings of over $463,000. We've provided financial counseling services to over 110 new individuals and launched our Young Adult Financial Empowerment Program. This is a pilot program open to DC residents over 18 years of age in partnership with a community-focused investment firm called Stackwell, providing financial education workshops aimed at the specific needs of young adults, such as budgeting, managing debt, building credit, and investing, and providing each eligible participant $100 in grant funding to start investing on Stackwell's platform. We've also provided 25 presentations to 364 attendees, 11 training opportunities to more than 200 attendees, participated in outreach and education events reaching almost 10,000 residents, provided Know Your Rights flyers, created toolkits for allied service providers, and obtained multiple impressions of our work via social media. OVSJG funds, particularly through the Access to Justice initiative, enables us to support clients, including clients like Ms. N, a survivor of domestic violence experiencing homelessness, who sought our help to understand several unfamiliar accounts and debts discovered upon leaving an ex-boyfriend. We pulled credit reports to identify any information needing to be disputed. We filed an identity theft report with the Federal Trade Commission and complaints with law enforcement. For other clients, we returned $25,000 from a lost settlement, as well as saved almost $27,000 on another settlement. And as we highlight our great work, we do also want to share a concern. In solidarity with the DC Coalition Against Domestic Violence and the Victim Advocate Network, we note a need to comply with the Transparency Act of 2022, including identifying OVSJG's funding priorities that will enable the victim services community to better coordinate efforts to meet the needs of all victims of violence and maintain the highest quality of services for survivors. We greatly appreciate OVSJG and the work it does on behalf of DC residents needing access to justice and victims of crime and the exploited, and are honored to partner with them. We also look forward to seeing increased transparency in the budgeting process. And thank you, and I'm happy to answer any questions.
Thank you so much, Ms. Millar. Next, we will turn to Elizabeth Davis, Government Affairs Manager, Children's National Hospital.
Good afternoon, Chairperson Pinto and members of the committee. My name is Elizabeth Davis, and I am the Government Affairs Manager at Children's National Hospital. For over 150 years, Children's National has been an integral part of the healthcare safety net serving children and families in Washington, D.C. metropolitan region. Thank you for the opportunity to provide testimony regarding the FY 2023-2024 performance of the Office of Victim Services and Justice Grants. At Children's National, our Child and Adolescent Protection Center partners with OVSJG by providing trauma-specific medical and mental health care to District of Columbia children and youth survivors of maltreatment. Our Violence Intervention Program is another important OVSJG-funded program. Through these programs, our medical professionals and mental health clinicians work in an interdisciplinary manner to provide comprehensive care to children and youth exposed to violence. We recognize the value of collaboration and are committed to working closely with community partners to promote safe and stable relationships and environments for children and youth. We thank OVSJG for their continued support and partnership that allows us to work more collaboratively with victim service providers. For over 20 years, OVSJG has been an integral part of Children's National Child and Adolescent Protection Center program through grant funding for our sexual assault nurse examiners who provide acute forensic medical exams to the pediatric population. Since 1997, the grant has grown to support the full scope of trauma-specific medical and mental health services. Over the past fiscal year, we have continued to strengthen our relationships with stakeholders across the system. Most recently, we executed MOUs with the Safe Shores for the Youth Advocate Response, the DC Rape Crisis Center, and the Network of Victim Recovery DC. The MOU allows adults with developmental disabilities to continue to receive care at Children's National, to have an adult sexual assault advocate. For these patients, the care provided at Children's National is a familiar, more suitable medical setting for for their evaluation needs. In FY 23, we provided medical services for over 430 children, mental health screening for 188 children, and scheduled therapy with 71 unique child victims of maltreatment. Our pediatric sexual assault nurse examiners conducted 43 acute forensic medical evaluations for evidence collection. This work would not have been possible without funding support from OVSJG. We want to thank OVSJG for funding this important work at a level that allows us to meet the increased demand. The funding supported the hiring of a new clinical social worker whose contribution allowed CAPC to exceed our goal number of mental health intakes for the last quarter. We also plan to hire a patient care technician and an additional clinical social worker with OVSJG grant funds. With a more fully staffed outpatient clinic, we anticipate a continued increase in the number of patients and families we can serve. As we mentioned in last year's performance oversight testimony, Children's National continues to recognize the mental health needs of children who present with problematic sexual behaviors. We are happy to report that this past fiscal year, we received a federal grant to help address this issue and are working to enhance the MDT approach to youth with problematic sexual behavior. Our goal is to help community stakeholders change the way in which they respond to children and youth exhibiting problematic sexual behaviors. We look forward to working with OVSJG as we continue to expand our work in this area. Finally, we would like to thank OVSJG for the continued collaboration on our Youth Violence Intervention Program. Since 2021, our program has continued to identify and screen pediatric victims of community violence and provide mental, emotional, and behavioral support to help disrupt future cycles of violence. Recognizing the need for many of our patients to be connected with mental health services, our Youth Violence Intervention Program has made that a priority focus. Without support from OVSJG, we would not have been able to hire a second social worker to help us screen and connect more youth to services. We gratefully acknowledge the support of OVSJG and their strong commitment to connect children and youth experiencing sexual assault and physical assault to mental health services and resources. We look forward to continuing our collaboration and partnership with OVSG to serve district youth. Thank you for the opportunity to testify, and I'm happy to answer any questions.
Thank you so much. Penelope Spain, Chief Executive Officer, Open City Advocates.
Good afternoon. My name is Joshua Miller, and I'm the Research and Advocacy Director for Open City Advocates, as well as a Ward 4 resident. Due to the death of a family member yesterday, our CEO, Penelope Spain, is unable to be here, so I'll be delivering Open City Advocates testimony on her behalf. We provide legal representation and holistic advocacy to youth who have been committed to the DC Department of Youth Rehabilitation Services, including throughout their reentry from secure facilities. If our clients find themselves in the adult criminal legal system, we continue supporting them throughout their subsequent supervision, incarceration, and reentry. Open City Advocates also engages in systemic reform efforts and is a member of numerous coalitions and working groups dedicated to supporting returning citizens, including the DC Reentry Action Network, which OVSJG helped launch a few years ago. I'd like to start today by expressing our profound gratitude to the Office of Victim Services and Justice Grants for their steadfast support for Open City Advocates. In 2006, only 1 year after establishing our organization, OVSJG saw our potential and provided critical seed funding. At the time, OCA was still operating out of a closet without heat or air conditioning in a warehouse next to Marvin Gaye Park in Ward 7. 18 years later, Open City Advocates has assisted over 165 court-involved youth and, through impact litigation, successfully established the right to legal counsel for all children throughout their commitment to DYRS. OVSJG's steadfast support has allowed us to uplift the voices of youth returning from both juvenile and adult incarceration, ensuring that they have a voice in the services they receive. By advocating for carefully tailored reentry plans and through intensive community support, we have been able to cut recidivism by half compared to those who don't receive our intensive post-commitment representation, thereby preventing future incarceration and improving public safety. OVSJG's financial support is critical to the smooth and consistent operation of our program. The support of its staff, however, goes beyond the financial management of its grants. Our OVSJG program officer often brainstorms with us about new partnerships and provides ongoing feedback. In addition, we regularly receive support from our program officer on case-specific issues. For example, if we're struggling to find safe housing for a client, we can turn to our OVSJG contact to help make connections to government agencies or other grantees to meet the need. As a recipient of dozens of grants each year from public and private sources, I can attest that the programmatic support we receive from OVSJG is second to none. OVSJG's ability to provide strong financial oversight alongside programmatic support makes it a standout government office striking the perfect balance of efficiency and humanity. Over the years, the support we've received from OVSJG has enabled OCA to expand our services to reach more youth and make our city safer. Through the federal ARPA Flex funds, for instance, we've been able to provide direct assistance to our clients by providing them education and workforce development stipends, as well as transportation, groceries, and cell phone service, all of which are critical to supporting their education and employment goals. Lastly, OVSJG funding allows us to pay stipends to youth engaged in leadership development opportunities through the DC Juvenile Justice Advisory Group. Watching our young, homegrown youth leaders develop into the next generation of youth advocates and social justice reformers is one of the most fulfilling parts of our work. OVSJG makes that possible. The funds we receive from OVSJG support DC residents with the highest needs. Our clients struggle regularly with obtaining stable housing, vital documents, adequate mental health support, substance use and recovery support, and meaningful education and employment opportunities. Over the past few years, with ARPA funds provided by OVSJG, we have been able to make a huge impact in the lives of our clients who are returning from incarceration by providing substantial and meaningful financial support. Even such simple and cost-effective solutions make a huge difference for our clients' stability. OVSJG provides the robust funding for our juvenile and adult reentry support that engenders new and innovative solutions while also providing the critical continuity that transforms service providers like Open City Advocates into leading models of reentry support in the District of Columbia. On behalf of Open City Advocates, I would like to extend my gratitude to OVSJG for its continued support of and partnership in our work. Robust funding and programmatic support for juvenile and adult reentry services is exactly what the district needs right now. Thank you for your time and consideration.
Thank you very much, Mr. Miller, and please send my sincere apologies to Ms. Spain for the loss of her family member.
Thank you, I will.
Next, we will turn to Christina Jackson, Executive Director of Washington Council of Lawyers.
Thank you, Chair Pinto, for your leadership and to this committee for your support of the Access to Justice initiative. As you've heard all day long, vital services funded in FY23 and 24 would simply not be possible without the Council's consistent and unwavering championing of the programs that make it possible to offer and maintain high-quality legal services for residents in need. Washington Council of Lawyers brings a unique perspective to this hearing. While we do not provide direct legal services, we support, train, mentor, and foster a collaborative community among legal services attorneys and pro bono volunteers who serve DC residents in need of legal help to address critical life challenges. From our distinct vantage point, we understand how our network of legal and social service providers collaborate to advance justice and support our neighbors. One of the roles we play in this collaboration is our partnership with the DC Bar Foundation, the administrator of the initiative funds, in supporting grantee organizations and their staff. We facilitate trainings of eviction defense attorneys supported by the Civil Legal Counsel Projects Program and immigration lawyers whose organizations receive access to justice grants funding. Through our coordination of the eviction defense trainings for staff across 7 grantee organizations, we have seen how this unified program has strengthened the way legal services are provided to district residents. Recently, we expanded our partnership with the Bar Foundation by adding similar trainings for staff from 6 immigration grantees. Although new, we've already seen comparable success in cross-organizational collaboration and cooperation with this group. In addition to our targeted work with housing and immigration grantees, Washington Council of Lawyers offers wide-ranging professional skills development through our litigation skills series. Here, we recruit experienced and respected litigators from our community to offer courses in all aspects of litigation, ranging from mediation to legal writing. Access to Justice funding allows the DC Bar Foundation to provide scholarships to their grantees, ensuring their staff can attend focused, timely, and comprehensive skills trainings. Notably, these trainings are also offered to pro bono volunteers who often partner with legal services providers to serve DC residents in need of legal help. The foresight of the DC Bar Foundation in ensuring its grantees have access to this type of professional support that might otherwise be cost prohibitive is important. Through our unique role in supporting the work of initiative grantees and their staff, through our partnership with the DC Bar Foundation, we have seen grantees work to dramatically expand their community outreach, hone their ability to overcome extraordinary challenges, leverage their unique organizational strengths, and be more efficient in legal services delivery. Concrete examples of these efforts include the establishment of a coordinated entry point for litigants to access services, affirmative outreach to litigants about available legal support, and collaboration on policy and systemic advocacy. But what I've described is just a small part of the breadth of the initiative. As an organization that looks holistically at civil justice in DC, we are consistently struck by the singular and irreplaceable role the initiative plays in ensuring the district residents facing a wide range of civil justice problems have the legal help they need. Simply put, the initiative works. The funds support well-established legal services programs and allow the community to respond to new challenges through innovation and cooperation. In this way, the initiative ensures the district lives up to its responsibility to ensure low-income residents have legal help to address the most pressing needs they face, including housing, domestic violence, consumer debt, education, reentry, and much more, as you've heard from today. The initiative promotes stable housing, public safety and community resilience, economic opportunity, among the many other security systems for DC residents that you've heard about today. It does this recognizing that the consequences of going without competent legal representation can be long-term and reverberate across district neighborhoods and wards. Equally as important, though, the initiative helps keep highly qualified, experienced lawyers serving district residents through the Student Loan Repayment Assistance Program, or LRAP. LRAP is a key recruitment and retention tool for legal services employers. Scores of our members cite LRAP as a top reason they're able to continue as public interest lawyers in DC. We are grateful for the progress that we've made through the Access to Justice Initiative. While we know the legal needs in our community still far outpace our ability to meet them, the initiative is essential in advancing the priorities of a safe, stable, healthy, and economically vibrant community. Thank you for the opportunity to testify today about the value of the Access to Justice Initiative.
Thank you very much. Indira Hennard, Executive Director of DC Rape Crisis Center.
Good afternoon. Dear Chairwoman Pinto and fellow committee members, it is great to be with you all today. Thank you, Chairwoman Pinto, for your leadership and ongoing partnership. The DC Rape Crisis Center is dedicated to creating a world free from sexual violence. The center is the oldest rape crisis center in the country and the only rape crisis center in Washington, DC, that holds a local, national, and international footprint in the global sexual assault movement. The center was founded in 1972 and is celebrating over 50 years of providing services to survivors of sexual assault who represent the most vulnerable and marginalized survivors in Washington, DC and beyond. The strategies of the DC Rape Crisis Center employs an intersectional anti-oppression and community-based lens in how it approaches its work, both in its work with survivors of sexual assault and in its work to create accountable community responses. The DC Rape Crisis Center works at the intersection of freedom, justice, and liberation that provides a unique framework for serving disproportionately impacted survivors of sexual assault. Additionally, the DC Rape Crisis Center has created programs and services that have a direct response to racism and oppression. This is further reflected in not only the critical role that the center holds on the acute continuum of care for survivors of sexual assault, but the center's long-term strategic relationships as well. One of the DC Rape Crisis Center's long-term relationships is with the Office of Victim Services and Justice Grants. The center has been in partnership with OVSJG for close to 20 years. It is through this long-standing partnership that OVSJG has been a steady and unwavering partner in our mutual desire to provide unparalleled services to survivors of sexual assault in the district. While we know these are extremely challenging times, the DC Rape Crisis Center applauds OVSJG, the District of Columbia, and Mayor Bowser for the commitment to victim services that is reflected in the FY24 OVSJG budget. We appreciate the continued support in the district's investment for our community's most vulnerable population. The FY24 victim services budget reflects an overall 67% increase since FY19 in combined local and federal funds, and a 161% increase in local funds to support victim services. Further recognizing the challenges facing the community, we applaud the 21% increase in local funding support between FY23 and 24. While these historic investments provide sustainability regarding life-saving services in the district, we would like to highlight some critical items that are important to uplift and address in order to reflect a more equitable victim service community. First, we thank the district for continuing to evaluate the city's financial management system and wanting to pivot to a more streamlined system. However, the transition to that new financial management system DIF was challenging for some grantees, including the DC Rate Crisis Center. The timing of the launch of DIFs was not ideal, and the processing of invoices was challenging at times. We want to applaud Director Porter and her team with a special shout out to Interim Deputy Director Kelly Dillon, who also serves as our grant manager, for all of her support and guidance through the hiccups we experienced with the DIF system. Kelly did a masterful job of being responsive and helping to troubleshoot issues that arose. Additionally, Director Porter has been intentional in partnering with the victim service community and engaging in critical conversations to ensure that the system is equitable and is inclusion within the victim service community. In order for the victim service community to further stand in alignment with DC values, we must examine the ecosystem that is harming leaders of color and disproportionately impacting leaders of color to lead thriving, successful organizations. There has been a huge shift in the philanthropic landscape in the DMV, where foundations that used to fund direct service organizations have shifted their funding priorities, whereas some direct service organizations who used to get funded are no longer getting funded, and OVSJG is the primary funding source. For example, the Washington Area Women's Foundation commissioned a landscape report to address what is happening with Black women leaders across the public and nonprofit sectors. I'm going to leave the remaining of my testimony to submit to the record, but I just want to say that overall leaders of color are really challenged with getting funding to build up the capacity of their organizations, and the impact of this cannot be overstated. Leaders of color are constantly doing more with less, and as such, the health and well-being of leaders of color is at a point where it is leading to significant burnout and pushing many leaders of color to leave the sector entirely. It is important that we recognize the constant fight that leaders of color are doing around funding and the necessary resources that they're having to fight for in order to lead their organizations. And as we look towards the FY25 budget season, we look forward to working with Director Porter and her team, as well as your office, Chairwoman Pinto. Thank you for your time, and I'm happy to answer any questions.
Thank you very much, Sinard. Jody Ovka, Founder and Executive Director of Access Youth.
Good afternoon, Councilmember Pinto and members of the committee. I'm Jody Ovka, Executive Director of Access Youth. Thank you for the opportunity to appear today to testify regarding the performance of the Office of Victim Services and Justice Grants. Access Youth believes that children belong in classrooms, not courtrooms. Since 2009, OVSJG has been Access Youth's longest running partner in our work to keep vulnerable youth in school and out of the justice system. They serve a critical role in our community as the stewards of federal and local funds related to juvenile justice and delinquency prevention, and local initiatives focused on the prevention of truancy and chronic absenteeism. And I would like to give a special shout out to Deputy Director Tawana Stewart, who has been a tireless supporter of Access Youth from OVSJG in every way possible, and does an incredible job. Access Youth's mission is to empower vulnerable youth with the tools they need to stay in school, graduate on time, and avoid the justice system through mediation, restorative justice, and positive youth development. Since I founded Access in 2009, we have served over 10,000 students, and external evaluations continue to prove our impact, largely in part to OVSJG funding. Our truancy prevention and restorative justice in schools programs are embedded at 8 DCPS schools: Anacostia, Ballou, Eastern, and Woodson High Schools, and Johnson, Kramer, Hart, and Kelly Middle Schools. Access Youth's four-pronged model of student support meets students where they are, and equips them with tools they need to improve their attendance, behavior, and academic performance. Our full-time on-site program managers work to build relationships with students and families, provide opportunities for students, work with students to set up and meet specific individualized goals, and empower them to maintain accountability as they work to increase their attendance, improve their behavior, and their academic performance. Our Restorative Justice in Schools program, launched in 2011 at Ballou High School, has been supported by funding from OVSJG since then. This year, Access Youth will directly provide conflict resolution programming to nearly 450 students across our schools. Our team directly prevents and intervenes in student conflict through mediation as an alternative to punitive disciplinary approaches. It then provides ongoing education, programming, and support to these students for the remainder of the school year. And this can provide a 7-year continuum from 6th grade to 12th grade for many of our students. In addition, since 2012, following the passage of the Attendance Accountability Act, we have been a key partner to the District of Columbia Public Schools and OVSJG in their efforts to improve student attendance and reduce truancy and chronic absenteeism across the district. Thanks in large part to the funding we receive from OVSJG, as well as funding from some of the schools themselves. This year, we anticipate serving 800 students in our truancy prevention program at risk of chronic absenteeism this school year. Our program model is very simple. Every student receives support from our full-time on-site program managers who implement our 4-pronged model of student engagement. They provide students with the support they need to increase their attendance, develop the socio-emotional skills they need to avoid resuspension, and improve their academic performance. And our program works. In a multi-year comparative study conducted on the 3 years prior to COVID-19, we found students in our program, when compared to their peers who were not in our program, had an average of 18% lower unexcused absences, 10% higher ISA, and 7% higher promotion rates. And 98% of the students in our RJ program avoided suspension for their initial infractions, and 82% avoided suspension for the remainder of the school year. However, in the wake of the pandemic, nearly all the attendance barriers and behavior challenges students previously experienced have been heightened. Family resources, transportation challenges, safety, and school climate all have increased. Looking ahead, federal ESSER funds that help schools implement these efforts will expire. Therefore, we urge the district to increase OVSJG funding and its investments in solutions like ours that truly work. As the committee assesses OVSJG's performance and prepares to review their budget, we request that you recognize their vital efforts and accomplishments in delinquency prevention and reduction of absenteeism. And we urge the council to increase funding to OVSJG, DCPS, and partners like Access Youth, so we can turn the tide on chronic absenteeism in the District of Columbia. Without OVSJG's leadership, resources, and initiatives, thousands of students and over 1,000 served by Access Youth alone would lose the support they need to stay in school and out of the justice system. Thank you for the opportunity to testify today.
Thank you. Santos Amaya, public witness.
Hi, good afternoon. Can you hear me?
Yes.
Can you see my camera?
We can't see you, but that's up to you. If you want to take your camera off, it looks like something might be covering your screen, but if you want to just speak with the cover on, that's totally fine.
I would like to put the camera on, but I don't know if you can see me.
Yeah, we can't see you, unfortunately. Sometimes there's a slide at the top of the screen. But that's okay. You can go ahead. We can hear you well.
Okay. Good afternoon, Committee Chair Pinto and member of the committee. Thank you for the opportunity to testify today. My name is Santos Amaya. I'm a DOJ partially accredited representative and I'm immigration paralegal at Carecen. On behalf of Carecen, I'm here to express our gratitude for the funding and support that we received from the Office of Victim Service and Justice Grant. In my personal experience, I was unaccompanied minor when I arrived to the United States at 15 years old, and I was able to navigate the immigration system thanks to Carecen. Now, I'm doing the same for the migrants so they can have a stable life. Since 1981, Carecen mission has been to foster comprehensive development of the Latin community by providing direct services while promoting grassroots empowerment, civil engagement, and human rights advocacy. During the fiscal year of 2023 and 2024, the grant funding that we received from the Office of Victim Service and Justice Grants has allowed us to provide direct services to DC residents and immigrant survivors of crime in furtherance of our mission. Thanks to the support of the Consolidated Victim Service Grant, Carecen has been able to help undocumented crime survivors apply for U visas. Those migrants have cooperated with law enforcement after surviving serious crime, such as domestic violence, rape, child sexual abuse, and aggravated assault. For example, I had one client apply for a U visa after he was innocent victim of gun violence and cooperated with local police investigation into that crime. As an immigrant myself, I was grateful for the opportunity to help him navigate the immigration system, access holistic services, and understand his rights and seek justice in his case. In addition to helping immigrant crime survivors apply for U visa, Carecen has also helped our clients seek work authorization, obtaining permanent residency, naturalization, and submit family reunification petition on behalf of the family members. In fiscal year 2024, Carecen has hired a new pro bono coordinator who will help us to leverage our partnership with local law firms to expand our services to immigrant crime survivors in the community. Throughout this partnership, Carecen will provide trauma-informed legal services and refer to at least 60 new immigrant crime survivors. Additionally, we will educate at least 400 DC residents regarding crime survivors' rights. We look forward to ensure that those clients receive the immigrant legal services they need to one day regularize their status, remain in the United States, reunify with their families, and the support that Carecen has received from the Office of Victim Service and Justice Grant has been critical to our ongoing success in serving DC residents. But for every client that we accept, there are many more that we must turn away due to lack of capacity. On behalf of Carecen, I would like to also mention the important impact of access of the initiative, which was created by DC Council in fiscal year 2007 to provide public services to make civil legal services available to DC residents. Carecen is extremely grateful to the mayor and the DC Council for their long-standing support for the initiative, and in particular to this committee, who has championed it from the beginning. We hope that you will consider increasing the funding available for providing services to DC so that we can expand our programs and continue to support our clients for many years. Thank you.
Thank you very much for your testimony. That concludes our public witnesses today. I want to thank all of you on this panel and who have testified today. I think we heard a lot of very consistent messages about the excellent services that folks are providing to DC residents across the spectrum, with so many important needs that are continuing and sadly growing in many areas. And so we really, really appreciate the hard work that you all engage in every day and sharing your perspective, not only on the clients that you're serving, or if you are a client being served, but also on the role that OVSJG plays in dispersing those grants and empowering much of the funding for that work. So thank you very much to all of you for being here, your continued collaboration, and I look forward to seeing you all soon. We are now going to move on to our government witness, Director Jennifer Porter. Invite you to the table up here. For coming, and I see you have been joined by some of your team today. Will anybody else be assisting and answering questions today. No problem. Hi. Okay, great. Could you all then state your names for the record, and then I'll go ahead and swear all of you in. We can start with Director Porter.
Sure. So it'll be the two of us answering questions.
Okay. And what is your name and
John Nitz, AFO for Public Safety and Justice, supporting OVSJG and Director Porter.
Okay, wonderful. And you all are not answering questions.
They'll just be supporting me with.
Okay, great. So as you all know, it is the tradition of this committee to swear in all government witnesses appearing before it. So if I can ask you to raise your right hands. Do you swear or affirm under penalty of law that the testimony you're about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Great, thank you. Please take a seat. Now I'd like to invite you to make any opening statement you may have, Director.
Sure. Hey, good afternoon. My originally drafted statement says good morning, so I just wanted to emphatically share that for the record. Good afternoon, Chairwoman Pinto, other members of the committee in their absence, committee staff, and everyone who is joining us today, also virtually. I'm Jennifer L. Porter, and I have the honor of serving as the Director of the Office of Victim Services and Justice Grants, affectionately known as OVSJG. I'm proud to share today the accomplishments and performances of our agency during fiscal year 2023 and fiscal year 24 to date. The mission of OVSJG, as stated earlier, is to develop, fund, and coordinate programs that improve public safety, enhance the administration of justice, and create systems of care for crime victims, youth, and their families in the district. We do this in several ways. OVSJG funds community-based organizations, as well as district agencies that provide services for victims of crime, justice-involved individuals, and juveniles, funding prevention programs. As a state administering agency for 11 federal victim service and criminal justice and juvenile justice funding programs, OVSJG engages in planning and coordination with those agencies. We provide technical training and assistance to organizations and agencies who receive grant funding and provide these services. In addition to victim services, justice grants, and truancy reduction programs, OVSJG also operates the district's address confidentiality program, which provides a legal substitute address and mail forwarding for eligible DC residents to maintain the confidentiality of their actual address, and those being survivors of heinous crimes, including stalking and threat. We also operate the private security camera incentive program, which encourages residents, businesses, nonprofits, and religious institutions to install security camera systems on their property to join us in community as a part of maintaining justice. OVSJG also provides policymaking expertise, advice, and counsel to the mayor on the role of victims and offenders in the criminal justice system. We enhance the district's responses to trauma and evidence-based practices to respond to, intervene in, and prevent violence. Today, I'll share a few highlights of our performance. In May of 2023, OVSJG's hospital-based violence intervention program, affectionately known as our HVIPs, were awarded the Distinguished Justice Potter Stewart Award from the Council of Court Excellence. This is a really distinguished award, and it really was recognition for all of the outstanding contributions by our participating hospitals, participating community-based organizations, and the dynamic community liaisons who do the work of supporting survivors of some of the most heinous crimes. This award was a highlight for our team as well as our entire community for 23. In FY23, OVSJG launched our capacity building grants. This program was designed to break down some of the barriers that smaller grassroots organizations and newer grantees have historically had and challenges in obtaining funding. The design of this program was to connect these grantees with tools, training, and identify gap analysis to secure funding, to increase organizational capacity, and to continue to meet the needs of the communities that they serve. The opportunity was aimed to enhance the capabilities of those organizations and specifically designed to build capacity within our community, faith-based organizations to strengthen their operational and programmatic effectiveness. Benefits to participants include financial support tailored to each organization's specific needs, training, resources for organizational development, and access to a strong network of service providers and peers working together to collaborate and to participate in monthly capacity building trainings led by our expert training team. Grant funding. In FY23, OVSJG administered 132 awards to community-based organizations and government agencies, funding healing services for primary and secondary victims of all crime categories, training to technical assistance for community leaders and staff, and critical support for returning citizens and reentry serving organizations. As a state administering agent for 11 federal awards, OVSJG received a total of 8 federal awards in FY23, funded at $7.3 million. 5 of those federal awards were for justice grants and 3 were for victim services. In FY24, OVSJG has received a total of 7 federal awards, totaling at $7.5 million. 4 were for justice grants and 3 were for victim services. And just to note, these are multi-year awards. I shared a little bit earlier about our address confidentiality program, but we're really proud of this critical and solemn program. We were able to also make sure that we are expanding the knowledge of this resource, and we were proud to have a total of over 2,000 people receive training, education, and information about this program. 46 participants were accepted into the program, and we continue to provide this life-saving resource. The Private Security Camera Incentive Program. This program encourages residents to join our community funding model and being able to purchase private security cameras and be reimbursed for those through our rebate program to join our partner agency, MPD, and providing footage and information to help deter crime and assist law enforcement. In FY23, 714 rebates and voucher applications were approved. And since its inception, 11,854 rebates and vouchers have been approved. So we're really proud of this. Of note, in FY23, there was 6 arrests, made, in which video footage was extracted from a program participant. Those arrests made included 3 murder cases and 1 sexual assault case. So we're really proud and continuing to double down on those training and outreach efforts for the program. Our Juvenile Justice Advisory Group, affectionately known as the JJAG. Our JJAG spearheads the development and adoption of the district's application for our Title II federal funding. They play a critical role in helping to develop our 3-year plan for our delinquency prevention program. The JJAG advises the mayor and district governments on those awards and how we facilitate those awards. They have the important task of facilitating authentic youth engagement and obtaining input from youth with experience navigating the juvenile justice system. Through the years, they have provided technical advice and support, and they also play a critical role of maintaining our compliance monitoring with our Title II awards. In FY23, 2023, OVSJG made 8 awards advised by the JJAG, and the JJAG's funded compliance monitor and racial ethnic disparities coordinator conducted site visits for 11 of our sites, including our MPD police precincts and our DYRS facility. The compliance monitor also worked with agencies to streamline data collection and data verification. And happy to share that in the summary response of our compliance monitoring, it was deemed that the District of Columbia provided an effective system of monitoring, which designates that we can maintain 100% of our Title II funding. Supports for returning citizens. OVSJG made a grant awards to community-based organizations, and in FY23, over $5 million in ARPA Flex funding was awarded to support individuals who are in need of housing, transportation, vital documents, education, job training, and more. In addition to our Flex funds, OVSJG was able to enhance supports and services for justice-involved individuals. Domestic violence, housing, and services. OVSJG makes grant awards to community-based organizations to meet the need of victims, survivors, and their families. In FY23, OVSJG awarded over $10 million in ARPA funds to domestic violence service providers. And at the end of FY23, which she joined us, we were proud to celebrate the ribbon cutting of the DC Safe Space Crisis Shelter, the district's new 24/7 crisis shelter available for survivors. Trauma Response and Community Engagement Program, affectionately known as our TRECEP. As you know, this is one of our newer initiatives, but a powerful initiative that centers the needs of our community, but centers the modality that comes from our community and how they heal. This year in FY23, we were proud to expand beyond the Stoddard Terrace TRECEP to launch the second TRECEP site in historic Anacostia. This program continues to engage the Anacostia community in developing and in implementing community-defined healing priorities. And we're really proud of the initial outcomes of this program and our continued investment. Truancy reduction. In FY23, OVSJG's truancy reduction initiatives included Show Up, Stand Out, and our high school truancy reduction programs. Our program served over 70 schools, and last year, 3,700 students and families were offered services. 1,206 direct services were provided. Common supports for those students include tutoring, school uniforms, transportation support, and meeting basic needs. The high school truancy program provided intense long-term one-on-one mentoring and case management to students at risk of disconnection. This program works to remove barriers and increase opportunities to facilitate youth's re-engagement in school and to improve their attendance. For FY24, we anticipate engaging approximately 1,200 students. OVSJG was proud in 2023 to enhance our response and support performance improvement and effectiveness through our truancy reduction initiatives. As such, we continued and doubled down on our comprehensive oversight of these programs and initiatives and supported through training initiatives to our grantees to support in their meeting the needs of our students and families through high quality program delivery. Based on our current projections and grantee capacity for FY24, we are on track to serve approximately 1,290 students. And as of November 27th, there were 681 students engaged across our SUSO and high school program providers. Sexual Assault Victims' Rights Amendment Act implementation, effectively known as SAVR. We've got a lot of acronyms, so just humor us. In FY23, 3 community-based organizations, NVRDC, the Network for Victim Recovery of DC, the DC Rape Crisis Center, or DCRCC, and Safe Shores Child Advocacy Center were awarded grant funding to provide the expanded advocacy services codified under SAVR 2.0. For the entirety of FY '23, the program was up and running, providing 24/7 access to sexual assault victim advocates in hospital and community settings. In community settings, as well as at law enforcement and other district agency interviews. In FY '24, SAVR grantees, in partnership with the Sexual Assault Response Team, or the SART, developed and fully approved both the adult and youth SAVR working protocols to ensure a consistent quality of care, system coordination, and survivor-centered efficiency across all providers and services in the district. Finally, grantee support and engagement. In FY '22 and '23 to date, OVSJG staff have concentrated efforts to engage and support grantees. To this end, OVSJG staff hosted 23 training events on topics such as financial grant management and reporting, application preparation, and specialized training for sub-grantees. Each of our grant managers provide direct one-on-one technical assistance for grantees. And I'm just really proud of our efforts, including our capacity building programs, our offered trainings, as well as that third tier of technical assistance that our grant managers provide. In closing, I want to thank you, Chairwoman Pinto, for the opportunity to share our accomplishments. I want to thank the talented public servants who work at the Office of Victim Services and Justice Grants, who make this work possible, and the dozens of community-based organizations that work to heal district residents every day. I look forward to working with you in the committee, and I'm available to answer any of your questions.
Great. Well, thank you so much, Director Porter, to you and your team for all of the work throughout the year that is so critically important in serving district residents. Really appreciate it. And thank you for that testimony and walking through some of the big ticket items that you all are focused on. I want to start with just kind of zooming back about your vision for the agency and how you understand the relationship between victim services and justice grants in the various sectors that you deal with at OVSJG.
Sure. So you want to zoom back? Repeat the question for me. I want to make sure I get it right for you, Madam Chairwoman.
I want to get a sense of what your vision is for the agency and how you understand the relationship to be between the agency and the victim services and the justice grants.
Sure. So next month will be a year that I've been at the agency, and I've spent this first year really trying to lift the hood and understand our funding model, how we as a district have arrived to this funding model, and what the capacity is of the agency to implement that model with fidelity, but also with efficiency. And still doing that and still working with our community advocates, our nonprofits who we fund, as well as hearing from survivor and advocacy-led organizations, it's been enriching to really reflect on our model. My vision is to assure that the mission of this agency, that we can do that not just with the community at the center of what we do, but also to make sure that the community can feel that what we're doing is in their best interest. And so the first call from the community, and what we've also worked and endeavored to do, is to make sure that there's transparency. And so some of the efforts are to make sure that the model that we have, which also, to your point about victim services and justice grants, that it works. We have a community-centered model, which means that we allow for the community to prioritize what should be funded. We make sure that in spaces and places where our community believes that government should not be telling them how to heal, we make sure that we provide a space for the community to be able to tell us that. And with the open, consolidated RFA funding model that we have, we allow for the community to tell us not only how community would like to heal, but what they need to be able to provide those services. So in our model, it accounts for us to be able to say, not just how should this community heal from the amazing community-based organizations who some of them have been doing this work longer than I've been alive, to be able to reflect on that expertise, reflect on the trends that they are experiencing on the ground, and also some of the reporting and information from our sister agencies that we hear, that we're able to see that in the funding. Because OVSJG is the state administering agent for 11 federal programs, it's imperative that we make sure that those particularly designated items that should be funded from those particular models, that our community is reaching them. It's important that the agency is best equipped from a capacity standpoint, but also making sure that our community organizations have capacity to meet the needs. So the vision for the agency means making sure that we are positioning our community to get as much as possible in terms of funding eligibility, and in terms of getting that funding to the community. And so right now, we're at challenging times because the capacity of need that exists in our community is greater than the available funding. And so making sure that those critical organizations who may not be at capacity for being eligible for both federal and local funding, that we provide opportunities for capacity building, for technical assistance, and making sure that where there are emerging trends, emerging crime trends and emerging victimization trends, that we have the resilience as an agency to be able to meet those needs through our funding opportunities. I think finally, to answer your question about both sides, it's critical that we know that for both returning citizens and victims of crime, those immediate and acute needs, they have to look like the community. They have to look like and sound like and be culturally aware of where they are. And so we're continuing to not just identify opportunities from those federal awards, but also making sure that we're identifying opportunities locally to support increasing the capacity of those organizations.
Okay, well, thank you for that. And if you heard some of our public witness testimony today, there were so many folks who talked about their appreciation for OVSJG and the help in getting the funds that they need and their partnership with you all. There were also a number of witnesses who talked about their frustrations with the no cause termination clause. Sure. And so I want to discuss that with you and get a better understanding of what the current thinking is and what we can do about that. So many OVSJG grantees reported to us that a no-cause termination clause was introduced into grant language, that no negotiation was allowed, and that the grantees were forced to accept the term or go without the critical funding that they need. Does the agency plan to use these termination clauses in the coming years, and why do you believe they're necessary?
Sure. So thank you for the question, and just have talked with several of the grantees around their concerns around this language as well. One of the efforts in partnership with our general counsel and our attorney team when we started up this fiscal year was to make sure that there was transparency on all of the things that our grantees are beholden to in terms of district law, district policy, and district best practice. We requested in partnership with our attorney team that we look at all of our contracts, contract language, our awards, and any of our memorandums, just to make sure that where there are entities or opportunities that our grantees would be impacted or would be affected, that we would make sure that they would be aware. As I mentioned with you, and as I also shared with our grantees, that particular language is standard district practice. And we, with our council team, assured that that would be made aware through our grant agreement. What was shared and what was also shared with the grantees is that where there are extreme situations or where there are challenges, part of being in a grant or contract obligated relationship with the government is that where there are situations where the contract has to be terminated, that is something that our grantees are beholden to. And so in our effort, again, to make sure that they were aware, but also that OVSJG's contract stipulated, OVSJG's agreement stipulated what the time parameters of that would be. It was included.
Okay, so there are a couple of different issues that I'm hearing. The first is, it sounds like when you say transparency, we want grantees to know that this could happen.
Yes.
Is it OVSJG's position that you always had this authority?
Yes.
Okay, and what is the basis of that authority?
So as I shared in the testimony, the legal citation for this is, excuse me. And while I'm looking for this, I can just share and consult with our team what was shared. If there are, situational updates where the government has to perform a federally mandated act and they would have to terminate an award, my understanding is that that language came, the law or the regulation on the law came from that. So, and I can, thank you. Okay. Chapter 27 of DC, of our DC regulations. I'm sorry, I have it and I shared it
No,
with
that's
you,
okay.
but-
And I may have it too. I wanted to make sure we're thinking of the same one. So if it's chapter 27, 3700.
Yes.
Point 1, the contracting officer may terminate a contract for the convenience of the district in whole or in part if the contracting officer determines that the termination is in the best interest of the district.
Yes.
Okay. And so I read that to be for a contracting officer for a contract. Isn't that distinct from a grantee?
My understanding is that that is what the district uses to govern grants and contracts, and that grants can be treated as contracts as well. So where the basis of that policy comes from is that particular regulation.
So is that only in the case where funding has not yet been dispersed? I imagine it wouldn't be the agency, or is it the agency's position that if funding is dispersed and there's a federal emergency, that funding could be clawed back?
Sorry. Okay. So our grants, because our grants are cost reimbursable grants, and because our grantees incur costs prior to the reimbursement, there are special conditions where they can be awarded, or that they can actually apply to receive advances at any point, at any time that the government, again, deems in the best interest of the government, that can happen. And so again, with our legal team being able to look at that, we wanted to make sure that our grantees were actually aware of that.
Has there ever been a circumstance that you're aware of that due to some federal emergency, as you articulate, that a grant would have to be canceled? And that somebody challenged that cancellation on the basis of the contract language?
Not to my knowledge.
Okay. You said that this is consistent across district government. Are you aware of any other agencies that use similar language?
Yes.
Okay, and what are those agencies?
Let me get back to you on that, because I want to make sure I'm speaking in turn, but it is consistent with district practice.
Okay, we would appreciate that specific because that's what we were told by the agency, that this was consistent, and we have looked and we have not been able to find any other agencies that used this language. So
Okay.
if it does exist, we would really appreciate seeing it on the committee. So as I don't want to speak for all of them, but many of the grantees for years have been asking for multi-year contracts.
Yes.
And we continue to hear that we can't do that due to anti-deficiency and other issues. And so now it feels like we're going even farther away from what folks are asking for consistency in their funding model by saying this grant can be terminated at any time without cause. How can we give grantees assurances that their hiring and their disbursement of their own funds that they're expecting reimbursement for is going to be honored?
So I think there's a separate conversation around multi-year awards and assurances for current awards. I can speak to the multi-year award question, which I know that the agency has considered, and I know that, other agencies actually consider. Because our funding model exists, again, it's a community-based model. We have the community to apply to us and to let us know what they're going to be, what they would like to implement. That process has to happen. It actually starts in March. So we're gearing up now for our RFA process. We open up the RFA, and essentially, we employ a braided funding model. We know and we can estimate, we know what we have in terms of the federal multi-year awards. We can estimate based on what, has happened, in the past, or projections with federal partners and what is coming in terms of federal awards. But the local budget is determined by you all. And so, what has to happen is because of the anti-deficiency law, those local awards, we cannot make multi-year awards. But in terms of the federal funding that we have, because most of our funding for the agency comes from local dollars, we have the braided funding model, and we assure that we can meet the need that is coming from the request that's coming from the community, whether it be a split award from federal and local or just local funding. But because we, are working with you all and in partnership with the administration to understand what the local budget is, in terms of multi-year awards, that's the model that is honestly the most efficient at this point to make sure that we can get the funding out to the community.
And thank you for that. I more am using the multi-year award request as a juxtaposition to suggest people have been asking for multi-years. I hear you on why that may not be feasible right now. But then to go so far the other direction and say, not only can we not issue multi-year awards, but we can't even tell you with assurances that you're going to get the funding that was budgeted. You say that the budget is dependent on us, right? We passed the budget last summer for funding throughout the year to make sure that these grantees had access to these dollars. It was a big effort. It was a big push. We were reconciling a lot of proposed cuts. And that's the assurance that needs to be maintained throughout the year, that the law is going to be followed and the dollars out the door. I mean, in the example that you articulated of, there's a federal emergency, would you be open to changing the language to saying, in the event of a federal emergency like we had with COVID, then perhaps all contracts of the district would have to be reconsidered?
So, and my understanding of the regulations and the law, that is the case. So in terms of the inclusion in the grant award, that's the case. To take a step back, I describe our funding process as like landing on an aircraft carrier, because we put out our consolidated RFA. We start in March, looking at past performance of grantees, looking at any surplus that we have, looking at anything that's identified in terms of what you all are thinking about, anything earmarked. And then we already have the applications from the grantees before the budget is even determined. right? So we have to make sure that once that budget actually loads, for us to be able to implement these awards on October 1 or as close to October 1 as possible, that the process of notifying the grantees, getting the agreements signed and executed, being able to assure that the certifications and business licensing and all those things happen before we issue awards. There's a whole process that happens. So the way that we fund is open in a way that we can maximize getting the funding that we have out to the community. So while we don't know the award amount, my team is working in the background, really hard to make sure that the notices are updated, that we're contacting grantees, that we're getting all the required documentation. So you're right, there was a lot of work, but even in that case, we're holding to see, okay, how much do we actually have to push out, right? So is that clear?
Well, I hear you on the kind of complicated matrix of the funding model. I guess I still am unclear how we're going to give assurances to grantees who were awarded through the complicated process, are planning to receive a set amount of funds, determine their budget model for the year based off of that plan and contract, but are now being told for the first time that, in my view, is dissimilar from any other agency that we've seen. We can cancel this at any time for any reason. And I keep hearing you say, well, this was kind of always our authority or in the event of an emergency. But given the huge amount of consternation and panic this has caused with so many of the grantees who I know you and your team work with so closely throughout the year and care deeply about, is there any consideration? Can there be additional consideration to change the language or remove that clause?
I think the challenge is removing the clause does not remove the authority of the government to do that. And so again, we can talk about whether or not it's included in the language, but we're still beholden to it. And again, our effort and the efforts of our attorneys were to make sure that everything that we were beholden to, that we would be transparent about that. So I think, what's happening here is, and I can fully understand why this is something that is pretty much, what I was advised and what I understand is standard contract language would be alarming because it wasn't there initially. I'm not, I can understand that, but recognizing that as an effort of transparency, we just had a global pandemic, right? Nothing that anyone, predicted, but something that we all had to adjust to, and particularly in this community, had to really adjust to. And, we're grateful that there were opportunities, afforded for us to work in partnership to continue services. But again, my, understanding of the law is that they would still be beholden to this.
But if they're already beholden to it, what is the basis of that authority? Well, I have a couple questions on that. So let's start with there.
Sure.
If that's already the law, where is that law?
I think again, it's the chapter 27 to 37 of the DC regulations.
Okay. And so I would pose that it is an open question if there is a distinction between a contracting officer and a grantee. But even assuming that's all the case, then why is it just for transparency, or are there any additional plans or concerns that you have about being able to award the grantees as anticipated?
Why include it in the award? Why include it in the, repeat your question? I'm sorry. I'm trying to make sure.
No, that's okay. So you said that you want to be transparent. If you have the authority already, you want to make sure that the grantees know that.
Yes.
But I'm asking, are there any plans that OVSJG has to change the change these contracts or to change the amount that has been agreed upon to be awarded?
No.
There's no plan in place for this year. Okay. Well, I think that even that assurance will hopefully go a long way to some folks as well. I do still think there's room to think about the language. Would like to see if there are any other agencies that do this, or if we can consider more specific language to articulate in the event of, you know, as we call in the law, act of God, like a global pandemic, something that's so out there, to make sure that the district is covered. I still don't understand what our, as a district, legal liability or exposure would be for breaking a contract if your view is that we already have this authority, which is why I was asking the question of, has this been challenged in the past? Because then that would give me some insight to why the agency is trying to protect itself in this way. But because it seems like there hasn't been an issue before, the executive's position is you already have the authority. I still am not really seeing the benefit of including something that's causing so much consternation.
I understand.
Thank you. Okay, so in terms of grant administration, historically, OVSJG has not allowed no cost extensions, an extension of a project or budget period without additional cost from the sponsor to grantees who do not fully expend their funding in the awarded fiscal year. Some other agencies do allow for this. Are you considering reassessing this policy? And if not, what are other factors that are driving that decision?
Factors that drive whether or not we have no cost extensions for awards. So essentially the Anti-Deficiency Act. So because we have a braided funding model, I explained our timeline. We can't, you know, once the fiscal year ends, that's pretty much it. So we work again extensively with our grantees to make sure that we're providing technical assistance, training, support to make sure that they get those funds out the door. We want to make sure that district residents are served. And so, you know, the reality is in a 12-month performance period, our hope with our efforts and support that our grantees can be able to perform those projects.
Okay, thank you for clarifying that. So in terms of transparency, and I hear you on the clause issue, you want to be as transparent to grantees as possible. Some grantees have raised issues to the committee about a perceived lack of transparency with the funding model specifically and how those decisions are come about.
Okay.
Can you share with us on how you make those decisions and how the agency and grant managers have addressed those transparency concerns?
I need you to be a little more specific on the concerns because I don't want to just ramble on about, you know, our efforts for transparency, but I want to get to your question.
So I'm curious more specifically about the funding strategies and management of grants, how those funding models are developed, especially in a changing landscape, especially when they're changing year to year. What are some of the considerations or metrics that the agency makes to determine those funding levels?
Sure. So one of the decisions and one of the priorities is to make sure that we're continuing to fund existing programs. We want to make sure that district investments can be sustained, mostly to make sure that the efforts that we're continuing to build with the support of funding from taxpayer dollars, that it's able to be maintained, but also that survivors in the community have the ability to be able to access those services throughout the years. And ways that we do that is just to make sure that we do that through grant monitoring throughout the year, looking at organizations' capacity to be able to implement those funds. So as we're working, you know, we obligated 100% of our budget, making sure that when we get to quarter one, quarter two, where agencies need technical assistance or support to be able to push out those funds, that we're able to do that. And if there's not necessarily capacity for that, we're able to lean into support. I shared a little bit about the timing of our model. So we share the list of our funding our federal funding opportunities. And so the priorities to make sure that one, the district is making the best of our federal formula dollars, making sure that those organizations that have the capacity to be able to implement those specific projects that they're doing that, and working with our sister agencies, advocacy organizations to learn and to know a little bit more about emerging crime trends and emerging needs in the community. So working with our advocacy organizations, working with survivor communities who share priorities and feedback, and making sure that we're able to fund the most critical need.
Thank you for that. And as you analyze local versus federal dollars, what is your theory on the flexibility of those categories, especially as they relate to one another?
The flexibility of the categories of funding federal versus local. So it depends what we want to do, okay? So because we have a braided funding model, in terms of categories of what we can do, there are funding opportunities that specifically earmark funding for survivors of particular crimes. There are other funding models that are a little bit more flexible. Our local funds, you know, and you all sometimes have particular projects that you would like to earmark to see, and we have priorities that are set by the mayor and the administration. But in terms of what we can and can't do, it depends on what the community writes. We can't fund what the community doesn't write to us. And I think the beauty in that model is we get to see so much innovation and creativity. We get to see really culturally specific supports that government may not have thought about or created. And we get to sustain services in community, how community wants them. And so in terms of what we can and can't fund, I think some of the challenges that exist is, you know, right now, most of our funding is local. And so again, we have to wait. I think, you know, it was late summer when this year, just for various reasons, we make sure that in terms of the federal opportunities that we can, in our RFA, we, you know, list those categories and those the earmarked services that we can provide, hoping that we can sustain with the budget those existing grantees that exist in the community, and that will have an opportunity to fund, you know, even more.
Well, thank you for that. And I'm glad you mentioned the culturally specific opportunities that come, and that being a big part of what you all do and helping people with capacity building, especially for smaller organizations where the grant that they receive could be up to 90% of their annual budget. What is the breakdown between new organizations OVSJG is funding every year? And is that a specific consideration that you and your team are making when applications are coming in for existing grantees who have been kind of repeat players and maybe larger organizations versus new organizations that are coming up with some of these innovative strategies?
Sure. I think, you know, where there are opportunities for us to fund, you know, new awards, we do. We fund based on the project and based on, you know, what the community writes to us. So there are opportunities, I think, again, because of the community need, we prioritize existing funds, but our funding model is not exclusive to those. We're really proud that we have a community peer review model in our funding model. So we're able to hear from not just experts, but community members who help to weigh in on our funding decisions, but making sure, again, that we're looking at, you know, whether or not, you know, looking at the budgets that are submitted and making sure that district residents are able to be served by what is presented.
Okay, thank you.
Sure.
So as I'm trying to get a better sense of some of the considerations you make for the disbursements, in your pre-hearing questions, you state that the agency did not assign last year priority rankings to different types of victimization. but provided $10,241,000 to domestic violence housing grants, and none for LGBTQ housing specific organizations. Given the agency doesn't rank or prioritize kinds of victimization, how do you plan the budget and funding strategies throughout the year to make sure that we're addressing the varied and diverse needs of our victim population in DC?
Sure. So the caveat there is we have to fund what is applied, right? So when we say why we haven't prioritized a particular victimization or particular community, we can't fund what doesn't exist in the community if there's not a resource that exists. We can work with advocacy organizations. We have our capacity building organization that's encouraging organizations to pursue our funding, but it's not necessarily that we're saying we're not going to fund these services. We have to fund it where it exists. So we encourage all victim serving categories to apply. So, and as of FY23, FY24, all but 2 of the 67 victim serving applications that we received were funded or received increased funding. So we fund, what comes in.
Okay. And how do you see OVSJG's role as a funder for housing services in relation to other district agencies that provide housing services?
How do we see it in relation to other? Can you be a little more specific with your question?
Are you targeted in your coordination with DHCD or DCHA, DHS, other agencies that are working to provide housing options for DC residents, but also you are working with providers and grantees who do this work? And so is there a coordinated effort with that work?
So we have been in communication with our housing partners. One of the challenges, again, as a state administering agent, we are the agent who receives the formula funding for housing. DHS is also a state administering agent for a particular federal funding, but we make sure that those funds go out, but also housing is one of the number one requests and issues for survivors. And so as, leading, organization that's serving survivors, we provide that. But I do think that there are some areas of opportunity of growth in terms of coordinating with our sister agencies that are providing housing.
Okay, thank you. That's one of the concerns that I hear a lot about is the lack of housing options and for emergency housing, especially for domestic violence victims. And so hope we can continue that effort throughout the year and figuring out ways to scale and leverage the various resources we have for housing in the district, and make sure we're oaring in the same direction to increase that supply. So in terms of the hotline, the victim hotline is one of the most important resources that the agency offers. We have heard reports that callers who've called with matters relating to non-homicides have been discouraged from calling the hotline. How do you review your hotline policies and the efficacy of the number?
Sure. So thank you for that question. And we fielded some questions from council members about this. Our hotline does not, it is a triage service. They are connecting people to the very resources that we fund and otherwise. And I think just even the concept that the idea that folks will be turned away from the hotline is really unfortunate. I do know that in some of the follow-up that we heard, we did do a site visit this year with our hotline, and I honestly believe that there is potentially a conflation of services because our hotline, our trained providers who are as well a grantee, they triage survivors. They also take calls from individuals who are supporting survivors. So obviously, we would, with great concern, would like to get to the bottom of those concerns. But I honestly don't believe that that is the hotline, that those calls were made to the hotline.
How many staff do you have answering the hotline?
So that's the thing. We have a community funded model. So our hotline is actually funded to a grantee who trains. They provide 24/7 technical assistance to their hotline workers. They provide monthly, more than monthly training to the call takers on emerging crime trends. They also work on a monthly basis to check in with our grantees and other partners who provide services to assure that they know about census and bed counts to make sure that they're triaging folks where the capacity exists. The Office of Victim Services and Justice Grants, we are grant makers. And so we do not implement the hotline. We fund the hotline. And so in the same way that we fund housing, that we fund mental health services, we fund that as an entity. The importance of the hotline is where, as a funder, OVSJG cannot be in the position of prioritizing, hey, you're calling us, so we're going to send you to preferred grantee number one. We fund the hotline, which is able to triage folks based on capacity, based on their need. And they also have, some really cool technology that helps their providers to be safe and confidential, being able to provide security measures so that survivors who are calling are actually safe.
How much is the grant for the hotline?
Sure, let me get that. So it is $852,294.
Okay. And I don't mean to only pick on the hotline, but to what extent is OVSJG overseeing or auditing grantees after awards have been awarded?
Sure. So we have a robust grant monitoring process. We check in with our grantees quarterly in terms of their performance. They report to us their outcomes for each quarter. Some of our grantees actually invoice quarterly. Some of them invoice more frequently, but they provide performance reports. Our skilled grant managers check in with them in terms of any not meeting any benchmarks for the quarter and any capacity and technical assistance that they need.
Okay. Well, I'll just lift up again then some of the issues to keep in mind with next time those check-ins happen. Or we've heard about long wait times or people not being connected to services. And I think something like a hotline is so important as it might be someone's only interaction with the government where they finally decided to make a call. And so making sure that those call takers are really steeped in the vast array of resources that we have here to be able to share with folks.
Sure. And we're confident that they're doing that.
So I want to ask you about mortgage payments. This has come up from a number of grantees.
Yeah.
And whether the agency can permit community-based organizations to use local funds to make mortgage payments. Since local funding can be used for, quote, mortgages and recouping payments from possible future sales, why has OVSJG found that this policy is a, quote, liability and, quote, not in the best interest of taxpayers or within OVSJG's mission?
Sure. So first, as I shared, our braided funding model, we sort of cascade to the most restrictive funding source because, again, at the end of the day, we want to make sure that we get as much funding to go out. The challenge with mortgage payments is that Mortgages are assets that are secured through a process. For me to get a mortgage, I have to confirm that I have a plan to be able to pay it. And so we want to make sure that those commitments and those plans are not being OVSJG's, our mission is to make sure that we're funding the existing need. And so the challenge with mortgage payments is that is a payment for an asset that essentially persists beyond the grant period. And so because of that, OVSJG really has the onus to be in relationship beyond that commitment. So if I'm paying the mortgage of an organization, that begets the need of a covenant. If district taxpayers have paid for your building, we should own the building. Not we should own it, but we have a stake in the future liabilities as well as the future purposes and intents of that. And so with our capacity and where we are, and again, with the priority to make sure that the most funding is possible, we make payments for rent, we make payments for rental properties. But in terms of mortgage, we want to make sure that taxpayer dollars that are spent, that they're spent for services, current services within those program years.
Thank you for that viewpoint. So last year, the committee funded a VPART coordinator, specifically to coordinate services around hate crimes. What is the status of implementing this coordinator?
So it is my understanding that the organization has been funded and the coordinator has been hired.
Okay, that's good news. So let's actually talk about staffing a little bit.
And it's not, I want to just clarify that it's funded, but it's implemented at the Office on LGBTQ Affairs where the VPART is.
Right. Okay. We had heard that there was some confusion initially about implementing the coordinator position, and so wanted to make sure that was resolved. But it's your understanding that the person has been hired out of the Office of LGBTQ Affairs?
Correct.
Okay, great. So how many FTEs does OVSJG have and how many vacancies do you have?
Sure. We have 22 FTEs and 3 vacancies.
Can you walk us through what some of those FTE positions are?
Yes. Senior Grants Management Specialist, Admin Officer, Program Coordinator, and Staff Assistant. I'm sorry, that's 4. I apologize.
Sorry, what was that last part?
That was 4. I apologize.
Oh, okay. Okay. And sorry, just one more confirmation on the VPART coordinator.
Sure.
Do you know what organization that person was hired from?
I can follow up with the Office of LGBTQ Affairs and get that for you.
Okay, thank you so much. We'd really appreciate that. We haven't been able to get that information. Great. Okay, so private security camera incentive program. First of all, congratulations on funding the 1,807 cameras. OVSJG reported that 769 vouchers and rebates were awarded in FY 2024. Can you tell me how many of those applications were for vouchers and how many were for rebates?
Sure, 1 second. While I'm finding this, I'll take the time while I'm flipping through the pages to give a shout out to our program coordinator, who works tirelessly as our champion of this program to really meet the needs of the community with this. We're really proud of this because it really is, again, a community model that allows for our residents to be able to work with us. Okay, thank you. Let me get back to you because I have the total number of rebates and vouchers. I know that our voucher program is significantly less than the rebates, but let me get back to you on that.
Okay.
I have the security camera report, but I want to let me
Okay,
circle back.
understood, no
with you.
problem.
Okay.
So in the pre-hearing questions, you noted that in fiscal year 2023, MPD used footage captured by private cameras 22 times. How does that compare to last year? And has the agency considered tracking whether or when a program recipient directly contacts MPD? I'm so surprised by that number, by how often I hear just anecdotally people telling me about their footage that they're calling MPD to coordinate. And so trying to understand if there's an underreporting or how we can make sure that people aren't just viewing their own footage, but that they're actually sharing it with law enforcement.
Great question. Give me 1 second. So to clarify, our response is that there were 22 requests that resulted in successful extraction for footage by MPD. So for a specific crime. So there are requests that MPD makes, but one, the community has to respond to them. They actually have to surrender the footage. The footage actually has to be viable to make that successful extraction. So there are a couple of steps in that process, and we're the 22. There's usually around no more than 5 a month that are actually successful extractions. But in terms of MPD's request and folks in the program, that can be greater. I also shared that this is specifically for folks in the program. So you can have a security camera and MPD can actually make a request for that or subpoena that footage. You don't have to be a participant in the rebate program to have that. But this is just specifically those who are participating in the rebate program and those requests that have been made of them.
Okay, thank you so much. I appreciate that distinction. That may be one of the reasons for the lapse. And then just to make sure I understand you correctly, are you saying those are the requests that MPD affirmatively asks for, but would that not capture people who did receive the rebate, who have the camera, but they proactively share the information with the police?
That's a good question. Let me clarify that. I think the distinction I'm making is, and I think that's one of the distinctions that's really important when we promote the program, when folks have concerns around like government voyeurism or things like that. This is a program where MPD, DC government does not have access to the footage. We have to request it. And the reality is MPD can request anyone's footage, whether they're in the program or not. So we make sure that we make that distinction. You could be like on the metro and recording IG Live on your phone. If a crime happened, MPD may subpoena you, right? Program or not. And so we are tracking the metrics of those who have participated in this program and the successful extraction of that to make sure that, one, folks know the efficacy of the intervention, but also to encourage folks to participate in ways that they are comfortable with.
Thank you. I would appreciate a follow-up on that. I think that will be important, as you said, to highlight the program, but also figure out how we can make it even more successful. So I'm really very worried about our truancy numbers in the district. How is OVSJG measuring the success of the truancy reduction programs that you all are supporting? And how have the programs that you've funded impacted truancy rates to date?
How have the programs that we funded impacted truancy rates to date? Well, I can share that with SUSO being a entry-level model where we identify young people who have been identified as at risk for truancy. We meet them where their needs, their identified needs are. And so one of the challenges, honestly, Madam Chairwoman, is that there are so many multi-layered contributions to truancy. But our model is one that, because it is opt-in, because it is, a non-mandatory program, the outcomes that we're seeing are resulting in that one-on-one mentoring, one-on-one identifying of needs, and being able to support young people. I am not in terms of the success of the program, with us being a first touch program, we are able to partner with other agencies to provide those wraparound services that are needed.
But as you're providing those services, are you measuring levels of truancy going up or down, and how that compares to the overall population versus the students that you're working with? What are some of those?
So we're looking at in-seat attendance. We're looking at access to some of the services that are requested in the needs assessment, because we know that while there are multi-layers of factors that contribute to truancy, we know that those can be proxies to why young people are not attending school. And I apologize for not having the metrics in front of me, but I can definitely get those back to you in terms of what we're measuring for success.
And if this is something that you need to get back to us on as well, that's all right. But have you found that the students who have been exposed to SUSO have increased their in-seat attendance?
Yes.
Okay.
And again, there's, when we look at, varied factors that would impact their in-seat attendance, but we've gotten really positive feedback.
And how many schools are being served through SUSO?
26.
And is that's down from 72 schools in fiscal year 2023?
Yes.
What is that decrease due to?
Decrease in funding of the program.
Okay. And so are those considerations, how do you decide which schools to go to?
So we work with our educational partners. We work with DCPS and OSSI to identify, we look at the in-seat attendance rate, and we look at the truancy rates of those schools, looking at their capacity to be able to implement a first touch program. And also this year, and new to the program, looking more at their capacity to not just support programs that engage the families, as well as those wraparound supports, but that there's capacity in the school to be able to support the SUSO, the community-based organization working with them.
Mm-hmm. Okay. Well, thank you for that, and hopefully we can get some more information from you all afterwards. I'm going to turn to my colleague at large, Councilmember Christina Henderson, who's also a member of the committee, for a 15-minute round.
Thank you, Chair Pinto, and good afternoon. Sorry, it took me a moment because I was like, it's been a day. I have been listening throughout the day to some of the public witness testimony and the things that have come up. So I just want to ask a couple of follow-up questions if I could. I've also looked at the pre-hearing responses that you all submitted to the committee. And so I want to start talking about grants that you all disperse out. So, last year we heard from several providers who overextended their budgets and had some cash flow issues because grants were not dispersed timely. And so I'm curious, what was your overall grant lapse rate for FY23?
Sure. Mm-hmm.
Yeah, so at the end of the year, there was approximately about $3 million that lapsed
Okay.
for all funds. Now, some of those funds are non-lapsing. We include in that the truancy, and then also in that, because it is part of subsidies and transfers, the private security. So if we back those out, it's less than $3 million.
Okay.
And so it's lapsed in the way, I guess, the fact, since they are reimbursable grants, it's not that we're taking any money back. It's just the fact that they weren't able to invoice for whatever was out there. And so we didn't have to make any disbursements, and that's why that money's still remaining.
Okay. I saw in the pre-hearing responses that Office of Victim Services received 4 federal grants in FY23 that were not obligated. These grants would have provided resources to youth involved in the criminal justice system. One grant provided some funding to the OAG, some funds to the OCME, residential substance abuse treatment, totaled over it's totaled a little over $1 million, was what, 1.1 million. I never like to leave federal money on the table, ever. So what happened here? Why didn't we get those dollars out?
Sure.
If that's your program staff person, she can
Sure.
Oh, okay. Never mind.
So my understanding is that so for the federal awards, especially the multi-year awards, we don't have to obligate those awards, and particularly for the awards that are going to our sister agencies.
Okay.
If they are currently funded on previous year's awards for those awards, we may not obligate those awards based on what their need is.
Okay. But at a certain point, we're going to have to report to the federal government our spending. What I don't want us to happen, what I've seen happen in some other agencies, is we then receive a notice from the feds around a notice of concern around our underspending of federal grants. So, and I'd imagine for some of these things like residential substance abuse treatment, as the chair of the health committee, we could have, I can certainly ask DBH that question, but I feel like this funding could have been used in that regard. So have you all, what is the communication with these particular agencies around the transferring of funds or not transferring of funds? And then also for these particular buckets, how long do we have to use that money? If it is a multi-year grant?
So how long do we have to use? So most of the federal awards are multi-year awards. Yeah. Okay. So for the residential substance abuse treatment award specifically, that goes to DOC, the Department of Corrections.
Interesting.
Yes.
Okay.
So we have spoken with DOC, and we're in partnership with them to actually obligate and expend that award this year.
For FY24.
For FY24.
Okay. All right. What about OCME?
Yeah. So the federal formula awards that we get, particularly for Coverdell for OCME, those awards are formula awards that we pull down from the federal government. Because they are multi-year awards, we award based on the need that is identified from the agency. So we do have an agreement in place to implement the FY24 Coverdell Award for OCME.
I'm sorry, can you explain a little bit about?
Sorry. Office of the Chief Medical Examiner.
No. What type of, I couldn't hear you. What type of award you were saying?
Sorry.
I think you said the covered or?
Coverdell is the title
Coverdell,
of the particular funding that is particularly used, that is the interagency fund that goes to the Office of the Chief Medical Examiner. So if they don't identify the need for those funds, we are able to carry over in a multi-year award based on their spend plan for the next year.
Okay. But OCME is aware that these funds are available to them.
Absolutely.
Okay.
Every
As I'm
single
just
one of our
saying,
sister agencies.
because, you know, the sister agencies will come to us and they'll say, I need money. And I want to say, well, you might have some funds available.
So
now I know that this is obviously funds for a very specific purpose.
right.
However, comma, for the local dollars that they receive, if they are if they're using federal funds, they could perhaps use the local dollars for something else. If they're not supplanting. I know there's specific rules about that, but
Correct. And it's really important for us as a state administering agents to make sure that those funds, and we do monitor those funds just like our community funds,
Okay.
to make sure that they're used specifically for the need that exists. Unlike local funds, those federal funds, and you know, sometimes I use this as a point of advocacy for DC statehood, but those formula funds are earmarked specifically for the formula that exists for the district.
Yeah.
And we make sure that we are, as a state administering agent, we're pulling down those funds to be able to meet the need that exists, that is articulated by the sister agency. So they are absolutely aware and in their spend plan and the opportunities specifically for those earmarked areas, that they are aware and they're actually able to spend those funds on the awards based on where their need is.
Okay. So in the FY24 federal awards chart grant list that you all provided, you list there are a few that says that the grant is quote unquote in process. What is the process for successfully awarding some of those funds?
Sure. So the federal award cycle is not on our cycle. So we receive the awards, or we receive notification of the award. We have already issued, at this point, letters of intent to fund for our sister agency partners. So we work through our AFO on the interagency award process. And then once the award is made, we will continue to monitor and we'll monitor activities. The difference and the nuance in our interagency awards, particularly our multi-year awards, is we want to make sure that where those previous year's awards based on, again, the need identified, that we're able to make sure that those awards where they need to, the following year awards can pick up where the need exists.
Okay. Okay. I want to change gears a little bit. So I've been on this crusade of getting our government to release the reports that are overdue or lost in purgatory. And so last year I sent multiple letters to the city administrator about certain reports that were overdue or missing that I feel like are informative to the work that we're doing. The Domestic Violence Fatality Review Committee's 2023 report is not yet published. You note in your pre-hearing responses that the report was submitted to the executive for review in May of 2023. Do you have any update about the expected publication of this report?
It's been published. At least yes, it's been published.
Okay. Is it possible that someone can send a link of where we can find it?
Sure.
Okay, great. Wonderful. Okay. Forensic nurse examiners. I understand that OVSJG worked with the DC Federation of Nurse Examiners to raise salaries for forensic nurse examiners to help in the process of recruiting and retaining nurses for this particular area. So I want to thank you so much for that. The wage increase took effect in Q4 of 2022. Do you know, I guess, percentage wise, what was the salary increase? Was it via grant or contract?
We can get back to you on whether it was contract or award.
Okay. In that follow-up, I was just wondering what the term of it, or so term in terms of what is the length of the grant or contract. And then when that does expire, how you all plan to continue to maintain those levels of the salaries in the future. And then in my final 4 minutes, I want to talk a little bit about hospital-based violence interruption programs. Again, I sit on the Judiciary Committee, but it's my overlay of chairing the Committee on Health, which I think this is super important. So the NEAR Act required that hospital-based violence interruption programs be in all of our hospitals in the district. Whose responsibility is ensuring that that is actually happening?
So it's a two-way responsibility. The hospitals have to be open and have capacity and support from the Office of Victim Services to be able to implement them. Some of them, in partnership with community-based organizations. And the Office of Victim Services has a commitment to fund them.
Okay. Have we met 100% participation?
Yes. We're aware that there's a new hospital coming on board in FY24, and we're working to assure that there'll be, a commitment to seeing the standing up of that project as well.
Okay. So you pre-asked my question. I was going to ask about Cedar Hill in terms of you all having conversations with UHS to make sure that hospital-based violence interruption is part of that hospital on day one, especially with the closure of United Medical Center, which already has that program in place. Do the grant agreements require that the VIs be present in emergency rooms 24/7, or are some of them only there, say, during the daytime hours or vice versa?
So my understanding is that varies from program based on their structure and capacity, but I can get back to you on that.
Okay. Beyond the grant award, what other additional supports do you all provide for HVI programs?
Sure. So we actually fund a HVIPS coordinator that regularly convenes the violence interventionist that support the initiative, hospital leadership. They prioritize issues or system level issues that they may all be impacted by, or identifying solutions that the individual programs can synergize around to support each other. They also identify areas of need and support in terms of coordination. They're individual hospitals, they're entities, they're not government entities. And so where there are areas for coordination, data sharing, and support, they work actually pretty collaboratively to support each other. That position we fund works to liaise with other sister government agencies where there are needs for supports, trainings, as well as identifying resource gaps, and also helping to support the monitoring and evaluation of the HVIPs.
Okay. In terms of allowable costs under this particular grant, is it mostly personnel?
Let me get back to you on the specifics of what it is. Each program will write what their, just like the rest of our funding model, what their need is within the model, the HVIPS model. But let me look to see what the priority costs are for you.
So there's a reason to the question. Two parts. So one, what we have heard from other violence interrupters, maybe not in the hospital-based setting, one of the primary asks that they have is around salaries so that the VIs don't have to have multiple jobs and can actually focus on the work. So it's not a part-time endeavor, but it is actually their career path for this season of life. And so I think that's why it's important to kind of understand what the breakdown is of how the programs are sort of spending their monies. The other is that continuing education and trainings are also important too, in order for folks to get up to speed on best practices and other things. And so just wanted to make sure that funding allowed for that to take place as well.
So that the coordinator position that we fund, they actually coordinate monthly trainings for each of the community violence interventionists that work on HVIPs. Actually, and I say this, I say this very successfully because the way in which they work together is really commendable. So I don't see training as a gap. I will like flag and caution. One of the challenges that we have, and one of the opportunities that we have with the community funded model is we allow for our community-based organizations to determine what the salaries for their staff are. Where there are caps or where there are gaps, the community is able to let us know what they need for their leadership, for their staff. So OVSJG does not have any restrictions on any salaries for any of our programs. We allow for the programs to determine that. It allows for them to be competitive where they need to be, but it also allows for the communities to account for any capacity or limitations that they have to be able to scale their programs for success. So while I can't speak to other VI programs, I can say that the budgets that the HVIPS teams submit to us, we work to fund what, at their request.
Okay, great. I'm over my time. Thank you so much. Thanks.
Thank you very much, Councilmember Henderson. All right, Director Porter, just a couple more questions from me, and thank you very much for you and your team being here and your patience. I want to follow up on something Councilmember Henderson asked about with the Domestic Violence Fatality Review Board report. We also have been unable to find it, and on the website, every year's report is listed, but this year's report is not listed. It stops after 2022. So if the report is done, just a reminder to make sure that it is published on the website, and if you could send that to the committee, and we'd be sure to get it to all the members.
So you will. Okay. So the report, I'm told the report is available on LIMS. But we'll make sure through our partners in OPLA that you all get copies.
Okay. And for your website, for OVSJG's site.
Yes.
Okay, great. Thank you so much.
Sure.
Okay, so budget question. In your pre-hearing responses, you stated that all but $139,804 of victim services local grant funds have been allocated for the fiscal year 2024 budget. However, in the spreadsheet that was included, it looks like almost $4 million is still available in the victim services grants line item. Can you help us understand this discrepancy?
Sure.
Yeah, a lot of that is basically timing. If you look at the reports, you'll see I ran them as of the end of December to give you a full picture of 3 full months. What has happened since then is a lot of those have been awarded and sent out to the grantees. So that's where we're at right now. It's just, this happens every year when we look at the current year. It's basically a timing issue of the fact that the money has not gotten into those buckets that you're looking for it. And instead it's in the process of getting there.
Okay, so it's a more accurate number to say everything has been allocated except for 139,000.
Yeah, I think that's an accurate number.
Okay.
Yes. I mean, not having in front of me, I think that's a fair answer.
Got it. Okay, thank you for that.
You're
for that
welcome.
clarification. So domestic violence is an issue that is very important to me and the committee and is a growing challenge in the district. And one of the things that continues to come up from people who are doing this work and in this space is that we need to be doing a better job of preventing it before it happens. And in the pre-hearing questions, we asked what OVSJG was doing to prevent violence in general. And the agency's response, it indicated that as a victim-oriented agency, you dealt with post-violence, not prevention. In an October hearing before this committee with the city administrator and deputy mayor for public safety, we discussed complaints from advocates in the DV space that OVSJG does not spend anything on DV prevention. We saw in your pre-hearing responses a $30 million allocation in grant funds aimed at increasing safety and lessening harm, specifically around victim-centered services, housing programs, patient-centered approaches, treatment, and so on. But these don't sound like prevention of domestic violence. They sound like victim-based services, which are extremely important, but categorically different from efforts aimed to prevent violence before it happens. So does OVSJG fund prevention efforts of violence? And if so, where can we find these?
So yes, we do we do fund prevention. I think some of this there's a little bit of semantics here, or just a little bit of, we're kind of talking past each other. We believe, and based on, best practices in the field, that treating victims and survivors is prevention. And so while we are the state administering agent for funding sources that fund victim services, that is still considered prevention. We also do fund primary prevention efforts. One of the things to clarify is that I think while the Office of Victim Services, our mission is to really make sure that we're funding healing in the community. Healing does come through prevention. And so that number categorically is included in prevention. Now, and I heard some of the questions around primary prevention. One of the grants that we fund is actually Men Who Can Stop Rape, which is a prevention education program that we actually fund exclusively for primary prevention. But also, Chairwoman Pinto, we fund what we receive, right? And so whereas the agency that is the SAA, State Administrative Agent, that pulls down those discrete victim services funding, we would prioritize our braided funding model for services that directly impact survivors. But we don't have an exclusion. And as I shared, we fund prevention services. We have the opportunity to fund prevention services because DC Health is the state administering agent for prevention, for many other things. They also pull down federal prevention support, and I don't quote me, but I'm pretty sure they have about $3 million that they fund out to community-based organizations for prevention services. We want to make sure that we're meeting the community's need. So there's not a prohibition of us, but there's a priority because our role is to make sure that we're serving victims, and we know that prevention is a way to do that.
Okay, well, thank you for that confirmation and clarity. We'll echo. I appreciate that and the continued work that you and your team have done throughout the course of the last year. Will continue to do, especially in this budget coming up, and the very, very real needs that our residents have in the district in this space and that are relying on this funding. So thank you. I want to give you an opportunity if you have anything you want to add to the record before we conclude.
Sure. Just want to acknowledge all of our amazing grantees who came and testified today, in particular the survivors and survivor-led organizations. I just want to take the moment to acknowledge you. You are the center of our thoughts and all of the work of our team. And just want to thank everybody for coming out, and just thank Mayor Bowser for her continued investment and support in the agency and in our leadership, and looking forward to working with you all. There are several different models of funding models across the government, and myself and my team, we're really proud of our model. It's not perfect, but we have to work together to make sure that it works. And so making sure that our grantees have what they need, but also making sure that we're holding them accountable to getting the services out to the community. We can grow, and we'll continue to endeavor to find more efficient ways. And we need you all's partnership. And just want to encourage you all, reach out. If you have any questions, let us know, and we'll be following up with you about the follow-up questions.
Great. Thank you so much, Director Porter, to you and your team. The time is now 4:36 p.m. on the same day that we began. I want to thank my wonderful team as well for all of your efforts. And on behalf of the entire committee, thank you all to everyone who testified today and Director Porter.